We'll take from that side. Yes. Applications and order for tunes, please don't mention, just hand over this. Applications and order for tunes. The other matters will hear. Mr. Mukherjee, you are coming. There was some chance that it would not be taken up.
No, Lord, this was a new type of matter, Lord. I was first miscellaneous appeal.
Order for T1 and application handover. The others, please wait. We'll just take up these. Yes, please.
Is there order for T1 only, but my urgency?
No. Our system is whenever the file comes, it's given in the list. Yes. Handover.
My lord, we can leave our my lord Justice Uday Kumar. I'm mentioning a matter. This was in sitting in Port Blair bench. My lord, with Justice Ajay Mukherjee has passed an order regarding diversion of land. Against that, they went up.
This is a review.
No, my lord.
Remand
This is a contempt.
Contempt.
And is already assigned by lordship.
Please hand over. I'll ascertain with Justice Mukherjee when, as per his convenience. এটা স্লিপটা নিয়ে নিন, একটু আলাদা করে রাখবেন, আমার পিএ কে পাঠিয়ে দেবেন এটা।
This is assignment by
এটা পিএ কে পাঠিয়ে দেবেন, বুঝেছেন?
One more thing, my lord. There is a supplementary affidavit.
When the matter is taken up, file it, give a copy to the other side, and
the supplementary affidavit be tagged with this, because the Port Blair bench department said they'll send soft copy here. So
we cannot do it right now here sitting in this bench.
Because a different bench.
Yes.
We'll come back.
To mention a matter for extension of interim order.
Yes.
My lord, the rejection for paper book has to be made. It was mentioned earlier. File is probably on the way.
For to be mentioned. Yes. To be mentioned. Take.
Permitted to mention one matter for short hearing, my lord. Your lordship directed that.
Hearing matters, we are not taking up this matter. We cannot.
Directed.
No, we directed all the. No. Yes.
Take a track.
Sorry, Ms. Mithuna.
But I think my lord assigned first appeal matter, my lord.
Hearing we are not taking up right now. Yes. What is the matter? No.
May I have your
No.
May I have your lordship's kind leave to mention this concerns the shop in the Oberoi Grand Hotel, your lordship.
What are you mentioning? An
My
application?
only mention is for considering the stay application.
Application
hearing,
is hand over.
And your lordship, the contempt application which I have filed upon.
Applications you hand over.
Grateful, your lordship.
Application hand over.
Become infructuous.
To be mentioned then.
So may I be permitted to mention two matters for inclusion in the list?
What are the matters? Application?
First appeal.
No.
Lordship, may I be permitted to
application or order for turn or what?
I want a leave to file an appeal without certified copy.
You have a normal copy?
Yes, I have applied in the month of December 2024.
Against which court?
Against. I have to check.
See the district at the top of the memo, left hand side.
Nodia.
Nodia
district.
Yes, leave is granted. Leave is in certificate.
Mention it's a matter at the determination of Honorable Justice Division Bench.
Justice Shen, what is the urgency?
Next date is fixed on 17th March 2025, and on that day the department has been asked to show cause why the suit will not be dismissed.
Your suit?
Yes, my lord. Because we have not.
Hand it over. I will see when we can take up as soon as possible. We'll fix a day for these matters. Hand over.
But I will write here, it's a determination of showman.
Yes, please indicate that. To indicate করে এইগুলো একটু আলাদা করে রাখবেন তো, পরে একটা 2-3টে হলে মেনশন করে এই সপ্তাহে হয় পরশু না তার পরের দিন এটা দিয়ে দেবে, এগুলো প্রথমে দিয়ে দেবে। Application? Yes.
My lord, inclusion in the list for hearing.
No. Call on the list.
Number 1.
My lord, I appear on behalf of the respondent. Why? My lord, I am for the appellant petitioner, my lord. This application is at my instance, my lord. The affidavit of service, my lord, of the
What is the application for?
There was a direction, my lord, for filing the affidavit of assets and liabilities, my lord. I'm praying for an extension of time, my lord, to file that.
On 21st of March 2020.
My lord, in the meantime, my lord, may I just confirm, my lord, whatever your lordship has directed me to pay, I've already paid. No payment is, my lord,
21st of March 2024, my lord, the liberty was given to file the affidavit of assets and liabilities, my lord.
What is the delay? Reason for the delay?
But certain documents could not be, my lord, gathered, my lord. In the meantime, my lord, there was, my lord, some medical issues with my client also, my lord. He was, my lord.
You have filed your opposition.
Yes, my lord. My affidavit of assets also, my lord.
No, opposition, my lord. The assets and liabilities. His assets and, my lord,
Oh,
affidavit.
no question of
My
asset.
application for
Right. So you have filed your affidavit of asset and your application of this is there.
Yes, my lord.
So now you ought to file your opposition also.
My lord, only, my lord, my affidavit, my lord, my affidavit of assets and liabilities. My lord.
Opposition you have filed.
My lord, the opposition also, my lord.
How soon can you should be ready with that? If you have filed the extension application, unless you are ready with
2 weeks, my lord, I'll file.
no question of 2 weeks. You have to file it by tomorrow. If you have filed an application for extension, show your bona fides. No, then we are rejecting the application.
My lord, kindly,
We'll hear it
kindly,
without your
my lord,
affidavit.
kindly
We'll
consider,
draw
my lord,
adverse
my lord,
inference.
kindly considers, my lord, one aspect, my lord. There was initially an
When
order
were you directed?
directed, my lord, some
When?
time back, my lord, some
What is the date?
21st of 31st of March. My lord,
Why should
21st
you-
of March, my lord, was the direction.
21st of March.
2024, my lord.
No question of an extension in any way.
My lord, kindly
We'll
consider.
draw adverse inference and
My lord,
believe him.
my lord, kindly considers only one aspect, my lord. My lord, initially there was a direction for me, my lord, paying, my lord, 50,000. I've complied with that.
You have not done a favor to anybody.
My lord, no, my lord. My lord, the order of this honorable court, my lord, I've
You
complied with
are
everything.
consistently avoiding the contesting this
No,
alimony.
certainly not, my lord.
Give another 50,000 then, and that will be the price for your grant of extension. 1 year back you were directed. You are not paying. You have paid 50,000. That's enough.
My lord, there was, my lord, subsequently your lordship, my lord, directed me to pay 1 lakh. That, my lord, even that.
Total what amount have you paid?
Only that one lakh 50.
My lord, 1 lakh, my lord, I've paid, my lord, pursuant to.
When
your
did you
lordship,
pay 1 lakh? Because of your delay.
My
No
lord,
other.
kindly, my lord, takes up, my lord, paragraph number
When
9
when
of-
did you direct?
My lord, 9th of February 2025, the appeal was, my lord, taken up. My lord, there was a direction of your lordship, my lord, to pay 1 lakh, my lord. I've paid, my lord.
You have to file both the opposition and the extension and the affidavit in affidavit of asset by the end of this week. That's the last chance we are giving you. If you fail, you're gone.
My
The
lord,
present application.
My lord, one more week. My lord,
No.
My lord,
No.
My lord, kindly consider.
No.
My lord, 11th of February
No.
2025. My lord,
No.
paid.
No. 1 year have already lapsed. Can 3 of
And my
2025?
lord, one more, my lord, 3, my lord. My lord, my lord, speaking on my client's, my lord, instruction. My lord, my client's once, my lord, the matter, my lord, may, my lord, go for mediation. Since, my lord, already, my lord.
You're agreeable to mediation?
Lord, this is the first time, my lord, they have come up with this.
Take instruction. In the meantime, we'll dispose of this application, but this happens.
Only one thing, kindly dispose it of. My lord, let them, my lord, give one address where I can find their advocate on record and the client. My lord, every time I have to serve, I have to give them 3 notices. 3, my lord, these 3 clients to the 3 different addresses, and their advocate on record doesn't receive notice. I have to send him by post.
Who is your advocate on record? You.
But let them give
Why
one
are you not
address.
receiving notices?
That chance, your lordship, I didn't have such factual in.
Why are you not taking the notices?
I-
You will pay 50,000 more to your client.
My lord, kindly.
That is the cost you have to pay. That's as in lieu of cost of this.
Notice.
Utterly recalcitrant client. Utterly. Your advocate on record is not receiving notices because he doesn't have instruction. What do you think the court to be? You can dupe anybody. You're not paying alimony. We'll grant exemplary alimony against you and go up and challenge that. And we'll give full reasons for that. And you have to file your opposition and assets by the end of this week. Otherwise, you will proceed without those. Learned Counsel, the CAN 3 of 2025 has been filed for extension of time for filing affidavit of assets and liabilities by the husband. Pushed up at the time of moving the application, Learned Counsel for the husband also points out that he seeks an extension of time to file the opposition to the alimony application as well. Push up, next para, we find from the records that the husband had been directed to file such opposition and affidavit of asset long back, that is on March 21, 2024, about 1 year back. Pushed up, it is not at all credible that the husband could not obtain the documents required for filing such affidavit of assets for the long period of 1 year. Push up, next para. Hence, otherwise the husband has not made out a case for grant of any extension of time, and ideally, comma, the court should proceed without such affidavit of asset. Full stop. Next para. Moreover, comma, it is pointed out by learned counsel for the uh, respondent wife that the learned advocate on record appearing for the husband has been refusing service of even notices. Full stop. Next para. No satisfactory explanation in that regard can be furnished by the learned advocate on record for the husband who is present in court today, comma, led by Mr. Banerjee. Full stop. Next para. As such, comma, it is clearly evident that the husband is deliberately avoiding the disposal of the alimony application and to disclose his income. Full stop. Hence, comma, we direct. It is also brought to our notice that already an amount of rupees 1,50,000 has been paid by the husband to the wife, comma, in lieu of ad hoc payments pursuant to directions of court. Full stop. Next para. Such directions, comma, it is also clear, comma, were passed from time to time since the husband has been avoiding the final disposal of the alimony application. Full stop. However, comma, in order to give the husband a last opportunity to produce his affidavit of assets and opposition, comma, the time for filing affidavit of assets by the appellant husband and the affidavit, the time for filing affidavit of asset and affidavit in opposition by the appellant husband is extended for the last time till March 17, 2025. Full stop. Next para. Such extension is subject to cost of rupees 10,000 being paid within that period by the appellant husband to the respondent wife through the latter apostrophes learned advocate on record. Full stop. Next para. In the event such affidavit of assets of the husband and or his opposition is not affirmed by March 17, 2025, and or the above costs are not paid to the respondent, comma, the court shall proceed to decide the alimony application by construing that there is no traverse to the allegations made in the alimony application and the affidavit of asset filed by the respondent wife. Full stop. Next para. In the event such affidavit of asset and or opposition is filed by the husband within the said period and the costs are paid, comma, the time for filing affidavit in reply, filing a composite affidavit in reply by the respondent wife, comma, dealing with the allegations made in the husband's affidavit of asset and the opposition is extended till March 24, 2025. Full stop. The application for alimony shall be listed on March 26, 2025. Full stop. Next para. Can 3 of 2025 is disposed of in the light of the above observations. Affidavit of service filed today be kept on record.
But only thing, my lord, is in the meantime, I'll let them, my lord, take a instruction on the mediation part, my lord.
Acha, learned counsel, arekta line add kore, learned counsel for the husband also submits that the husband is agreeable to go for mediation. Full stop. The learned counsel for the respondent wife shall take instructions as to whether the respondent wife is also agreeable to the same and to intimate the court about such intention or otherwise on the returnable date.
Right.
But this does not absolve you from filing these things.
No, certainly.
Yes.
Would I beg to appear for the respondent number 1, 2, 4, and 5?
Others have been served.
I've been served, but yesterday night I took out the
Track
track
report.
report and it found the service has been affected. If you lordship grant me time, so in the meantime I can file the same.
Today you can file the affidavit.
Yes.
They have been served.
Yes.
Yes. Move the matter. একটা প্রথমে লিখে নাও তো on the prayer of learned counsel for the appellants, comma, the appellants are directed to file their affidavit of service during the course of the day, full stop. It is intimated by learned counsel for the appellants that the other respondents apart from the appearing respondent numbers 1, 2, 4, and 5 have been served, comma, as evidenced by the postal track reports. Yes.
My lord, at the outset, my lord, I appear for the respondent number 1, 2, 4, and 5. My lord,
Yes.
they are moving their injunction application. My lord,
Substitution.
Substitution.
Yes.
If your lordship takes up the application,
This can 3, yes.
Can 3 of
It is within time, Mr. Rai. They have made appropriate prayers.
তো allow হয়ে গেছিল তো। The deed of 37 days, your lordship will find died of
37 days after 90 days.
after 90 days, so setting aside abatement.
So
Not
only
condemnation
setting
of
is only setting, not condemnation of. Yes, what do you say? The present application bearing can 3 of 2022 has been filed for substitution of the heirs and legal representatives of the petitioner is the appellant. You have said petitioner number 8.
Yes.
Of the appellant number 8, namely Anarul Sheikh. After setting aside abatement, pushed up, there is a delay of about 37 days in preferring the application after the expiry of the statutory 90 days for preferring substitution applications. Pushed up. Upon hearing learned counsel for the parties, we find that the application is otherwise in time and sufficient explanation has been given for the delay in filing the application after the expiry of 90 days. Pushed up. Accordingly, can 3 of 2022 is allowed, thereby directing the heirs and legal representatives of the deceased appellant number 8, Anarul Sheikh, to be, as mentioned in paragraph number 2 of the application, to be impleaded as substituted appellants in place and stead of the said deceased. Pushed up, the necessary consequential corrections to the memorandum of appeal and the other pending applications, if any, shall be carried out by the learned advocate on record for the appellant during the course of the day. Mr. Shanal, during the course of the day, both other application and memo. So no address to cost. Yes. What about?
No,
Oh, you have to serve notice on the substituted.
yes, that I have done.
Oh, you are for the
I
appellant.
am for the appellant.
So you are representing.
And so for the other application is for this can 5 of 2024. This is also a wrong impression while filed for substitution or other rule. I am
So can 5 you are rejecting as infractious?
I am withdrawing the same because
Very well. Can 5 of 2024 was initially filed for substitution of the heirs and legal
8.
representatives of the self-same appellant number 8, whose substitution has been directed to be effected by the previous order, full stop. Accordingly, on the prayer of learned counsel for the appellants to petitioners, can 5 of 2024 is dismissed as withdrawn without any orders to cost.
this is the application for injunction.
What is the appeal against?
The suit for partition suit dismissed on the ground of non-general necessary parties. There is no defense taken. Certain persons' names are featuring in the record of rights, on basis of which, my lord, the court below is of the opinion that those persons should be made as party. Without deciding, my lord, what interest they have at all have any interest over the property or not.
In the written statement, they have not.
They have never taken that point, defect of parties.
General point of non-maintainability.
Yes. So this is the point.
What is the injunction sought?
Not to disturb my position because the plaintiff suit for partition and the plaintiff.
How do you know you are in possession? Any finding in the
Yes,
court, any
well,
injunction in the court?
There is no dispute over the
Trial court, you are enjoying injunction.
Trial court, my lord, no.
Do not find.
No. একটা ইয়ে করেছিল অ্যাপ্লিকেশন করা হয়েছিল
May I use an affidavit? 1 week's time, my lord, I'll come.
Yes, we are hearing him for ad interim. We will definitely grant you if you want.
No, ইয়ে নেই
Injunction বোধহয় নেই।
বোধহয় নেই That's right.
How do you know you are in possession?
Well, the trial court judgment degree, my lord, it appears, my lord, the
Show that. Prima facie at least show.
Yes.
Only possession, injunction only regarding possession has been asked.
No, position and also for not to
You
transfer.
have not asked for that. In your application, it's not there.
No.
Restraining from interfering with or
With the
disturbing peaceful possession only. You have to show possession.
আছে না if you lost your
Which page? Internal?
No, my lord, that is number 70. If you lost, you can turn to internal page 8.
Yes. There's a previous suit.
Previous suit between the parties, and where it was held, my lord, that the suit received decreed expertise with cost, even without the cost. Plaintiff's title 8 share in the entire suit joth is hereby declared, even if I are hereby rested from interfering in the peaceful position of the
You are the plaintiff there.
I am the plaintiff there.
So why a separate suit?
Because at that point of time, the declaration for injunction in certain properties are there. Subsequently, my lord, this particular suit was filed on the ground, my lord. Is already pointed out, defendants did not prefer any degree for declaring order number 4, such and such, to be not binding upon them by a counterclaim in the written statement. According to us, my lord, previously suit was effected, it was filed, and there is a declaration regarding our share in the property in question.
That no partition was sought there.
No partition was sought for.
That degree still stands.
According to us, that degree stand. Trial court did not avert regarding the legality and validity and binding effect of that degree.
Prima facie case is there, Mr. Banerjee. We are granting injunction regarding possession. Parties to maintain status quo as regards possession. But we'll record this.
Yes, ma'am.
Ad interim.
Ad interim, and my lord will give me an opportunity.
Yes,
to file.
how soon can you file?
2 weeks.
The present appeal has been preferred against the dismissal of the partition suit filed by the plaintiff's appellants. Pushed up next parallel, counsel for the appellants argues that it is recorded in the impugned judgment of the learned trial judge that in a previous title suit bearing title suit number 394 of 1970 filed by the plaintiffs, a decree was passed inter alia restraining permanently the defendant numbers 1 to 5 therein within bracket defendants in the present suit bracket close from interfering with the peaceful possession of the plaintiffs, which according to the appellants, is still subsisting. Full stop. Hence, there is prima facie proof of possession of the plaintiffs in respect of the suit property. Full stop. Next para, learned counsel for the respondent disputes the contentions of the appellants and seeks to use an affidavit in opposition to the injunction application. Full stop. Next para.
Injunction was there. I find it.
Ad interim was there.
Yes.
Possession.
Position.
Learned counsel for the appellant further
Parties
submit.
to maintain status quo. Here is the order.
No, keep it with you. We also find from the documents sought to be relied on by the appellants that there was a subsisting status quo order during pendency of the suit in the trial court. Hence, we are prima facie satisfied that an ad interim order in respect of the possession of the property ought to be granted. Accordingly, the parties shall maintain status quo with regard to possession of the suit property till disposal of the present injunction application. Injunction application has been renumbered.
It is, yes. 1 of 2019 subject to action.
Accordingly, the respondents shall file their affidavit in opposition to can 1 of 2019 within bracket old number can 9962 of 2019 bracket closed within a fortnight from date. Full stop. Reply if any shall be filed within a week thereafter. The application shall be listed for hearing on April 9, 2025.
May I deposit the other cost and other thing for preparation of the
Let the application be disposed.
I am for the respondent number 1 to 5 and 8 to 15.
The rest have been served, Mr. Ghosh?
Yes.
Other respondents?
Yes.
You have filed your service?
Earlier also.
Earlier filed? Yes.
Can application number 2, one is for stay. For injunction. Also can 2, the application for addition of part. The plaintiffs are the appellant. Before passing of the decree, preliminary decree, the plaintiff number 1, the opposite.
You have challenged a preliminary partition decree?
Before passing of the preliminary decree, I am frankly speaking that he died. Death report was given, but plaintiff should have taken steps for substitution instead of that simply. And the suit was decreed on the following day, 28th of November 2019. Therefore, my lord, this appeal has been preferred by the years.
If the death happens after the hearing is concluded, Mr. Ghosh, then.
It appears from the judgment that as if
On the same day, argument concluded and argument has been finished. But from the judgment,
That is something we'll decide in the appeal, but addition of party is a right.
Yes.
Yes, Mr. Rai, what do you say to that? Addition of party is the only, because after conclusion of hearing.
Yes, my lord, 2 and 3, both 2 and 3 can 2, 3, and 4. 4, my lord, during after passing of the degree, and
All of them died.
2 only, my lord. Number 2 can 2 and can 3. These are, my lord, same.
These are similar.
Similar.
In both cases, death occurred after the hearing was concluded.
Before.
After the hearing was concluded and the
That is
preliminary
one,
degree
my lord,
was passed.
That is 3.
That is can 3 or appellant 3?
Can 3.
You are mixing up, Mr. Ghosh. Can 2 is for death of appellant 3.
Can 2 is death of appellant. Can 2 is death
Who
of,
died after conclusion of hearing and before passing the preliminary degree?
Yes. Can 2 is not 3. This is not before preliminary degree he died.
But after the hearing was concluded.
After the hearing was concluded.
You are not sure on that.
I do not know, my lord, because it appears from the judgment itself as if
The heirs were, why were the heirs not implemented?
in the court below.
In the court below, the suit is still pending.
But I know-
Did you point out to them
Lord,
the
it was
death?
pointed out, no, we are the appellant. We should have done it.
You are defendants there.
Yes, now we are in plaintiff.
Plaintiffs.
You are challenging the preliminary degree.
Yes.
Achha. The shares were not according to your prayer.
My
Then it has, the suit has abated. What would be the effect? If you allow it here, then it will percolate down.
Lord, your lordship, kindly see this.
You have to give explanation for that.
It is, if it is, my lord, again.
My lord,
If they-
nothing explained in the application. My lord, why this?
In the suit, the suit has by now abated.
Yes. But Lord, in spite of Lord that notice brought to the court, no substitution was allowed. We should have taken steps for substitution.
Very well. Since they were not implemented there,
But they have been implemented in the memo of appeal, but
obviously. And regarding can 3, that is for appellant number 1, that also you intimated, but they were not substituted. You intimated, did you file an application for substitution?
that is my difficulty.
Intimated, what is the meaning of
I do not
intimation
know,
to
Lord,
court?
it appears from the record that it was intimated. But
Court learned.
yes.
If you intimated us today that 2 persons have died, what would you do without an application for substitution?
No, after conclusion, it
Then the suit abated, Mr. Ghosh.
My lord, appellant number 1 expired on 25th October 2019. Can 3?
no, that is all right. That is with leave. We have sought for leave. There is no difficulty.
And whatever appellant number 3?
Appellant number 3 expired on 9th March 2017.
Yes.
Long before.
We hope
my lord.
after the suit.
Long
We
before-
hope at least after filing of the suit. Or before filing of the suit even.
No, after filing
Lord,
out.
before passing of the preliminary.
When was the preliminary degree passed?
28th November 2019. So, my lord, so
died
far
on
as appellant number 3 is concerned, my lord, died long ago. My lord, before 2 years, at least 2 years before the, not 2 years, 1.5 years before the degree, preliminary degree is passed.
Appellant 1, we can appreciate, yes, it was within 90 days before that the preliminary degree was passed and all. And this is not the final degree. If it is a final degree, then abatement we could be
After
considered.
preliminary degree, there was no difficulty.
Have to give you explanation for the delay.
No, my lord, no explanation, only the expired. They are the following paragraph 6. Kindly come to my lord, can 2.
No, since you are saying and Mr. Ghosh is not opposing, it must be that.
Here, paragraph 9, Lord, kindly see.
Acha, fine.
Two.
Today to which? Number 3.
Reporting, that means, what is reporting? If you are a defendant, order 22 to 10A, we could consider.
It has been drafted in this manner, Lord, I have
No,
seen.
no, then
I have seen. Partition should not.
we'll record that addition of party in the at this stage would might percolate down to the suit and absolve you of the explanation for the delay. We'll grant you leave to file supplementary affidavit to this explaining the delay. This is regarding can 2 and can 3
Can 3 can
since
be done.
only within a month from the before a month from the passing of, but you did not file any, but the time for filing application was not over. Can 3 will be more lenient, will allow it, Mr. Rai. And
Can-
what about leave, this leave application, can 4?
Can 4 Mulad,
While we are at it, let us also hear about that.
after judgment was passed,
Died.
died before preferring appeal. Therefore, Mulad leaves also.
So we'll start from can 4, the easiest one.
Yes.
Mr. Rai, we are allowing can 4 and can 3, can 2 supplementary affidavit, and we can direct you to file opposition if you want. Or need not, I mean, if they explain. Can 4 of 2020 is an application for leave to present the appeal by the heirs of late Khaitu, comma, the appellant number 6, comma, who was one of the plaintiffs in the court below, but died after passing of the impugned preliminary decree of partition. Full stop, next para. Upon perusal of the application, comma, we find that the same is in form. Full stop, accordingly, can 4 of 2020 is allowed on contest, comma, thereby granting leave to the heirs and legal representatives of the deceased appellant number 6, comma, one of the plaintiffs in the court below, comma, to present the instant appeal. Full stop. The department shall carry out the necessary corrections in that regard to the memorandum of appeal by incorporating the names of the said heirs and legal representatives of the deceased in the memorandum of appeal. Full stop. Next para. Can 3 of 2020 is an application for addition of party upon the death of one Isarul Haq, comma, who has been impleaded as appellant number 1 herein and was a plaintiff in the court below. Full stop. It transpires that the demise took place on October 25, 2019, whereas the preliminary decree was passed on November 28, 2019. Full stop. As such, comma, the period for filing a substitution application had not expired before the impugned decree was passed. Full stop. Accordingly, since the application is otherwise informed, comma, can 3 of 2020 is allowed, comma, thereby directing addition of the heirs and legal representatives of late Isarul Haq, comma, who was one of the plaintiffs in the court below, as parties to the as appellants to the present appeal. Full stop. Next para. Can 2 of 2020 is an application for addition of party upon the death of one Saidul Haq, comma, impleaded as appellant number 3 herein, comma, who was a plaintiff in the court below. Full stop. It appears from the amendments in the application itself that the death of the said late Saidul Haq occurred on March 9, 2017, and as such, comma, on the date of passing of the impugned decree, preliminary decree of partition, that is November 28, 2019, comma, the time limit for filing a substitution application had long expired. Full stop. Next para. However, comma, since an addition of the said of the heirs of the said deceased in the present appeal might percolate down to the pending partition suit, comma, we are of the opinion that although courts are lenient in impleading heirs of deceased persons in a partition suit, comma, some explanation ought to have been furnished for the huge delay of about 2 years in filing the present application. Full stop. Accordingly, the appellants are granted leave to file a supplementary affidavit explaining the delay in preferring can 2 of 2020 within a fortnight from date. Full stop. An advance copy of the same shall be served on the learned advocate for the respondent. Full stop. The can 2 of 2020 along with the other pending along with can 1 of 2020 shall be listed under the same heading on April 8, 2025. April 8th.
I have one application can 5.
What is can 5?
Can 5 and I applied for an order of injunction against the respondent numbers 46 and 47. After the preliminary degree is passed.
You are for which respondents?
I am for 1 to 5 and 8 to 15.
And 46 and 47, you are against.
I am playing injunction against 46 and 47. Now, my lord, the application for injunction, my lord, can one was pending, filed by Mr. Ghosh's client, not to put the degree into final for final degree, not to put the preliminary degree for final degree. Well, this application was pending since there is no order on this application in this appeal. Now, my lord, the respondent number 46 and 47, those who are my lord, opposite party number 42 and 43 in the application, my lord, started construction. My lord, in spite of my lord, repeated request not to make any construction, and my lord, the complaint made.
Mr. Rai, can we file that, grant that injunction, because this appeal is still not in form? We were wondering
But
about
my lord,
that.
they are merely constructing, my lord.
My instruction is that there is an old boundary wall.
You are not supposed to espouse their cause.
No.
46 and 47. Very well. Can 5 of 2025 is an application filed by the respondent numbers 1 to 5 and 8 to 15, alleging that respondent numbers 46 and 47 in the appeal are making construction over a portion of the joint over a portion of the suit property, comma, by choosing a prime location and also in contravention of the rights of the other co-sharers, comma, since the property is as yet joint. Full stop. Next para, having found the petitioners in Can 5 of 2025 to have made out a strong prima facie case, comma, we hereby restrain the respondent numbers 46 and 47 in the appeal from making any construction and or changing the nature and character of the suit property in any manner during pendency of Can 5 of 2025. Full stop. The petitioners in Can 5 of 2025 shall serve copies of the application on the respondent numbers 46 and 47, indicating that the application shall be listed next on April 8, 2025 and file an affidavit of service till on the returnable date. যেটা ইনজাংশন গ্রান্ট করলাম till disposal of the application করে দাও, বলেছি বোধহয় till disposal of Can 5. Thank you, Mr. Ghosh. We are putting it on the same date so that we can again. Yes. Thank you.
Application for restoration. The last occasion on 26th of February, my lord asked me to file supplementary affidavit explaining the delay.
Yes.
Sent the copy, but while from the postal track report it appears that item on hold, addressee absent, intimation served.
That is good service.
For the postal, the first application for restoration is concerned, my lord, those have been served, my lord. This is other
Oh, this supplementary affidavit could not. We will treat that as good service. So what is it? File that supplementary.
The supplementary affidavit.
Why two? Two judges' copies. What is the explanation, Mr. Mahatma?
I was taking proper steps, but during COVID pandemic, my lord, after June 22, 2021, my lord, the client could not contact regularly with the advocate. Therefore, my lord, when on 24th of June 2024, in paragraph 9, I have stated, asked the advocate to take step for hearing of the applications. My lord, it was found that the matter has been dismissed in Lojima for non-filing of the Tolowana cost of ₹5 and my lord, enough notice.
Acha, if you allow the application, can you do that by tomorrow?
I have already deposited.
Yeah, already.
Yes, I have stated.
Very well. You file your affidavit of service also today. The new affidavit of service or the din? Question.
Use the old affidavit of service and
The affidavits of service filed today be kept on record. Push up. It is evident from the same that copies of the restoration application have been served on the respondents. Full stop. As regards the supplementary affidavit, comma, we also find that substantial service has been effected. Full stop. Accordingly, we take up the application for hearing. Full stop. Next para. The learned counsel for the appellant submits that, as explained in the supplementary affidavit filed today in support of the restoration application, comma, due to the intervention of the pandemic in between and communication gap between the appellant and his counsel thereafter, due to reasons beyond the control of the appellant, comma, it was missed out that the appeal had been dismissed in the meantime due to non-compliance of the court's order to remove defects. Full stop. It is submitted that the defects are merely non-deposit of the Tolabana of ₹5 and filing of written up notice forms. Full stop. It is submitted that those have been deposited in the meantime. Full stop. Next para. In such view of the matter, comma, we are satisfied of the cause of the delay for filing the application. Full stop. Accordingly, Can 4 of 2024 is allowed, comma, thereby recalling the order dated March 8, 2022, whereby the appeal, whereby FA 24 of 2021 was dismissed for non-compliance of the court's order. Full stop. The appeal bearing FA 24 of 2021 and the connected applications are accordingly restored to their original file and number.
My lord, one thing I have prayed for, my lord, in paragraph 11 of the supplementary, that time to file the postal cost and my lord, application.
Postal cost and what else
I
remains?
have postal cost and my lord didn't have notice form.
You have already.
I have put in on 1st of
Acha.
July 2020.
Very well. The Tolabana, comma, written up notice form and postal costs which were deposited late be accepted upon condonation of delay in depositing the same. Thank you. Yes. Substitution application now.
Yes.
Substitution is late or within time?
From the date of knowledge within time.
No, from the date of death, you have to explain. Date of knowledge in an explanation.
No, date of death.
Appeal abates from the date of death after 90 days.
Yes, sir.
Your explanation may be from the date of knowledge, but what is the explanation? Let us see in the application. You have to pray for condonation, setting aside abatement and condonation of delay.
Condonation of delay application is pending.
It's also there.
Yes, sir.
Then we'll treat this substitution application to also contain the prayer of abatement, setting aside abatement. What is the explanation?
Actually, we are not known to each other. After the service of the TAN application, from the postal receipt, we came to know that the person has died.
Acha, then since there is a section 5, you have to serve on copies on the other side then.
Copy of the copy has been served on all the respondent. Respondent number 1, twice, once he refuses.
That is good service.
On the second time, no text.
But all right. You have served copies of both the applications.
Yes.
You have filed the affidavits of service. Please file.
In course of the day, I shall file, my lord. In course of the day.
On the prayer of learned counsel for the appellants stroke petitioners, comma, the appellants are directed to file their affidavit of service during the course of the day, full stop. Learned counsel for the appellants submits that proper service has been effected substantially on all the respondents. Full stop. Accordingly, we take up Can 1 of 2024 and Can 2 of 2025 for hearing. Full stop. Can 1 of Section 5 for preferring the appeal or preferring this application?
Preferring the appeal.
Acha. Then you have not prayed for the delay. You have not written a single line in the substitution application.
Don't know the date of death, my lord, because
You have to say that in your application. You have said it is filed within time. It is date of knowledge is not the time when the abatement is counted. It's a wrong impression on us. This is substitution. Operates after 90 days, automatically appeal abates against them. Date of knowledge is only an explanation. I will direct you to file the proper your.
Rule 4, sub rule 5, my lord.
What does it say?
Plaintiff was ignorant of the death of a dependent and could not, for that reason, make an
Order 20
application.
rule 4-5 subsection sub rule 5.
Yes, sir.
Yes, please.
Where the plaintiff was ignorant of the death of a defendant and could not, for that reason, make an application for the substitution of the legal representatives of the defendant under this rule within the period specified in the Limitation Act, and the suit has in consequence abated, and the plaintiff applies after the expiry of the period specified therefore in the Limitation Act for setting aside the abatement and also for the admission of that application under Section 5 of that Act on the ground that he had, by reason of such ignorance, sufficient cause for not making the application within the period of.
Now you are convinced that we are correct. You are wrong. We'll read it out for you.
Yes.
Where the plaintiff was ignorant of the death. It's a common misconception. You are not at fault. You are so confident, that's why we permitted you to read the provision. I lost my confidence when you said you are so confident. It is clear where the plaintiff was ignorant of the death of a defendant and could not for that reason make an application for substitution of the legal representatives under this rule within period, and the suit has in consequence abated, and the plaintiff applies after the expiry of the period specified therefore in the Limitation Act for setting aside the abatement and also for the admission of that application under Section 5 on the ground that he had, by reason of such ignorance, sufficient cause for not making the application within the period, the court shall, in considering the application under Section 5, have due regard to the fact of such ignorance. So file your Section 5 and your abatement. The present application has been filed for merely for substitution of the heirs and legal representatives of respondent number 5, Srimati Rekha Mondol. Full stop. However, the application has been filed beyond the period of beyond the limitation period for filing a substitution application, and even after the period of 60 days thereafter. Full stop. Accordingly, being not accompanied by any application for setting aside abatement and or condonation of delay, we grant leave to the appellants to file a composite application for setting aside abatement and condonation of delay in filing the present application. Full stop. The appellant shall serve prior copies of those applications on the respondents, indicating that the present application that the said applications shall be listed along with the present application. Full stop. Upon such service being effected and the appellants being prepared with a proper affidavit of service, leave is granted to the appellant to mention the present application as well as the fresh application, leave for which has been granted, for inclusion in the list. Full stop. Let the matter go out of the list for the present. But file your affidavit of service today. That we have granted you leave. File that today, it will be on the record. This will go out of list. Whenever you file those fresh applications and serve copies, mention applications we immediately include. Whenever you mention. Next.
I am for the appellant.
Behalf of the respondent.
Yes.
My lord, behalf of the respondent plaintiff, I am praying for not this week, my lord. We yet to receive the Vakalatnama from the clients, my lord. That's why we are.
What is the application for?
In the partition suit, it is a immediately.
All the respondents have been served.
Yes, the thing is, respondent and they are.
You don't have Vakalatnama yet, so you have no locus standi. What is your name? We'll have to record your name.
My lord, Sritamani Yogi, Advocate Sritamani Yogi.
Affidavit of service filed today be kept on record, which indicates that proper service has been effected on the respondents. Full stop. Next para. Ms. Sritama Niyogi, learned advocate having instruction to appear for the respondents, seeks some time, since No Vakalatnama has yet been obtained by her from the respondents. Full stop. Next para. Accordingly, the respondents are granted liberty to file their Vakalatnama within a week from date. Full stop. Next para. Since the present appeal arises out of a preliminary decree of partition, comma, we direct the learned trial judge to continue with the final degree proceedings, semicolon, however, comma, no final decree shall be drawn up by the learned trial judge without prior leave of this court during pendency of the present appeal. Full stop. Can 1 of 2024 shall be listed next on March 25, 2025. Till disposal of this application, we pass that ad interim order. We will finalize that when she appears. Right.
Lordship, I'm appearing for
Can't hear.
item number 7, Lordship. I'm appearing for the appellant, Lordship.
Yes.
In this matter, we have served the notice of it is a matrimonial appeal, Lordship, arising out of matrimonial suit under section 25(1) of the Special Marriage Act.
You have not put in the Talavana of ₹4 along with written up notice forms. There's a defect. There's an office report. File that during the course of this week.
I shall.
File that. We'll take up the matter next week. What are the two applications for?
The application can 1 is for
You're challenging a divorce.
no, our marriage has been declared annulled. I am the defendant wife in the suit.
So what sort of a stay do you want? Annulment has been declared. We cannot stay that. That would tantamount to allowing the appeal. That would revive the
So,
marriage.
Lordship, may kindly takes up the prayer. There is I have prayed for an interim order restraining the opposite party husband from
Remarrying.
for further marriage of him till the pendency of this appeal. Since the appeal is a continuation of the suit, and as
Very
well
well.
as the learned court has.
But you have to, the condition is that you have to put in this Solomona and written up notice form within a week.
Lordship,
We'll direct ad interim order. You have served copy or this is for the first time?
application is for the first time. We have served the notice of appeal. It has been duly served.
How did you serve it? You have not put in the postal costs. Independently you have served.
Independently we have served.
This application you have not served.
No, Lordship.
You gave a notice so that she does not marry. Keep that with you. We'll pass an interim order. The present can 1 of 2025 is an application captioned as 1 for stay. Full stop. However, comma, we find the necessary pleadings and prayer in the application seeking a restraint order on the respondent husband from remarrying till disposal of the appeal. Full stop. Next para. The brief facts are that the appeal arises out of a judgment and decree whereby the marriage between the parties has been annulled by declaring the same to be a nullity. Full stop. Next para. In the event remarriage is contracted by the respondent husband during pendency of the appeal, comma, the appellant shall obviously suffer from irreparable injury. Full stop. Keeping in view the same, comma, we pass an interim order of injunction restraining the respondent husband from remarrying, comma, if not already married, comma, restraining the respondent husband from contracting a remarriage, comma, if not already contracted before today, comma, till disposal of can 1 of 2025. Full stop. The appellant shall serve a copy of the application on the respondent husband, indicating that the matter shall be listed next on in the monthly list of April 2025. When the appellant shall file an affidavit of service to that effect. Full stop. Next para. However, comma, we also find from the office report that the Talovana of ₹4 along with written up notice forms for effecting service of notice of appeal upon the sole respondent has not yet been filed by the learned advocate for the appellant. Full stop. Accordingly, we direct the appellant to put in the Talovana of ₹4 along with written up notice forms within a week from date, positively. Full stop. The office shall furnish a further revised report in that regard before the next returnable date. Great. এটা মান্থলি লিস্ট আসবে, এর মধ্যে পাঠিয়ে দেবেন, ও তলবানা দিলে অফিস রিপোর্ট করে আবার পাঠালে তখন মান্থলি লিস্ট Do that, ensure that it is done, at least from your pocket you do it. I mean.
But I have for that.
Yes, please.
There is a delay of 130 days
In filing the appeal.
filing the appeal. And whether it is arising out of a partition suit, decree has been passed, preliminary decree has been passed when one of the defendant died. And decree has been passed against.
No,
the
you have
defendant.
already served on the other side.
No, madam. This is appearing first time.
No, one of the persons died, but then the appeal against him is also bad.
Difficulty is, my lord, I cannot change the cause title during because the
No, you could,
decree and the cause title of the
We
appeal.
won't advise you, but you should seek a leave.
That
You know what to do. Unless you do that, the appeal is also gone.
first time today, my lord. I can file an application for a matter.
In the meantime, serve a copy of this application and file that application immediately. Can 2 of what is Can 1 injunction?
Can 1 injunction.
So we cannot. Can 2 of 2024 is an application for condonation of delay in preferring the appeal. Full stop. The appellant is directed to serve a copy of the application on the respondents, indicating that the same shall be listed in the monthly list of April 2025. If we were in your position, we would file an application immediately and mention it to be tagged along with this in the common list. But we are not in your position, so you do whatever you like. Yes.
What the name of letter?
And insert the name of the learned trial judge in the memo. একটা ডিফেক্ট আছে দেখবেন আরেকটা লাইন অ্যাড করে দিন the learned advocate on record for the appellant shall also cure the defect by inserting the name of the learned trial judge in the preamble of the memorandum of appeal within a week from date.
Well, I am for the appeal and my lord, this is partition.
I am for the respondent number 1.
Of filing.
The number?
One.
One only. Yes. What about the others? Yes.
I filed the affidavit to
3.
1 and 3 taken care of. What about the others?
my lord, regarding
Yes.
5 respondent, the pro forma respondent, a copy was not served because due to insufficient address was written there. Returned that, the envelope also returned, my lord. But in the same address, they appeared in the court, trial court, my lord. The pro forma respondent.
Very well.
So we know that address. So that's why.
This is regarding 4 and 5.
Yes, my
What
lord.
about 2?
Also I served, my lord.
2 you have served.
Sir, yes.
So 1, 2, 3 you have served.
All served except 4 and 5.
All means 1 to 3.
Yes, sir.
There are only 5. So there, why are they pro forma?
Pro forma respondent 4 and 5.
You have made after 1 everybody has pro forma.
Yes, my lord.
Why?
Yes.
You have not sought any relief against them.
My lord.
Plaintiff was only there.
Plaintiff only there.
What is the decree against which you have challenged?
Partition degree, preliminary degree was first.
But you have to serve all.
By the trial court, yes, my lord.
Well, affidavit of service filed today be kept. We are passing the usual order. Continue with no final degree.
We will file our affidavit in opposition regarding.
Do this, don't.
Well, there is jointness of property. The question arising, my lord, already.
We are not granting. This is not an injunction application. This is a stay application. If it were an injunction application, we would grant you leave. But this is the usual order. The trial court will continue with the final degree proceedings. If the final degree is drawn up, whether you file an affidavit in opposition or not, will restrain that.
Well, the question is jointness of the property because before this partition suit,
yes,
the father of the plaintiff and the defendant,
but that unless
already gifted the property.
Gifted the property. Unless you win the appeal, we cannot say that. At this stage, it's joint because there's a preliminary. Achha, the affidavit of service filed in court today be kept on record along with the connected envelopes. Full stop. Respondent numbers 1 and 3 are represented. Full stop. Represented through counsel. Full stop. As far as respondent number 2 is concerned, comma, proper service has been effected. Full stop. However, comma, with regard to respondent numbers, pro forma respondent numbers 4 and 5, comma, the envelopes have returned unserved with the endorsement insufficient address. Full stop. Learned counsel for the appellant. Achha, they contested 4 and 5 contested in the court below.
Yes, my lord, trial court.
Appellant points out that the address as given in the envelopes tallies with the address of the pro forma respondent numbers 4 and 5 at which they contested in the court below.
It's party against defendant number 3.
Achha.
Not good.
Thale initially contested করে দিন. Puts up next para, be that as it may, comma, since the address of the envelopes tallies with the address of the said parties in the court below, we are of the opinion that substantial service has been effected. Puts up learned counsel for the respondent number 3. You are for 3.
No, I'm for 3, Lord.
Respondent number 1 seeks to use an affidavit in opposition to the application. Puts up, however, comma, since no new facts have been pleaded herein, and only the facts pertaining to the suit in the court below have been substantially pleaded, we are of the opinion that direction of affidavits will unnecessarily delay the proceedings. Full stop. Next para. However, we make it clear that since affidavits are not directed, none of the allegations made in the application are deemed to be admitted by any of the respondents. Full stop. Can 1 of 2024 is accordingly disposed of by directing the learned trial judge to continue with the final degree proceedings in the partition suit from which the present appeal arises. Full stop. However, no final decree shall be drawn up without prior leave of this court till disposal of the present appeal. Full stop. In view of appearance, service of notice of appeal on the respond numbers 1 and 3 is dispensed with. Full stop. The appellant shall put in due requisites for service of notice of appeal on the other respondents and pro forma respondents within a week from date. Full stop. The trial court records, upon retaining a skeletal record for the purpose of proceeding with the final degree proceedings, shall be brought before this court by special messenger at the cost of the appellant, which is also to be deposited within a week from date. Full stop. Upon notice of service of arrival of the trial court records on the learned advocate for the appellants, the appellants shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Lordship, one thing. Pro forma number, defendant number 4 and 5, decree was drawn against them ex parte. They have not appeared in the lower court.
But firstly appeared, thereafter subsequently they did not appear.
From the very
We have added initially. Did they file written statement?
No,
Your
they did not file written statement.
No.
Did not file written statement. But
তাহলে একটা জায়গায় বলেছি না সেকেন্ড প্যারাগ্রাফে যে it is submitted by learned counsel for the appellants that pro forma respondent numbers 4 and 5 initially contested.
the subsequently did not.
At which initially they contested in the court. Address at which they initially contested with the since the address of the envelope tallied with the
Initially contested in the court below টা কেটে দেবেন ওটা হবে learned counsel for the appellant submits that the service was effected as far as 3 and 4 are concerned, 4 and 5 are concerned, এটা বলছে কোশ্চেনটা স্যার you should have checked up before submitting that they contested. The 4 and 5 যেটা লেখা রয়েছে ওটা কি লেখা আছে ওই তো 4 and 5 লেখা আছে
however with regard to the cohort
ওটাই বলছি তো
envelope of the return with the endorsement insufficient address.
full stop দিয়ে ওটা পরের সেন্টেন্সটা হবে learned counsel for the appellant learned counsel for the appellants points out that the suit was decreed ex parte against the said pro forma respondents, despite service having been effected on the said respondents at the address as given in the envelopes. Suit ex parte degree হতো না যদি না সার্ভিস সমান বাস এটুকুনি থাক তারপর পূজা আছে থ্যাংক ইউ ফর পয়েন্টিং আউট ইয়েস
May it please your lordship.
Yes.
There is a delay in taking out this appeal of 39 days, my lord.
39 days?
Yes. And my lord, the appellant was.
You have to serve on the other side.
Yes, I have served, my lord.
Did you direct you to serve?
No, it is the first time it is happening.
Without direction, service has no meaning. Although learned counsel for the respondents, appellant submits that service have been effected on the respondents, full stop, we find that there is no previous direction for such service, full stop. Accordingly, the appellant shall serve copies of the.
There are two applications. One is
both applications serve of both the applications bearing can 1 of 2024 and can 2 of 2024 on the respondents, indicating that the applications shall be listed for hearing in the monthly list of April 2025 when an affidavit of service to that effect shall be filed by the appellant.
I'm getting.
Serve and come back, serve both the applications.
Yes.
Next.
11, my lord.
Yes.
For the respondent number 6, my lord.
6.
6. My caveat was filed on.
Oh, you have to serve on the others then, Mr. Lokit. This is against preliminary degree of partition.
Your partition.
Although the respondent number 6, there was no direction for service.
No.
Yes.
Although service has been effected on the caveator stroke respondent number 6, who is represented in court through counsel today, comma, the other respondents have not yet been served, full stop. Accordingly, the appellants shall serve copies of Can 1 of 2024 on the other respondents apart from respondent number 6, indicating that the application shall be listed in the monthly list of April 2025 for hearing. Full stop. Next para. The appellant shall file an affidavit of service to that effect on the returnable date. Stop. Till disposal of the present application, comma, the learned trial judge shall proceed with the final degree proceedings, but shall not draw up any final degree without prior leave of this court.
My lord, with regard to my lord injunction, my lord, what he has prayed, my lord,
Injunction, he is not pressing. Dekhi, tin. You have to say that, Mr. Rokit.
joint prayer, my lord.
Injunction regarding third party interest or?
Yes, my lord, yes.
Yes, what do you say to that?
File affidavit, my lord.
Very well.
Because from the order, it is evident, my lord, that their predecessor in interest has put as attesting witness on that
File
document.
an affidavit within a week then. Within a week. আচ্ছা তাহলে returnable যেটা করলাম in the monthly list of April না করে shall next be listed on April 21, 2025. Full stop. Next para. Affidavits in opposition, if any, shall be filed by the respondents within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The parties shall remain restrained during pendency of the application from selling, transferring, alienating, on encumbering the suit property in favor of third parties. Change of nature, character, have you prayed?
Yes.
Doing anything, my lord. Kindly.
They have to pray for that, otherwise we won't.
They have not prayed before your lordship, my lord. I wanted to file affidavit.
It is that. There is no allegation of construction also. Next.
My appeal, my lord. I'm on behalf of the respondent husband, lordship.
Give us half a minute.
May I submit the affidavit of service? On the last occasion.
Give us half a minute. Very good. You have served affairs and they're appearing. Affidavit of service filed to be kept on record. Which application first?
Injunction application first. There's another application we have filed.
You are challenging a divorce decree. Divorce has been granted.
Party divorce decree in favor of the husband, my lord.
So we are granting an injunction. Don't buy me.
Lordship, in that event, just few minutes ago, I received the brief, and Lordship, I have downloaded one order from e-court service, the order of learned trial court. Lordship, I just want to point out this order, right? Order number or order dated 7/11/2024. In this order, it is reflected that someone was tried to be served upon the wife petitioner, but wife petitioner refused to receive.
No, we'll consider that in the appeal.
There's another proceeding for 913 as well. And Lordship, an a separate miscellaneous case under order 9.
That does not debar an appeal.
No, Lord, it is not a bar. It is not a bar.
No bar.
Lord, one more thing, my lord. I filed an application for alimony pendentility on the last occasion, which is due to appear today.
It is appearing.
Oh, my lord, may I serve upon them in the meantime? Since none was appearing.
Very well. Injunction we are disposing of right now. We are recording that you are not admitting any of the allegations made herein.
And there's another issue, my lord. There was a eviction notice served upon me to leave my matrimonial home. The order was passed by your lordship, including that part.
What order was passed?
My lord, the first order, my lord, 28th of January. Kindly that order be
reimposed. I mean, continue. Yes. Cannot evict her. You have to be saddled with her for the rest of your. No, the rest of the pendency of the eviction, at least.
Lordship, kindly on the record that we are not admitting any other kind of allegation.
No, we recorded. Can 1 of 2025 is taken up first for hearing, full stop. The same is an application for injunction on twofold grounds. Full stop. First, comma, since the appeal has been preferred against a decree, against an ex parte decree of divorce, comma, the appellant wife seeks a restraint order on the husband respondent from remarrying during pendency of the appeal. Full stop. Secondly, comma, by a notice dated January 1, 2025, comma, the respondent husband has sought to evict the appellant from the matrimonial home. Full stop. Next para. Since a prima facie case for hearing the appeal has been made out upon hearing learned counsel for the parties, comma, we are of the opinion that the appellant is entitled to both the injunctions as sought for. Full stop. Next para. However, comma, since affidavits are not invited, comma, it is deemed that none of the allegations made in Can 1 of 2025 are admitted by the respondent. Full stop. Next para. Can 1 of 2025 is accordingly disposed of by restraining the respondent husband from contracting any remarriage and or acting on or giving any effect to the purported eviction notice dated January 1, 2025, annexed to the supplementary affidavit to the application, comma, asking the appellant wife to leave and vacate her matrimonial residence and stroke or from disturbing the peaceful possession of the appellant in respect of her matrimonial residence in any manner whatsoever till pendency of the appeal. Full stop. Next para. The appellant wife shall serve a copy of Can 2 of 2024, comma, an alimony, Can 2 of 2025, comma, an alimony application on the learned advocate appearing for the respondent during the course of the day. Full stop. You will. You have not filed your affidavit of asset.
No, my lord, that's what I'm praying for.
The affidavit of asset of the wife shall be filed how soon?
1 week.
Shall be affirmed within a week from date, and a copy thereof shall also be served on the learned advocate for the respondent husband within a week. Full stop. Next para. The respondent husband shall file his affidavit in shall file his composite affidavit in opposition to the alimony application and the affidavit in asset of the wife, as well as the husband's independent affidavit of assets within 3 weeks from date.
Lordship, within 4 weeks. Lordship.
Then we'll direct you to pay some interim alimony.
There's a
Pay rupees 1 lakh and take 3.
It's a 15-year-old child, my lord.
Within 3 weeks from date, full stop. Next para, reply thereto, if any, shall be filed within a week thereafter. Full stop. The application shall be placed for hearing in the list on April 21, 2025.
I'm extremely grateful, my lord.
2025.
Photo ma'am.
Deeply obliged.
Item number 13.
Sir, I'm for the appellant petitioner.
Yes.
As
Service
per
affected, you sought for time on that count.
Yes,
I am
You're appearing, Mr.
only for one.
Oh,
Respondent.
what about service? On the last occasion, you took time to ascertain whether service has been affected.
one has received and one
There are 2 only.
left without any instruction.
Left,
The
then you have to
concerned
serve. No, but we find only 1 respondent here.
No, that is the
received. Duly received the postal.
No, in the application, only 1 respondent is mentioned.
no, that is Nirmal Chandra Shil since disease. And so the first son is of Nirmal is Pavitra.
No, these applications are for substitution.
Nirmal Chandra Shil was the dependent. His 2 sons.
What is the reason for what is the delay in preferring this application? What is the delay? Please use the microphone.
Delay is caused, my lord. Appellant petitioner.
Can't hear you. Use
Appellant petitioner is about 80 years old. She informed belatedly that his
No, what is the delay in preferring this application?
delay caused, my lord.
What is the delay? What is the time?
This delay, my lord, 1,621 days.
It is for setting aside amendment.
Setting aside
Not only that, condonation was 1,000 something.
1,621 days. Section
How many years? Divide by 365.
in this time.
What? How many years? Very bad in maths.
3 years, more than 3
years.
years.
More than 3, obviously, I can also say that. More than 4 maybe.
In this time,
Sufficient cause has been shown.
What is the cause? Let us see the cause.
Moreover, the
Should I use the
Affidavit in opposition.
COVID-19 period intervened, my lord, in this period.
In view of the huge delay in preferring the application for substitution and the application for setting aside abatement, comma, coupled with the application for condonation of delay, comma, learned counsel for the substituted respondent number 1 seeks to use an affidavit in opposition to the applications. Full stop. Next para, we also find from the affidavit of service that proper service has not yet been effected on the substituted respondent number 2. Full stop. Accordingly,
One has been received, madam.
accordingly, the appellant shall ascertain the current address of the substituted respondent number 2 and effect fresh service on the substituted respondent number 2B within a fortnight from date. Full stop. Leave is granted to the learned advocate on record for the appellant to carry out the necessary amendment incorporating the correct address in the cause title of the pending appeals and the memorandum of appeal within a fortnight. You'll
Postal service.
that will take years. No, postal service.
He is not available, madam.
You don't understand. Postal service, you will put in requisites, but the service will be effected at the same address.
Yes, madam.
Envelope says left. You have to ascertain the correct address. We have given you 2 weeks to ascertain the correct address and effect the correction in the memorandum of appeal and the connected applications. You will incorporate the current address within 2 weeks and also serve on them. Full stop. Fresh affidavit of service in that regard shall be filed on the next returnable date. Full stop. On the prayer of the respondent number 1, comma, the respondent number 1 is directed to file affidavits in opposition to the applications within on the prayer of the learned advocate for the respondent number 1, comma, leave is granted to the substituted respondents to file their affidavits in opposition within 4 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Let the matter go out of the list for the present with liberty to the appellant to mention the application as and when such fresh service is effected. Thank you.
Will I beg to appear on behalf of the respondent, my lord? But I am for the applicant.
You have filed a no objection Vakalatnama.
No,
You have filed. You have filed that no objection Vakalatnama, but the name does not tally. I mean, the memorandum says Shopon Pramanik with K. Who is this, please? Whose phone is this, please? Apnar? Memorandum spells Pramanik with a K, and your Vakalatnama is signed as CK.
Vakalatnama Shopon Pramanik.
Still you are in Shopon?
Yes.
We have reached Pramanik, the end of Pramanik. Pramanik ends with K in the memorandum. Your Vakalatnama says CK. Unless there is an indication, it cannot be a good Vakalatnama. Why do you not ascertain these things? The name has to be correct. Either he has to sign correctly or say alias, you know what to do. Then you have to obtain a no objection again. We cannot record your presence. Nonsense. Minimum they can have. File a proper Vakalatnama. Or you can file an affidavit, 1-page affidavit, we can grant you leave, your client will file a 1-page affidavit saying Shopon Pramanik is Shopon Pramanik.
Yes, madam.
CK.
I will file.
Will within a week do that. We find from the office report that the name of the respondent has been wrongly spelled. Sorry, the surname of the respondent has been wrongly spelled in the no objection Vakalatnama, for which the Vakalatnama cannot be tagged properly. Full stop. Next para. Leave is granted to the respondent to file a short affidavit indicating that the names, the surnames of the respondent in the Vakalatnama and the memorandum of appeal belong to the self-same person. Push up. Such affidavit shall be filed within a week from date with an advance copy to the learned advocate for the appellant. Pushed up. The application shall be listed next on March 18, 2025. What is the application for?
Now it is the application.
So the appeal is against?
The primary degree of a partition should among the.
So you have not granted any interim order as yet. You are granting ad interim order till disposal of the application. Do whatever you want in the meantime, that affidavit. The application will appear on 15. Push up. Next para. During pendency of the application, comma, the learned trial judge shall continue with the final degree proceedings, but shall not draw up any final degree of partition without the leave of this court.
Let the LCR be called for.
Not now, because after we dispose of the application on the same day, we'll direct you to do whatever. Their appearance has to be recorded. Unless that is done, we cannot dispense with service of notice of the appeal. That is the difficulty.
Madam, for the petition.
Yes, Mr. Right. Ex parte dismissal. Visitation.
I'm for the respondent, my lord.
Yes. You have carried out the necessary amendment to the cost title of the memorandum and all. Leave was granted.
Yes, my lord.
My client didn't receive the FA application.
Why two parties?
No.
Why two envelopes?
And in the
Two
three
addresses.
it was sent. From the two addresses mentioned, manner it has come with the postal endorsement insufficient address. And so far as the other address is concerned, it has been received. The post.
Yes, what do you say? You are Mr.
I'm Mr. Saptarshi Datto.
Mr. Datto, what? Yes, what are you saying?
I have not received the first appeal application.
First appeal, there is
I
no
have
first appeal application. There is a memorandum of appeal and there is an application in connection to the first appeal.
Okay,
He is not
I
duty
have got
bound to
the-
give
I
you
have
any
got the
copy of the
letter.
memorandum. You have got
I
a copy of
didn't.
the application?
Yes, I have
What
got
is
the
your,
copy of
what
the
is your
application.
stand? Let us hear the application then. Yes. You are the
I
father.
will be filing an affidavit in reply.
No, you cannot use an affidavit in reply. You have to use an affidavit in opposition, Mr. Datt.
Okay.
This is my application. My child is born on 24th August 2017. Now, I could visit my child lastly on May 2024. Although there is a direction to bring the child at the district legal service office of the district legal service authority at Barashat, but lastly the wife brought the child on May 2024 on the third week, Friday of third week. Friday of every
What was the direction
month.
given initially?
If your lordships kindly come to page.
No, the visitation was given for what? What frequency? Calcutta gave visit.
Once in every month in the third
Third Saturday.
Third February.
Once every month, 3rd February cannot be, third month, third day.
Third Friday. Sorry, I'm begging
Third
pardon.
Friday. Third Friday. So that was not complete, but now the suit is over, so that order is also not there.
But
So we'll pass.
The order has already been vacated, my lord.
The lordship, the conduct of the wife.
What does she do?
She is not deliberately bringing the child.
Yes, you want to use an affidavit in opposition, Mr. Datt?
Yes, my lord. Yes,
How
my
soon
lord.
can you file that?
I will need a 2 weeks time.
We are granting you 2 weeks, but in the meantime, every weekend you will give visitation to the father.
Yes, my lord.
Very good. Which day suits you? Friday?
Saturday or Sunday will be good.
Saturday or Sunday will be convenient. Not you, in fact, your child also.
Yes,
So-
yes, obviously.
So it has to be a neutral place near your place.
They are staying nearly at Mahesthala right now.
Mahesthala. And you?
So whatever suit.
You reside at?
I reside near at nearly to the Alipur Judges Court.
Previous visitation was given where, Mr. Rai?
My lord, at the district level authority, my lord, district legal service authorities office at North 24 Parganas.
Not any office, some park somewhere.
Any
So,
malls also, sir?
Or any mall.
Mall,
My
mall,
lord.
very well. Mall is acceptable.
South City Mall?
That will involve expenses for you. Don't forget that. You'll have to buy something to the wife also.
No, my lord. There will be no difficulty.
Divorce has been refused.
Divorce has been
So
refused.
marriage subsists. She's still your wife.
Yes. Expert.
Remember that also.
Yes,
Expertly or whatever.
Yes.
We are not going. But Mr. Rai, then choose a mall. I mean, you reside near airport, Birati.
Yes.
And they reside, it has to be the convenience of the child.
Yes.
So near her residence.
Yes, yes.
You choose a mall.
At South City Mall as suggested by my land friend.
South City Mall?
South City Mall will be good.
Very well, very well. So every Saturday around, it will be for 2 hours. What time will suit you or the child?
See, in the evening, she has some activities. I'm not sure about that.
In the afternoon?
After those, like
Not after
5
that.
to 5 to 7 will be good, I hopefully.
5 to 7? Very well. Fair enough, Mr. Dutt. Thank you. The present application is one for visitation of the minor daughter or son?
Daughter.
Minor daughter of the parties who is aged
7.5 years.
a little more than 7 years. Full stop, next para. Learned counsel for the appellant submits that the visitation right as granted by the trial court was not properly given by the respondent wife. Full stop. The allegations made in the application and by learned counsel for the appellant are controverted by learned counsel for the respondent. Full stop. On the prayer of the respondent, the respondent is directed to file an affidavit in opposition to the present application within a week, within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The application shall be listed next on April 9, 2025 under the same heading. Full stop. In the meantime, on every Saturday between 5 and 7 p.m., the respondent wife shall take the minor daughter of the parties to a pre-appointed place in the South City Mall in South Calcutta, the time and the exact location being fixed by telephonic conversation between the parties prior to such meeting, for the purpose of visitation by the appellant father of the child. Full stop. Next para, it is made clear that none else than the appellant and the respondent will be present at the time of such visitation, and the respondent shall not, in any manner, obstruct the free and fair access of the appellant to his minor daughter during such visitation. Full stop. Very well. This much.
My lord, your lordships recorded that for the
Only.
accepting the
You and her.
yes. Now, my lord, my clients' parents
For the time being.
My lord, kindly record that for the time being. My lord.
আচ্ছা ঠিক আছে যেখানে বললাম যে only the respondent, only the petitioner respondent, সেটা সেন্টেন্সটা শুরুতে দিয়ে দাও for the time being.
And my lord, since my learned friend has already entered appearance, my lord, the service of notice of appeal upon the respondents may be dispensed with.
Very well. In view of the appearance of the respondent through her learned advocate, service of notice of the appeal is dispensed with. Full stop. The trial court records be called for by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Obliged.
Any other application?
No, my lord, no concern.
আমারটা লাস্ট ছিল।
before your lordship takes other matter,
Sorry.
my lord, I made a mistake.
What mistake?
My lord, in the item number 3. my
What
lord,
happened? What did you do?
First title, he described us as plaintiff.
My lord,
We are dependents.
my lord, I am the plaintiff. Now, my lord, because of the wrongly cost title mentioned in the application, my lord, it's my mistake. I should have, my lord.
Not that, but what can you do now? We have allowed two appeals, two applications.
Two applications were allowed in one.
Those two applications we need not pass any further.
Defendant's application, your lordship is described as plaintiff's application.
Then we'll have to recall that order. We'll recall and keep it tomorrow. Item 3 টা কে নিয়েছে? We are not recording that, but we have passed that in open court. তুমি একটা লিখে নাও, তন্ময়কে বলে দেবে 3 টা এটা ঢুকিয়ে দিতে। লেটার বলে, একটা লেটার বলে আন্ডারলাইন করে, যা অর্ডার আছে লেটার করে। Subsequently, learned counsel for the parties mentioned the matter due to certain factual errors having been factual submissions having inadvertently been made, comma, which was the premise of the above order, full stop. Accordingly, let the matter be placed in the list tomorrow under the same heading. We have passed in open court, that order remains. We are saying that the next. Thank you.
Petition of the court, I have filed, serve a copy of the petition upon the.
What is the petition for?
No,
Is the
no,
matter?
I'm telling you, very short.
Mr. Ghoshal, and please take your seats. Yes.
Stay application is being taken.
Stay application in connection with what?
The appeal has been admitted, stay has been granted.
The
Appeal
substitution
can do-
certificate was granted in favor of the stepson. I am the second wife. Without making me as a party, he has filed an application. Ultimately, I filed an application, order 1, rule 10. That was also rejected, succession granted. It's an admitted fact, they have filed a suit for declaration untitled that my marriage is nullity. That suit has been filed prior to filing of this application.
That suit is not yet decreed.
Okay. That is still pending.
What is the application for?
That is, application is after granting the stay for not to disburse the amount by the LIC, 1,80,000.
Can stay of operation of the impugned judgment. So we have granted stay till disposal of the application.
Yes, my lord.
We'll make that absolute. Suit is pending, challenging nullity. That means you admit the marriage.
The thing is that, my marriage kindly appreciate, I appreciate that. And one thing is that in that case, the paperwork direction will be given. And
To you?
Yeah,
To the appellant, we will definitely give. We are
One
disposing of
thing-
the application, we will direct. And
kindly see one paragraph, if my lord permits me.
absolutely, yes.
Order number 28, middle portion, only one paragraph.
Page.
Order number 28, on the other hand, that paragraph.
Paragraph of what?
On the other hand, that portion.
Paragraph of what?
Order number 28.
Where do we find that in the application? Which page?
I think it is annexed to the memo.
It's the impugned judgment.
Yes. Right.
Impugned judgment, paragraph number 28.
Order number 28.
Yes, order number 28, yes.
Paragraph starts with on the other hand.
On the other hand, yes.
And advocate for the petitioner of the Miss case has submitted that Puspa Haldar is not legally married wife of such and such. She is stranger to this instant case. It is submitted that the Puspa Haldar, actually married wife of Pallav Kumar Bose, and their marriage was dissolved on 23/7/2014 by decree of divorce. Therefore, she was married with Pallav Kumar Bose on 11/8/2013. So during the pendency of the earlier divorce application.
Your case is that you married.
Marriage is earlier. That
Earlier?
was a mistake, and that was a correction by the marriage registers also. And he has given a deposition before the court also. There was a mistake, it has been recorded.
So you are not the second wife, you are the first wife.
No, I am the second wife, admittedly. They are disputing that during my first marriage, I contacted the second marriage.
Oh, your first marriage?
Yes. But I am a divorcee.
Divorce took place after the marriage of the second marriage.
There is a mistake, and that mistake was corrected by the marriage register.
The order says there's also.
But that's an arguable case, Mr. Ghoshal. There should be.
That's why that's and one thing, Admittedly, a civil suit is pending challenging the relation.
Yes, that is the reason we are saying that it's sub judice. That is the precise reason on which he gets an arguable
the
question.
conclusive proof of this relationship.
That is true.
Learned counsel, now, you are filing affidavit of service today.
Yes, yes, I've heard.
Affidavit of service filed today be kept on record. Push up both sides, heard learned counsel for the parties. Push up the appellant contends that she contracted a valid marriage with the deceased, comma, in respect of whose estate the impugned judgment has granted succession in favor of the respondent, comma, who is the stepson
Stepson.
of the appellant, comma, being the son of the deceased. First of next para. It is argued by the appellant that there is a subsisting suit seeking a declaration that the marriage of the appellant with the deceased person was a nullity in view of the same having been contracted during subsistence of the previous marriage of the appellant. Full stop. However, comma, the marriage registration certificate of the appellant was subsequently corrected, comma, since there was a bona fide error regarding the date of the same, and the marriage between the appellant and the deceased person took place only after severance of the previous marriage of the appellant by way of a divorce. Push up next para. Such suit, learned senior counsel appearing for the respondent disputes such contentions and submits that the documents furnished by the appellant are not conclusive proof that there was a valid marriage between the appellant and the deceased father of the respondent. Pushed up as such, comma, learned senior counsel seeks to justify the impugned order granting succession certificate to the respondent without impleading the appellant as a party thereto. Pushed up next para. However, comma, since a civil suit is pending at present challenging the validity of the marriage of the appellant with the deceased, comma, we are of the opinion that a sufficient arguable case has been made out for hearing the present appeal on merits as to whether cause of action was made out by the appellant for being impleaded before grant of the succession certificate, and as to whether the grant of succession certificate in favor of the respondent exclusively was justified. Pushed up. Accordingly, there shall be stay of operation of the impugned judgment and order within bracket deemed decree dated December 23, 2024, passed by the learned civil judge senior division, first court within bracket district delegate bracket close at Asansol, comma, district Paschim Bardhaman in succession case number 50 of 2021 till disposal of the appeal. Pushed up next para. The in view of appearance of the sole respondent through his learned advocate, comma, service of notice of appeal on the respondent is dispensed with. The trial court records shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Pushed up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who sub liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Subject to correction, whether this order will have no bearing on the civil suit, pending civil suit.
It is made clear that this court has not entered into the merits of the contentions and has made the above observations only in the context of ascertaining whether there is a prima facie case for hearing of the present appeal. Push up in any event, comma, the findings of a court in a succession proceeding cannot be conclusive insofar as the civil court is concerned. Push up hence, comma, it is made clear that none of the above observations shall be binding or conclusive, and the civil court where the title suit regarding the marriage of the appellant is pending shall independently decide such suit and connected proceedings without being influenced in any manner by any of the observations made above.
Grateful, Lordship.
Number 17.
Well, I am for the petitioner.
Yes, Mr. Chandu.
But as per your lordship's direction, my lord, I served the notice past 3 places. So for the one that address given in the cost title of the memorandum of appeal at where he is not living. Thereafter, one address is incorporated with the leave of the Honorable Court. In spite of that, I have also sent a notice to their working place. And so far the new address is concerned, that is unclaimed, return. But husband is contesting in a proceedings, that is maintenance proceedings in the barrackpur.
At the same address?
But I do not know whether he is living or not.
No. His address given in the said proceeding is the same as this. Then how can that have a bearing on this?
No, I praying for leave. If your lordship direct me to serve the copy of the learned advocate appearing in that proceedings.
Achha. The affidavit of service filed today indicates that proper service has not been effected.
That is unclaimed, both two places. Your lordship kindly see, unclaimed.
Oh, achha, that is good service. There were previous indications. Well, the affidavit of service filed today along with the connected envelopes, indicate that in respect of two of the addresses of the respondent husband, the postal envelope has returned with the endorsement within double inverted intimation served and double inverted unclaimed. Hence, the same tantamounts to good service on the husband. Such affidavits of service are kept on record. Can 1 of 2025 is accordingly disposed of by restraining the respondent husband by an order of injunction from contracting any remarriage during pendency of the appeal. Next para can there will be no order as to cost. The appellant shall put in requisites for service of notice of appeal on the respondent within a week from date, and also put in special messenger cost within a week from date for bringing the trial court records by such special messenger, upon which the trial court records shall be so brought before this court. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Of liberty to the parties to mention the appeal for hearing, inclusion in the list for hearing, as and when the same is ready for hearing.
Yes.
Item number 18, my lord, I am the unfortunate so-called wife. What happened, my lord? And
unfortunate so-called wife means?
Why I'm telling.
After Mr. Mukherjee is engaged, he cannot be unfortunate. Once he is engaged,
so
nobody can
is for the so-called unfortunate husband?
Yes.
Like yes, why?
Now, what happened, my lord? A suit for divorce has been filed. I say, my lord, that the
no, you are challenging what? What decree?
Divorce decree. Decree for divorce. Now, my lord, I will show, but mere filing, they filed the matrimonial suit. There is a direction for service. Now, my lord, my specific instruction that the summons has never been served. Good, bad, made indifferent, my lord. Ultimately, decree was passed. But if you see once the order, the court says expiry decree, that court has to consider. It is not that the matrimonial proceeding court suo motu will believe whatever statement has been made. Now,
I have to prove their case.
Absolutely. I will show from that. Now, second thing, when I came to learn about this decree.
This is injunction restraining remarriage.
No, something happened. That's why I'm taking your lordship's time.
Oh.
Now, when I came to learn, when in 498 proceeding, they took bail. They said that I got a decree for divorce. Then I came to learn and obtained certificate copy, and I came to learn that they are going to marriage in 4th March.
2nd March.
2nd March. I'm sorry. Now, then I preferred the appeal after obtaining, and you are kind enough to grant an interim order. Now, from my neighbors and others, I came to learn that possibly they have already married.
Before that order.
Before. Now, my lord, I will just.
Mr. Chakravarti is so happy.
When he is appearing, I have nothing.
That picture was not given to my lord when the order was passed.
I'm
Today they got to know. Earlier they did not know. That picture was not given.
From your mobile, I have just seen. Now, I'm just telling to your lordship.
Mobile showed you.
Photographs. Now, my kindly.
How are the photographs relevant?
Photographs, my lord, the marriage
photographs which I've seen from his tab.
Mr. Chakraborty is carrying his client's marriage photographs.
No, Mr. Chakraborty in file, all things are there. Come on, kindly once see, my lord, once, my lord. Impugn judgment, my lord, once see, my lord.
Yes, impugn judgment.
But kindly see, my lord, once, order number 7. 3rd June 2024.
Yes.
But two ground.
এই
One is, my lord, that deduction, and
সার্টিফিকেট
second is
বড় লং
cruelty.
3-4 পাতা পড়ে সার্টিফিকেট করে যে 3-4 পাতা পড়ে
Order number 7 here, my lord.
নম্বর 7 পেয়ে যান ওটাই বুঝছেন yes
But kindly see, the petitioner, I'm skipping. The ground of cruelty has been established ex parte in view of uncontroverted and unchallenged testimony of the petitioner. This
Yes.
is the only ground.
oh
And this is the reason. He has stated so many things. He has to prove his case. And the court, on the next paragraph, your lordship will find harping on the service of summons. If that be the judgment of the learned trial judge with due respect, one line, that is the ex parte, therefore whatever cruelty he is saying, he is correct and pass the ex parte decree. Now kindly see the matter. If your lordship
লাগানো আছে আপনি
আমি তো দেখে আমি জানি তুই বুঝিস সব।
but what can we do now the
That's
injunction cannot be passed if they have remarried this will be
Expedite.
this will abide by the outcome of the appeal
And only I will pray because matrimonial suit, my lord, if your lordship kindly expedite the hearing.
how can you do that tell us
Now, my lord, I will put the special man jack cost for bringing lower court records, and I will prepare the paper book, my lord.
that you are doing in every case
But if your lordship kindly fix any day, my lord. Kindly see only one line.
anything special we can do for you in this case to expedite Lord.
Only one line.
What line
No, only one line in the judgment. It is a
judgment we understand yes what do you say
Lord, two things. One, there's a delay of 269 days that has not been condoned.
in
So,
preferring
Lord,
the appeal
Yes, they preferred the appeal. Your lordship passed the order, my lord.
oh during pendency of that section 5
Yes.
oh right
So we have to, my lord, file an affidavit against that because we have certain things to produce that she was aware of this, number one.
so
Number
they
two,
will
Lord.
not dispose of can 2 also
Yes, number two, my lord, since it has just failed from your lordship that this will be subject to the result of the appeal, my lord will consider, my lord, what the Supreme Court has said, the time period under 15 of Hindu Marriage Act and 25 under this act, my lord, 30 under the Special Marriage Act.
no sanction
No sanction required.
no
And
sanction
this cannot be a void
it's
marriage.
not under void or voidable
Yes, kindly have a look.
the Supreme Court judgment is required for that Mr.
So,
Chakraborty
my lord, since your lord, it
there
is
is
just
no penal provision one
Absolutely. It's not a
secondly
mandatory.
it's not a void marriage or a voidable marriage under the act itself
The act never says that if you do this, this
so
will
it's
be the
directory
consequence.
that's only a fetter
Yes.
Yeah.
So the time has gone.
I'm
Decree
saying
of
when the
June
judgment-
2024.
But in any event, it will abide by the result of this. You will have 2 wives. That is the result of the appeal.
Yes,
If
that
they
will be
win
the,
the appeal,
yes,
then you will have 2
that
wives.
will be the that
They're
will be
valid
the,
wives.
that will be the result.
That will be your penalty.
Yes. And both the marriages
You
will
have
become
to
valid.
subsidy. Yes, you have to pay maintenance to both,
Yes.
maintain both, and everything
Now,
else.
perhaps not that would not you also would
You
consider.
feel yourself to be a king. You carry out a second marriage. Now you'll behave like a king after this
June
happens.
2024, I conducted in December 2024 after 6 months. I waited.
Oh.
So it's not that within 15
No, then
90
that
days I
can
did it.
that has to be a consideration in condoning the delay also.
Yes, I'll come back with that affidavit. That's what I was
Yes,
saying. Kindly allow me to file an affidavit.
Right,
And now
definitely.
kindly modify the order that your lordship passed
Yes.
injunction. Since they are saying
When can 1 of 2025 is an application for condonation of delay in preferring the appeal, and can 2 of 2025 is an application for injunction restraining the respondent husband from remarrying during pendency of the appeal, full stop, by an order dated February 27, 2025, comma, in view of the extreme urgency pleaded by the appellant, comma, we had granted an injunction in consonance with the injunction application prayer of the appellant, comma, since it was given out to us that the respondent husband was about to marry a third party on March 2, 2025. Post of next para, however, comma, it transpires from the submission of learned counsel for both parties today that a second marriage had already been contracted by the respondent husband prior to the passing of the injunction order on February 27, 2025. Full stop. Next para. However, in order for the respondent husband to bring the particulars in that regard, on record, comma, the respondent is directed to file an affidavit in opposition to the said application within a fortnight from date.
Both the applications, my lord.
We'll come to that. Within a fortnight from date, full stop, reply, if any, shall be filed within a week thereafter. Full stop. Next para. In such view of the matter, comma, we recall the ad interim order dated February 27, 2025, comma, since the second marriage had apparently been contracted prior to the passing of the said order. Full stop. Next para. Insofar as Can 1 of 2025 is concerned, comma, in view of the second marriage of the husband, after waiting for the limitation period for preferring an appeal from a divorce decree, comma, learned counsel for the respondent submits that the said factum ought to be considered while disposing of the condonation application as well. Push up. Next para. Accordingly, on the prayer of the respondent husband, comma, we direct the respondent husband to file an affidavit in opposition to Can 1 of 2025 as well, comma, within a fortnight from date, comma, to which a reply shall also be filed within a week thereafter. Full stop. Both the applications shall be listed together for hearing on April 16, 2025.
No, not that period. Not that period, not April 16.
April 21.
I would say keeps it 1 week because I am going to have a surgery that time, that period.
When should you keep it? Tell us.
Maybe last week of April, that will be better, and give it 3 weeks time to use 2 affidavits.
আচ্ছা তাহলে affidavit যেটা বললাম fortnight না করে দুটোতেই তাহলে 3 weeks.
The week starting with 28th of April, my lord may keep.
আর reply যেটা বললাম এক week. Both the applications shall be listed next on April 28, 2025. Affidavit of service filed to be kept on record. দু জায়গায় fortnight বলেছে অনিন্দিতা, দুটোই হবে 3 weeks. আর affidavit of service filed to be kept on record. Returnable date 28th.
Grateful to lords.
And then
অনেকদিন পরে দিয়ে সেকশন 5 কনসিডার করতে হবে। আপনার সেকশন 5 একটা রাজস্থান হাইকোর্ট আছে যে ওরকম হলে দেবো না।
My lord, I am appearing for the appellant.
Here for the respondent.
Led by Mr. Shakur.
For both the respondents?
Both the respondents.
Very good. Yes.
I have
What is the delay?
There are more than 516 days delays, and that delay occurred because of the erroneous or wrong knocking of the door of the justice. Because
the justice was wrong before whom you were knocking, or
justice, temple of justice.
The temple was wrong.
The thing is that the order was passed by the.
It was a lesser temple or some different temple. You're knocking before a district court or
district court. Junior court passed an order, and on the against
what is the decree about?
The decree was about the non-payment of the outstanding dues.
Oh, money decree.
Money decree.
Suit has been dismissed.
Suit has been dismissed. That is why I have come for the appeal.
Acha. Why is it?
You
preferred an appeal before the district court?
District court, and the district court virtually took much more time to say that the district court has got no adequate jurisdiction, pecuniary jurisdiction to entertain and try this suit.
So section 14 basically.
Section 14 basically. The principle of equity will be derived from that section only, and that is why 516 days delay and delay.
Session, what do you say about the delay?
If I get a chance, I'll file a short affidavit. Otherwise, I leave it to you, Lord.
We'll dispose of this section 5. Unnecessarily kept pending.
They had come to know on the first date of the appeal itself that it is defective. If your lordship sees the order number 1, page 20, and this is not something, my lord, a point of jurisdiction which is to be decided. I am saying that this court has no jurisdiction because it is a commercial dispute. It is not like that. It is only on the quantum of court fee, which is apparent on the face of record. So if once that has pointed out on order number 1 on 5th of December, but I could have decided to withdraw it then and there.
Thereafter,
So
kindly
the
see.
point of maintainability was fixed on a different date. So maintainability was still sub judice.
That is what I'm saying. My lord. The point of maintainability, when is it required to be adjudicated? Something contentious regarding
But
maintenance.
Mr. Sen, if the court says that it required to be heard, court fixes dates for that. Section 14
Court
comes
has
in.
given me a chance to see whether this appeal is maintainable.
Court should have dismissed it at the outset.
Or my learned friend should have said, I'm withdrawing the appeal.
Could have said, did not say, took advantage of the court's view that the maintainability should be heard. You always take advantage of our ignorances.
No.
Every day.
I leave it to your lordship.
The Can 1 of 2025 is an application for condonation of the delay of about
516 days.
516 days in preferring the appeal. Who's of learned counsel, but the appellant submits that due to a bona fide error stroke misconception, comma, the appeal was preferred before the learned district judge, whereas due to the pecuniary valuation, comma, the same ought to have been filed before this court. Who's of it is pointed out by placing reliance on the order sheet before the trial court, comma, annexed to the application, comma, that the suit was fixed for hearing on the point of maintainability on the ground of pecuniary jurisdiction for several days, and ultimately the appeal was dismissed on the ground of pecuniary jurisdiction on December 20, 2024. Push up. The appeal was prepared and filed at the earliest thereafter upon the client contacting his present advocate. Push up. Next para, learned senior counsel appearing for the respondents points out that the lack of pecuniary jurisdiction of the trial court was not something which was to be argued or to be decided upon extensive consideration of law, but manifest on the face of the records. First up, the valuation of the suit was fully known to the appellant, and the appellant also was aware from the very first date of filing of the suit that the same lacked that the district court lacked pecuniary jurisdiction in view of the valuation, but seeks to take unnecessary advantage of the delay of the learned trial judge in hearing the maintainability question. In case of such ex facie bar, comma, it is contended, comma, the court should be slow in condoning the delay. After a careful consideration of the arguments of the parties, comma, we find that although the question of pecuniary jurisdiction is manifest on the face of the valuation of the plaint, comma, in the same breath, comma, since the learned trial judge fixed the suit for hearing on the point of maintainability on several dates, comma, it cannot be brushed aside that the appellant might have an impression that the said question ought to have gone in favor of the appellant. Push up. Next para. In any event, comma, unless the learned trial judge had kept the matter for hearing on the issue of maintainability, comma, the present appeal could have been preferred earlier, comma, since in the case of a dismissal at the outset of the appeal on the ground of pecuniary jurisdiction, comma, the period lost in the trial court hearing the appeal on the ground of maintainability would not be would not take place. Push up. Next para. Thus, comma, we find that an ingredient of section 14 of the Limitation Act can be imported into the present matter in view of the matter having been fixed on several dates for hearing on the point of maintainability in the trial court. Push up. Accordingly, we extend the benefit of Article 14 of the Limitation Act, Section 14 of the Limitation Act, read with Section 5 of the same said Act, and are of the opinion that the delay in preferring the appeal ought to be condoned. Full stop. Accordingly, Can 1 of 2025 is allowed, thereby condoning the delay in preferring the appeal, which is thus deemed to stand registered and admitted. Full stop. There will be no order as to cost. Full stop. Next para. Since we have not invited affidavits on the application, comma, it is deemed that none of the allegations made in the application are admitted by the respondents. Full stop. Can 2, what appropriate order will directly put in
the respondents, they are not paying me the outstanding dues. On the contrary, they are sending so many letters asking for payment of 1 crore of rupees.
How dare they pay you the money in the teeth of the dismissal of your
That is
suit?
true. But on
That
the
would be a contempt of court.
No, no, the thing is that, my lord, the thing is that the matter is sub judice, the matter is in the trial stage.
This application deserves only one order, two orders, special messenger and paper book. Can 2 of 2025 is an application for appropriate order of stay of the judgment and decree impugned herein, full stop. Since by the impugned decree, comma, the money suit of the appellant was dismissed, comma, there is no scope of reviving the suit by staying the operation of the same. Full stop. Accordingly, can 2 of 2025 is disposed of without any order of stay, but directing the appellant, comma, in order to expedite the appeal, comma, to put in special messenger costs for bringing the trial court records within a week from date, comma, upon which the trial court records shall be brought by such mode at the earliest. Full stop. Next para, in view of the appearance of the respondents through their learned advocates, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Leave is granted to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Only that same line, was it? No affidavit is filed.
Pardon?
No affidavit is filed to the stay application, was it?
Acha, stay application after since no affidavits are invited in respect of the stay application, comma, it is deemed that none of the allegations made therein are admitted by the respondent. Full stop. প্রথম লাইনে সবকিছুর আগে affidavits of service filed today be kept on record. Delay shown given by the stamp report is less than what he explained. So anyway, উনি তো পুরোটাই explain করছেন কবে থেকে কথা.
Some better case, I think, section 14 principle can be argued on this point also.
Whether it's bona fide or not.
Yes. If the defect is apparent, then can we say that even proceeding with it is bona fide and in good faith? Because there are two expressions. One is bona fide, one in
You are right, Mr. Shane, but only in these cases we are importing only in better cases also. I mean, the same principle, because if the court actus curiae principle somewhat comes in, not actus curiae as such, actus curiae, but it's an act of court. Court fixes it for hearing maintainability.
Court is keeping it pending, but filing is my responsibility.
No, the moment the court keeps it pending for hearing on the point of maintainability, Mr. Shen, maintainability is rendered arguable by the court. Rendered arguable by the, I say that I'll hear this on maintainability. The appellant will obviously take a chance. That is the only element of bona fides which you have put in.
Yes.
Bona fides because of the act of court in proceeding with that matter.
But can we not say that even it is on I have some responsibility to discharge to the court and say that somehow I have
Then,
filed.
Mr. Shen, you should have challenged the first order fixing it for maintainability hearing on the ground that it's a deemed registration of the suit and the court should have dismissed
We
it.
were not on notice. We were never served, and it is an ex parte dismissal.
Unless that, if that order remains, subsequently also several dates were fixed. If you never take any step for stopping that,
Yes, that is true also.
or even if you don't file any order 711 application could have been filed by you when you came to know. Several other things, or 710. 710 would
to
be
go into
better.
the merits. Always.
That is why we don't. I mean,
Yes.
section 5 stage we don't.
No point in exchanging, my lord,
Unnecessary.
literature on bona fide.
Unnecessary lack of niceties between the parties.
Okay.
Yes. Yes, Mr. Arifin. Is there any junior senior to you in this matter or senior junior? Like that matter? That matter? Is that matter? No, not Mr. Vijay Kumar's matter.
But he is the advocate record, my lord. I have been engaged, my lord, over him, but he is saying me junior. In age, my lord, I am junior.
No, we understood the entire thing. What is this matter about?
But here, my lord, this is, my lord, I have filed, my lord, there are two appeal pending before your lordship, my lord. One, my lord, I filed a suit for declaration of tenancy right, my lord. And second,
That was dismissed and the counterclaim for eviction was allowed. So two appeals.
Now, my lord,
Stay application in connection with execution case.
execution case, my lord. Yes, my lord. The stay, my lord, that second.
Why two applications?
Two application because, my lord, first, my lord, first application, my lord, there was section 5, my lord, and stay application, my lord. And in that stay application, it was, my lord, for my suit for dismissal. That in that, my lord, your lordship have passed an order of stay, my lord. That was subsequently vacated by your lordship in second order, my lord, because your lordship was of the opinion that in suit for declaration, I cannot ask for a stay of execution.
We were under the impression that that appeal was against the counter claim.
My mistake, I could not point out, my lord, before you.
Stay
Second-
decree for declaration dismissed, there cannot be any stay.
My lord. Now today, my lord, before your lordship, my lord, the
Second
second appeal is also there, my lord, and stay application is also there, my lord. So I'll first take that.
There is a
application.
section 5 in the second.
No, my lord.
No section 5. So affidavits in reply filed in the first one.
First one, my lord. and
We'll
your-
treat those affidavits to be affidavits in the second one also.
That your lordship.
For
Yes,
occupation charges.
yes, my lord. Now, my lord, please take my lord, stay application, my lord, in my lord.
What is the present second appeal? 111, 111.
111 is the first one, my lord. My lord, second one is my lord, 125.
125. Second one,
125 2025.
That has become FA 21.
FA 21.
FA 21 is 291.
That is original FAT was, it was
Effective 292. It was effective 292.
292, acha.
My lord. Now, my lord,
And you will refer to the FA numbers. FA 21 is the counterclaim appeal.
Oh, my lord.
FA 20.
In a previous application for stay filed in connection with FA 111 of 2025, we had initially granted stay but subsequently vacated the same. Full stop. The context of the same is that FA 21 of 2025 has the context of the same is that a suit for declaration of tenancy rights was filed by the appellants, which was dismissed, and is the subject matter of challenge in FA 111 of 2025. Whereas a counterclaim for eviction filed by the respondent was allowed, which has been challenged by way of FA 21 of 2025. We are correct on that. Full stop. Next para. Since the initial stay order was granted in connection with FA 111 of 2025, which is against the dismissal of a declaratory suit, on the mistaken impression of the court that the same was a challenge against the counterclaim for eviction, the same was recalled, full stop. However, since an independent application for stay bearing Can 1 of 2024 has been filed in connection with FA 21 of 2025, which is the appeal against the counterclaim decree of eviction, we take up the same for hearing independently without being influenced by the recall of the stay in the earlier matter. Full stop. In view of the above circumstances, the affidavit in opposition and reply filed in connection with Can 2 of 2024 in respect of the previous appeal are treated to be affidavits in opposition and reply to the present stay application, that is Can 1 of 2024 filed in connection with FA 21 of 2025, particularly for the purpose of assessment of the occupation charges which might be imposed for grant of stay. What is the should we, Mr. Arifin, should we hear them first, because they have to show the occupation? We'll grant stay in any event, but also why should we grant stay 2G case? What is your prima facie case?
The prima facie case, my lord, kindly see their letters, my lord, in which, my lord, they have asked for vacating my tenancy, my lord. They have admitted me as a tenant, my lord.
So you have a case that they have admitted your tenants.
My case is also.
But admission against the law, that will
I
be
am
an
guided by 1956 Act, my lord.
Oh, you take that point also.
And 2G is not applicable, my lord. Here, my lord. It was 1970.
Well, arguable question. Then we'll shift to the occupation charge. Yes, Mr. Roman, what do you say regarding the occupation charge? Your affidavit first.
My lord, so far as the stay application, this appeal is concerned, my lord, there has been a delay.
Delay?
Yes.
Our key delay.
Because this appeal was filed later on, after filing the earlier appeal. Has already been
Correct.
In respect to
The delay has been condoned in respect of which one?
In respect to the first one, my lord, and there is a report, my lord, by this, my lord, department also, my lord. Kindly see, my lord, this order, my lord, of the registrar, my lord. There is a delay, my lord, in only one case, my lord. But what happened, my lord? 2 certified copy was obtained, my lord. 1 certified copy was annexed, my lord, which was, my lord, later admitted, my lord.
Mr. Arifin, this appeal itself has been filed later. Certified copy we are not bothered with.
Judgment was delivered on 15 July
But
2024.
report of the
And this appeal was filed when?
Subsequently,
July 24.
but it was filed on at the same time.
15/7/20.
But kindly see my lord, the
20th of
report the
September
registrar, my lord.
2024. Which one? That was the first one.
There was only one report of the registrar, my lord. That's all, my lord. 26.
Report of the registrar is immaterial. Even if there is no report of the registrar, if you file the appeal late, you have to give
first
extra.
one also they took out an application for condemnation of defect.
That was allowed.
And that was allowed.
My lord. But in that, my lord, the certificate copy which was obtained later, my lord, was annexed, my lord. That's why, my lord, there was delay, my lord. And in this, my lord, the first certificate copy was annexed, my lord, so there was no delay.
1 minute. Let us see the memo. We can't find the memo of the second appeal. Memo of second appeal, memo ta kothay? Se দ্বিতীয় appeal-টা? এইটা? এটা তো কেন? এইটা মেমোটা? এটা তো এফএ না, এটা এফএ। এটা এফএটি 291 এর। 291 was the previous one.
Previous one.
না, এটা অন্যটা। তাহলে এটা কি এখানে পাবো? হ্যাঁ। আচ্ছা, থ্যাংক ইউ। ঠিক আছে, এটা এক্ষুনি।
21.
Or kindly see the certificate copy, my lord. It was within 30 days.
না দিলে বলেনি, কিন্তু আমাদের তো দেখতে হবে এই অ্যাপিলটা ফাইল হয়েছে কবে দেখিনি। ফাইল হয়েছে 13/9/24-এ। দেখি কবে অ্যাপ্লাই করেছে, দিন টাইম কিনা এই সার্টিফিকেট কপি। 15/7 ও অ্যাপ্লাই করলো হচ্ছে 20/7-এ, 5 দিন ওখানে গেল। No, regarding this certified copy, 15th July the order judgment was passed. He applied on 20th of July. So lost 5 days there. Ultimately, requisites informed and deposited in time. Ultimately, it was made ready on 20th of August 2024, and they filed it on 20th of September 2024. So therefore, there is no delay. So then, please come to your opposition.
My lord,
Opposition charge.
Gateway, my lord.
Because we are treating the other opposition as this opposition.
My lord, straightway kindly come to the charter engineer's report. That is at annexure. That is at page 16. The relevant paragraph, relevant page is, my lord, which the calculation was made. That is at page 19. Total area is 351 square feet. The market rental value is rupees 8,775 per month. And it has been also assessed that per square feet the rental is rupees 20.
So what would be the total? It would be
per month.
Per month?
That is 8,775 per month.
Is it facing the main road or inside?
Is it not facing the
Kindly see, my lord, there.
Let us see the schedule.
Well, kindly have look to the schedule.
It will, my lord, page 18, my lord, you also can find, my
You
lord.
will see from the decree.
2 rooms in the ground floor of the
My lord, that
premises.
is also mentioned in the report.
But
No,
report
we'll
does not
take a look at
consider, my lord, the room, my lord, they have not inspected the
My lord,
room, the
my lord,
condition of
it
the
has been
room.
let out for commercial purpose.
My lord,
They are using it for
The
commercial
model picture
purpose.
has been changed, partly commercial and partly residential.
They are using it partly commercial, partly
But initially it was let out, it was leased
commercial.
out.
Commercial. We'll see partly passage.
my lord,
On the
in my
south, there is a road. On the south, 5/1 Horoprasad Day Lane. 2 rooms on ground floor. Ground floor, on one side, there is a lane.
One side there is lane, my lord, and my lord, it's not a very wide lane, my lord. Nothing can come on in, my lord. I have also annexed photograph of the condition of the room, my lord. You'll also will find, and I have also annexed, my lord, the rent which is going on in that area in my reply, my lord. You'll also will kindly consider that also, because their report, my lord, does not consider any rent, my lord, of that area. First and second, my lord, they have just calculated the value. Today, what is the value?
No,
my
they
lord?
have also annexed another lease deed. What about the other lease deed? You have annexed a lease deed?
No, no,
This is your lease deed.
It was for a period of 5 years, subsequently.
That is different, yes.
Now, my lord, kindly consider my reply, my lord.
Here you,
If I
your
give-
lordship will.
Let them finish, Mr. Arifin. Yes.
The schedule of that lease deed.
It's posta, it's 351 square feet, fully commercial area.
Yes.
So 8775. Square feet per square feet, rupees 25. Let us hear him now. Yes, Mr. Arifin.
But if your
What have
lordship
you annexed to your reply?
consider my reply, my lord. First, my lord, kindly come to page 8, my lord. Page 7 and 8, my lord. It's, my lord, the rent receipt, my lord, of the adjoining area, my lord. My lord, here, my lord, that today's sale, my lord, is 1,672, one, my lord, and another, my lord, is, my lord, 2,000, my lord. My lord, kindly see the
When
address.
we don't know when these rents leases were given.
My lord.
Might have been given 10 years back. Which rent is carrying on?
But my lord,
The test
the
is
rent which
what
going
would they
on now, my
be able to fetch if they let out today
My lord.
to new tenants.
Now,
That is
kindly
the test.
consider the situation of that area, my lord, of the premises, my lord. Next page, page 9. This is the lane by which they were showing, my lord. Page 9. This is the gate, my lord, and your lordship sees this is the entry. Kindly see the condition of the premises, my lord. And next page, my lord, your lordship will find, my lord, the room. And page
That is
10.
why, my lord, the
All
rental
dilapidated and broken, my lord.
less.
And my lord, this is the condition, my lord.
It can be used as a go down. What are you using it for? What commercial purpose?
Partly commercial, partly.
What is the commercial part? What are you doing there?
That I have to take instance.
Must be go down, posta.
Go down, man.
Posta go down.
My lord, residential also, my lord.
Yes, yes.
Partly residential. You are asking about the commercial part. What is the commerce you are doing there?
Maybe the go down, my lord, but I have to take
Go down does not require a well furnished marble floored room.
Kindly consider
Rather, that would be counterproductive. One would hesitate to use that as a go down.
No, my lord, what they are asking, my lord, by this valuation report, my lord, what would be the
If they let
market
it out
value?
at present 351 square feet in posta,
My lord, it's
this
not
is a
posta, my
fair
lord,
assessment. Rupees 25 per square feet.
but inside
No,
the
your
lane, my lord,
lordship,
it's
though
but
the
not
posta,
posta, my
it
lord.
is commercial.
Near posta, my lord, but inside the lane, my lord.
They are posta.
But the police station is, I suppose, my lord, is
Golabari.
No,
No, not Golabari. Sorry.
no. That is their
Golabari is there.
my lord.
Police station.
Of the appellant.
And the police station is posta, my lord. But my lord, this is my lord, as 6A Haraprasad, the lane, my lord. It's not my lord in my lord, main posta.
There is no posta lane. There are different names of the lanes. Haraprasad there or what? Posta entirely is comprised of lanes only.
But kindly consider the
Posta, the main road has also become a lane.
Absolutely.
but kindly make a balance ballot, but consider the condition ballot and
No,
also-
8 say
decide
not
what-
8,000 say
whatever you
we'll
say, I have
we'll
to-
deduct 775 8,000 pay.
8,000 is my lord.
Posta area no.
My lord, maybe my lord, maybe 5,000. My lord, if
No.
my lord, I'll give to you lost, but my lord, kindly consider.
What were you paying previously?
My lord, 400 something. My lord.
Compensate that.
448.
No. 8,000 is moderately all right. Third learned counsel for the parties, push up next para. The respondent relies on the valuer's report annexed to the affidavit in opposition, which has taken into account the location of the premises which is situated in the posta area and is commercially viable. First up, next para. The valuer's report also considers the age of the building, which is about 100 years old, and has considered such age in assessing the market rent which can be fetched for the property, comma, upon allowing for depreciation. Push up next para. Upon such calculation, comma, rupees 25 per square feet has been assessed to be the market rent which can be obtained for the said premises at the present day. Full stop, multiplying the same by the area of 351 square feet of the suite room, comma, which is at present being partially used commercially and partially for residence by the appellants, comma, a monthly rent of about rupees 8,775 has been arrived at by the valuer. Which of next para, learned counsel for the appellant places reliance on the photographs annexed to the reply to argue that the condition of the premises is not very sound, puts up that apart, comma, certain rent receipts of adjoining premises have been also annexed to argue that the rent in the area at present is much less than that claimed by the respondent. Push up next para. However, comma, we are unable to come to a finding as to when the tenancies in respect of which rent receipts are produced by the appellant were given for the first time to the respective tenants. Pushed up next para. Thus, comma, we cannot take such rent receipts as a sacrosanct premise for assessing the current market rent which can be fetched from the premises, comma, which is the yardstick for consideration of imposition of occupation charges. Post up from the photographs as well, comma, we find that although the building is otherwise old and there are certain rubble accumulated in one of the portions thereof, comma, we do not find that the rest of the building is in such a decrepit condition that the same cannot be let out to third persons at the present juncture. Furthermore, comma, some of the photographs show that renovation work is going on and midway in a major portion of the building. Full stop. The said renovation might be the reason of the accumulation of rubble as well. Full stop. Be that as it may, comma, we are of the opinion that a moderately fair assessment is evinced by the report of the valuer as annexed to the affidavit in opposition, and are of the opinion that an amount of rupees 8,000 per month would be a moderately accurate estimate of the current market rent which the premises can fetch at the present juncture. Full stop. Accordingly, can one of 2024 filed in connection with FA 21 of 2025 is allowed, is disposed of by granting stay of operation of the impugned judgment and decree and stay of proceedings in any
judgment and decree, no,
oh sorry
proceeding.
There will be granting stay of all further proceedings in what is the number, please? It has been given in the application.
Yes, yes. Correct, has been. 1 minute. It would be, my lord. My lord, execution case number 113 of 2024.
Stay of all further proceedings in title execution.
Title execution case number 113 of 2024 pending before the learned 12 Plaint City Civil Court.
Pending before the landed register, City Civil Court.
Pending in the City Civil Court at Calcutta. Numberটা পেয়েছেন তো? Pending in the City Civil Court at Calcutta till disposal of the appeal, comma, subject to the appellants paying occupation charges at the rate of rupees 8,000 per month to the respondent. You furnish a bank account?
Bank account. No,
Directly we will put my lord through my lord.
Bank account number to detail.
Ask your client if somebody is present. If there's a bank account, we'll direct online transfer. That will save you from further allegations later on. Unnecessary allegations. You know, you're an experienced person.
But we will convene for us also, my lord.
Bank account number. Yes.
Particulars are there. Give it to him, not to us.
Okay.
To them, to Mr. Arafini. By online bank transfer at the bank account, comma, particulars of which are furnished by learned advocate for the respondent to the learned advocate for the appellants here and now. Full stop. Next para. The said amount shall be payable, said occupation charges shall be payable from the date of the impugned decree, from the month of the impugned decree. Full stop. The first of the current installments, comma, for the month of March 2025 shall be paid by March 31, 2025. Full stop. Thereafter, comma, for each month, comma, the current occupation charges shall be paid by the last day of each of the succeeding months. Full stop. Next para. Insofar as the arrears are concerned, comma, the same shall be paid by the self-same mode at the rate of rupees 8,000 per month by 3 equal monthly installments, comma, the first of which shall be payable by March 31, 2025, and thereafter by the last day of each of the succeeding months. Full stop. The said arrears shall be calculated from the date of the impugned decree up to the month of February 2025. In default of any of such payments, either current or arrear, the stay order granted above shall stand automatically vacated without further reference to the court.
For the paper books and other.
We'll direct them. The appellant, in view of the appearance of the respondent through their learned advocate, service of notice of the appeals is dispensed with. Full stop. Next para, the trial court record shall be called for by special messenger at the cost of the appellant, to be deposited within a week from date. Full stop. Next para, the appellant shall prepare and file the requisite number of composite paper books in respect of both the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. The appeals shall thereafter be heard analogously. Full stop. Liberty is granted to the parties to mention the appeals for such hearing as and when the same is ready for hearing.
But only one payment. Instead of 3 installment, may it be 5 installment ballot.
My lord, Mr. Shamol Chakraborty shall appear in this matter, my lord, on behalf of respondent, but my lord, he undergone eye surgery on Saturday.
Oh.
My lord, I am praying for some time. my
Actually, you have not yet put in the Taliban and written up notice forms. No, they won't know. Oh, he's your clerk. They will. Has not been put in. Otherwise, you would have said yes immediately. Do that within a week. What is the application for?
Application, my lord, is for stay, my lord. Decree for eviction, my lord, passed. And, my lord, I have been asked to evict, my lord. There were rival disputes, my lord, with regard to the title of the property, my lord. They say, my lord, that they are Thika tenants and land, my lord, vested in the state. My lord, I say, my lord, that I have some other landlord, my lord, who has inducted me into the property. My lord, my first point, my lord, if there is rival dispute, my lord, with
No, you have been evicted on the ground that you are a trespasser.
Thika land, my lord, I am a trespasser, my lord. Perhaps, my lord, the court, my lord, civil court did not have jurisdiction, my lord, because now after 2001.
No, there was no dispute regarding whether the land is a Thika property. If there was a dispute regarding that, it would be heard by the controller. And Bharatia also, yes, by the controller.
Yes.
But if you are evicted on the ground of trespasser, those are not applicable. So you don't have a point in the appeal. Where is the prima facie
No,
case?
my lord, I'll say, my lord, there is a dispute, Thika land or not, because I say, my lord, that I came under, my lord, a trust, an estate. And this was not a Thika property. This trust is the owner who has, my lord, put me in
All right.
possession.
So you have not admitted that it's a Thika tenancy.
No.
You have disputed in your written statement.
Yes.
This is an arguable question.
And in fact, my lord, this Thika tenancy point, it came, my lord, in their written statement. The plaint was to my counterclaim. Initially, when the plaint
1 minute. You have filed a suit for declaration of title.
in my counterclaim, yes.
Counterclaim.
Counterclaim. And it is their suit.
Declaration of tenancy counterclaim.
Yes, yes.
That has been dismissed.
Yes.
One appeal only.
One appeal only.
Then automatically they get a decree in the counterclaim. The appeal is against what? The counterclaim.
The appeal is, my lord, both.
No, cannot be. Counterclaim is a separate decree for all practices.
Counterclaim, I have not been able to prove anything, which is why.
When a counterclaim is a decree is passed in a counterclaim and a suit, they are treated to be separate decrees passed in separate suits. Counterclaim, has the status of a suit.
Yes.
So unless you challenge the declaration, then as of today, there is no appeal that decree attains finality, that you are not a tenant. If that be so, then they automatically get this decree in the, you have to prefer an appeal against that also.
Counterclaim also.
Absolutely. Otherwise, if that counterclaim remains, file an appeal and come back.
Yes.
Well, in the meantime, my lord, liberty may be given to file opposition with respect to stay application.
Then, my lord,
We'll grant an ad interim stay, but file an opposition for occupation charges.
File any execution proceeding, my lord, till date against the said judgment.
Even then,
No, some.
But unless you file that appeal, you don't have a prima facie case.
Not so that if
We'll put it on your mouth. We'll say that you pray and we grant you the leave to file a separate appeal against the declaration.
I'll
File it immediately. If there's a delay, we won't advise you further. We'll charge after this. So you do whatever you have to do. Come back. We'll keep it. Mr. Chakraborty's eye surgery saves you. So for 2 weeks we are granting you time
Yes, and
for his eye surgery. And adjournment is sought on the ground of the learned advocate appearing for the respondent having undergone an eye surgery, whose accordingly the matter is adjourned till March 24, 2025. Whose next para, it transpires from the records that the present appeal has been preferred, that only a single appeal has been preferred, although there are 2 decrees, one passed in the suit for declaration of tenancy rights filed by the appellant, which was dismissed on contest, and the other being a decree of eviction passed in the counterclaim against the appellant. Full stop. It is well settled that a counterclaim, for all practical purposes, has the status of a separate suit, and a decree passed therein is also a decree equivalent to a decree passed in a suit. Full stop. Next para. In the event the dismissal of the main suit remains, the plinth of the appellant's case of tenancy in respect of the property goes. Full stop. As such, on the prayer of learned counsel for the appellant, leave is granted to the appellant to file a separate appeal and to elect as to which of the appeals have been filed against which of the decrees, being the decree passed in the counterclaim and that in the suit. Full stop. This much. This much. You have to elect on the next occasion. You are challenging which in
Yes.
which one is against the counterclaim and which one is against the, obviously, because this is against a you have filed a stay application, this is against the counterclaim. Because in the counterclaim, the eviction degree. We'll record your submission on that. This is an appeal against the counterclaim. We'll record that submission. So next para. At this juncture, learned counsel for the appellant submits that since an application for stay has been filed in respect of the decree, the present appeal may be treated to be an appeal against the decree of eviction passed in the counterclaim. Full stop. Accordingly, we deem it to be so. Full stop. The fresh appeal which is to be filed by the appellant, if at all, shall be against the decree of dismissal of the suit of the appellant.
Liberty with respect to my opposition, my lord.
Very well.
No, then, my lord, in
No,
that
liberty against opposition, we are granting you time because of his eye surgery, and how can?
Yes.
Then you would have to grant ad interim stay. We are not granting that.
100.
Instead of direction was called for direction. That has been done.
Right. What is the application for?
Basically, the plaint of the petitioner was plaint was rejected for non-deposit of court fees at argument stage.
Yes, but a stay would mean revival of the suit. That cannot be granted. So we'll dispose of the stay application without granting any stay, directly passing the usual directions you put in the requisition. Since the present appeal arises out of a rejection of plaint, comma, in the event a stay is granted, comma, the same would have the effect of reviving the suit, which would tantamount to allowing the appeal before being heard on merits. Full stop. Accordingly, we are not inclined to grant stay. Full stop. Can 1 of 2024 is dismissed. Full stop. However, comma, the appellant is directed to put in postal costs and other requisites for service of notice of appeal on the respondents. Full stop. The trial court records be called for by special messenger at the cost of the appellant, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. A matter disposed of, very well. Dismissed ko na kore disposed of. Disposed of without any court.
September 1, place fixed for court fees by the plaintiff and ex parte judge. Matter was fixed for judgment. There was a direction upon the petitioner plaintiff to deposit the deficit court fee.
Plaint is rejected. Therefore, it's a decree, deemed decree. If the other side appears, I mean, when they get notice, I mean, we can, if you agree to put in the requisites, you can dispose of the appeal itself. But since they are not appearing now, therefore, it's difficult now. Oh, then it's difficult. We have to hear the appeal. Maybe we'll allow it ultimately. Whenever the appeal is ready, mention. Yes, call.
24, madam, for the appellant, madam. As per your lordship's direction, madam, I'll sub copy, madam, to the both respondents and madam, the advocate of the lower court.
You can dispose of the appeal itself.
In this matter, my lord, one predicament is there, my lord. I have been told to appear in this matter, but my lord, it was dispatched on Friday by the from Malda, my lord. It has not reached to the.
There is no.
It has not reached. The papers has not reached, Lord, till now.
We'll keep it the day after tomorrow. You give the papers to him.
In the meantime, my lord,
only section 5 has been rejected. That's why both of you, I mean, ultimately it will, after 10 years, we'll allow the section.
My lord, we'll keep it.
We are keeping it as it is. We'll just postpone it till day after tomorrow. We'll request him to give. Affidavit of service filed to be kept on record, which indicates good service having been effected on the respondents. Full stop. However, comma, learned counsel having instruction to appear for the respondent submits that he is not equipped with all the papers which have not yet reached him from Malda. Full stop. Learned counsel for the appellants is requested to hand over his further copies of the relevant documents to his counterpart for the respondents. Full stop. Let the matter stand postponed till March 12, 2025.
Item 25 to 28, my lord, I have served. But this is in respect of, my lord, may my lord.
Or both the respondents?
Both the respondents.
The affidavits of service in all the matters, my lord. This arises, my lord, out of an ex parte ad interim order. Subsequently, my lord, that has been extended. That's why the subsequent memos of appeal have been filed, my lord, against the.
What is the main first order? Which appeal?
First order is item 25. My lord, there is a section
FMT
5.
number 49.
FMT number 49, my lord. There is a section 5, my lord, which is where the delays in respect of the first appeal.
What is the section? Can 1?
Can, my lord, can 2. Can 2 is a section. Can 1 is a stay petition. First, my lord, in respect of the 3 appeals, there are section 5 applications. The last appeal, my lord, there is no section 5 because that was within time.
Can 2 টা কোথায়? Can 2 গুলো stay application তো can 1 এটা। আমি দেখে নিচ্ছি। এটা তো মেমো। এটা can. The delay is of about?
Well, the delay is about
121 days.
21.
121.
121 days.
The reason?
Well, the reason being, my lord,
Reason is not expressed in the application.
but it's my application. My lord. Initially, my lord, it was on the last day of before the puja vacations. Thereafter, my lord, once it came, but it was served, my lord, then the learned advocate, my lord, was dealing with the matter, had advised to file a Order 7 Rule 10. Now, Order 7 Rule 10 was filed. Thereafter, my lord, nothing was happening, and then it was
Order 7 Rule 10, why?
for return of plaint on the ground of pecuniary jurisdiction. I'm not going into the merits of whether at all the Order 7 Rule 10 could have been filed at that stage, because the reason being the sale agreement is of set down value of 1 crore 30
So
lakhs.
what is the impugned order?
Impugned order, my lord, is restraining, my lord, creating any third party interest in respect of the flat in question.
Achha.
Then, my lord, and then nothing was happening. The learned judge was in charge of the matter, my lord. The learned judge retired. So, and the charge benches were there, were not taking up the matter, and it was being extended mechanically. In fact, the plaintiff himself was applying for adjournment along with an extension petition. Usual that what happens once an ex parte ad interim order is obtained. So, my lord, it was subsequently, my lord, another advocate, my lord, advised, my lord, to challenge the order and also the extension orders. My lord, this is, my lord, because, my lord, written objection I have already filed. This is in respect of an ex parte ad interim order. The suit is, my lord, by way of the plaintiff, where plaintiff has sought for a declaration.
No, first let us deal with the section. Yes, what do you say? Section. Some explanation has been given because they're not advice initial.
Thing is there, my lord. Let me file an affidavit, my lord, affidavit in opposition regarding that. Because just because advice of an advocate is not a ground of delay, my lord.
Why not? You won't be able to improve anything by filing affidavit in opposition, because you won't be having direct knowledge on whether that advice was given. On facts, you cannot have anything to say. On law, you argue right now, we are hearing you. You say there is no sufficient ground explained.
Except advice of an advocate.
You had filed 711.
7, yes.
7 order 7 to 10.
Or 710, yes. 710 file, my lord, paragraph 9 on.
One of the grounds is that they had taken out a 710. They were under the impression that that would be heard out first. So that is a valid ground. That was never heard out. And we will condemn it. Learned counsel for the respondents seeks to use an affidavit in opposition, puts up, however, comma, upon ascertainment as to the scope of filing such opposition, comma, we find that there is no scope of factual denial of the averments, comma, since the respondents could not have knowledge regarding the goings on between the appellants and their learned advocates. Puts up, as to the rest of the paragraphs in the condonation of delay application, comma, those are matters of record and no affidavit is required to be filed. Puts up, however, comma, we deem that none of the allegations made in the application for condonation of delay are admitted by the appellant respondents. Puts up, next para, the ground for the delay has been indicated to be firstly that the appellant was initially advised, comma, after passing of the ad interim injunction, refusal of ad interim order.
Passing of an ex parte.
After passing of the impugned ad interim ex parte injunction, comma, to file an application under Order 7 Rule 10 of the Code of Civil Procedure, which was duly filed, which of the appellants were under the impression that the same would be heard out, and as such, comma, there would be no occasion to challenge the ad interim order, which was subsequently, comma, upon the said application being kept pending and extensions having been granted in respect of the original ex parte order of injunction, comma, the present appeal was decided to be preferred. Which of appeals have been preferred. FMAT 49 of 2025 is the appeal against the original ex parte ad interim order of injunction, whereas the rest of the appeals arise out of subsequent extensions of the same. Push up, upon hearing learned counsel for the parties and perusal of the averments made herein, comma, we are of the opinion that satisfactory explanation for the delay has been given in the application. Push up, moreover, comma, we cannot attribute any malafidis on the appellants, comma, since it is the appellants who would be the losers in the event the appeal was filed belatedly. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby condoning the delay in filing FMAT 49 of 2025. No condonation application in the others.
Well, in the second and the third appeal, there are two condonation applications.
So,
Both are can 1 in respect to item 26.
FMAT numbers are 50 and
51.
Full stop. Next para. Insofar as can 1 of 2025, both are can 1 in those.
Both are can.
Can 1 of 2025 filed in connection with FMAT 50 of 2025, as well as can 1 of 2025 in respect of FMAT 51 of 2025, comma, those are also applications for condonation of delay on grounds similar to that which has already been allowed. So accordingly, comma, by the same logic, comma, the said applications are hereby allowed, comma, thereby condoning the delay in preferring FMAT 50 of 2025 and FMAT 51 of 2025. Full stop. Next para, the FMAT 49 of 2025 is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Now make out your case, because if it's a short matter, we can decide by recording that because stay application need not be heard if you are satisfied. Either way, that should not be allowed. Or can we record that we are taking up the appeal itself with consent of both parties? We are doing that. In view of the short conspectus of the appeal, comma, as per our previous intention, comma, we take up the appeal for hearing along with the connected stay application. Push up in view of certain factual and legal questions being involved, comma, FMAT 49 of 2025 is now all the above appeals are admitted for being heard on the grounds taken in the memorandum of appeal. What is your case? What was the
suit filed by the plaintiff?
Please take your seat. We'll hear you on merits. You have annexed the injunction application and plaint must.
Yes, I have. Suit, my lord, filed by the plaintiff on the ground seeking declaration that he's entitled to purchase the flat. Plaintiff,
no specific performance.
No prayer for specific performance, and an injunction in respect of not to deal with the property. Perpetual declaration that he is entitled to purchase the flat.
Show us the reliefs.
Yes.
Plaint.
My lord, the plaint is at page 31. And my lord, I'll take your lordship straight to the press. Page 39 is the press.
So section 34 bar.
Section 34 bar.
When was the agreement entered into?
The registered agreement was entered into on 2nd of June 2023, agreement for sale. The total value of the flat is 1 crore 34 lakhs. The plaintiff admittedly has paid 42 lakhs. The plaintiff specific case in the plaint, he does not have the confidence to pay the balance amount.
What was that?
Paragraph 13. Paragraph 13. That the defendant 1 and 2, after availing the aforesaid advance payment for consideration of purchasing the said flat, deliberate to complete the construction within specific period, the dues which is very much shown from the facts mentioned here in above in preceding paragraphs. And as such, there is due and owing by defendants hearing neglecting attitude. The plaintiffs are not having faith to pay the remaining amount of the totaling a sum of rupees 1 crore 34 lakhs 57,000. So a party, a purchaser, intending purchaser, who's admits that the
take a seat. 2 grounds. 1, 34, section 34 specifically effect proviso. You must be aware of what will be asking. You are obviously aware. 2, in the absence of such a decree, such a prayer for specific performance, and in view of your averment that you don't have faith to pay the money, how can you say that you are ready and willing? And if you are not ready and willing, suppose you have a declaration that you have a right to purchase the suit property, but don't file a specific relief. They cannot be infinitely hauled up, restrained from dealing with the property.
No, I am playing for 1 day accommodation, my lord. I have to take
No, we'll dispose of, we'll set aside that interim injunction. We'll grant you to again seek afresh the same injunction application, provided you add a relief of specific performance. And the necessary.
One day
Also, there is an
only one day
arbitration clause in the agreement.
Yeah, you don't have a section 8.
I don't have not filed a section 8, but
So
there is an arbitration.
it can be waived.
That can be that, yes. That
only one day accommodation. my
For
lord.
what?
I have to take instruction.
No, we are not asking for your concession. We'll set aside the order and grant you leave to incorporate the appropriate prayer, and also you take care of your para 13. You are wanting 1 day stay accommodation for what? Engaging a senior?
My lord. Or to consult with the lower court advocate. My lord. Kindly give me
Don't
one day.
consult with the lower court. You'll never get advice that withdraw the appeal. Yes, send the matter to you. We'll pass an order of court.
Right.
The present appeal is directed against
Just
an
for one day accommodation. Just
no,
one
no,
day, my
no.
lord.
After the hearing, no. We gave you the option. The present appeal, it has FMAT 49 of 2025. The present appeal is directed against an ex parte grant of ad interim injunction restraining the defendants from selling, conveying or dealing with the suit property in favor of third parties and from now, full stop. Next para, learned counsel for the appellants argues that the suit is palpably barred by the proviso to section 34 of the Specific Relief Act in view of a declaration being sought for the suit property, a declaration being sought regarding the purported right of the plaintiff to purchase the suit property in the absence of any relief of specific performance of such registered agreement for sale. Who sub next para, secondly, in paragraph 13 of the plaint, the plaintiffs have alleged that they are not having faith to pay the remaining amount, which might hit at the readiness and willingness of the plaintiffs to have a decree for specific performance. Full stop. Next para. Upon hearing learned counsel for the parties, we find that the suit, in its present form, is prima facie barred by the proviso to section 34 of the Specific Relief Act, since in the absence of any prayer for specific performance of the contract between the parties, the mere declaratory suit would not be an efficacious relief. Full stop. Next para. Moreover, in view of the statement that the plaintiffs does not have faith to pay the remaining amount made in paragraph 13 of the plaint, for whatever reason, it is somewhat doubtful as to whether the suit for declaration or specific performance in respect of the contract is hit by the absence of readiness and willingness of the plaintiffs to have a decree either for declaration or for specific performance. Whose of next para, thus, the impugned order is vitiated, in view of the learned trial judge having failed to advert to the lack of prima facie case to get an injunction order. Whose of, since the self-same order has been extended mechanically by the subsequent orders, which are in challenge in the rest of the appeals, the same logic applies to the other appeals as well. Full stop. Accordingly, FMAT 49 of 2025 বলে সবকটার নাম্বার পরপর দেবে are allowed on contest, thereby setting aside the orders impugned therein. Full stop. Next para, the connected applications are also disposed of accordingly. Full stop. Next para. However, nothing in this order shall preclude the appellants, the plaintiffs to seek an amendment of the plaint to incorporate the relief of specific performance, and with regard to the readiness and willingness to have the agreement performed between the parties. If such an amendment is made and disposed of favorably, it will be open to the appellants to renew their prayer for injunction, without being debarred in any manner from doing so due to any of the observations made herein. Full stop. In the event such fresh application is made upon the amendment applications being allowed, if at all, the learned trial judge shall independently decide such application without being prejudiced by any of the observations made herein unnecessarily. No arrest to cause urgency.
Grateful, my lord.
Go and file an application for amendment tomorrow. Further relief চাইনি essential before provision.
Is that matter your lordship's past limited?
Given opportunity, liberty to file a supplementary availability.
No, 1 minute. You have changed the amendment, the preamble.
Injunction application behind.
No, not that. There was a direction to correct the preamble. The name of the judge has to be incorporated. Can you do that today? Can you know the name of the judge, second bench?
That has been incorporated.
In the memorandum, it is not there. You know the name.
Yes.
Can you do it during the course of the day?
Yes.
We are granting you the leave. Do that, and we'll take up the matter. You are ready in the matter, other way.
I am almost ready, but I want senior Mr. Alok Kumar Ghosh is actually my leader. I can actually do that.
You are sufficient.
Lordship.
But on the prayer of learned counsel for the appellant, leave is granted. Appellants, leave is granted to the learned advocate on record for the appellants to. একটা কবিতা করেছে, আপনার কবিতা করেছে। Leave is granted to the learned advocate on record for the appellants to incorporate the necessary amendment, inserting the name of the learned trial judge in the first copy of the memorandum of appeal during the course of the day. You have done it in one. In the first copy, in the memorandum of appeal. No, you have inserted it in a wrong place. I mean, here you have to do it. Preamble. You have done it in the caption. Yes, what is the matter about? FMAT against what?
I am a lessee of the Tulop complex running at 106 Bikebal Avenue.
Corporation is the lessor.
Yes, respondent, corporation.
It's a license, not a lease.
No, license.
License has to be a license. Shulab you cannot have possession of the premises exclusively.
That process was initiated once, my lord. You are given the charge of the particular pay and use toilet to collect and the corporations to pay the certain amount.
Not paying you.
Not that, my lord, for a limited period. Now, my lord, what the years, my lord, it has not continued. Then the steps had been taken by the corporation, my lord, to initiate the process, my lord, tender process, my lord, in which, my lord, all the parties who are.
Let them move their application. It's their appeal. Yes. Yes.
The page 21, I paid 15,000 rupees for the year 2023. My lord, therefore, yes, paid the ad hoc basis of the sanctioning licensee, and on the basis of that, I running the said.
But don't you have to pay monthly, whatever you earn from there, some percentage? Yearly?
Yearly.
Quarterly or what?
Quarterly 8,000.
Where do we get that? Quarterly 8,000? Where is the contract?
There is no contract, my lord. That is the on the basis of a direction given by the mayor.
Where is that?
My lord, that is page 21. Operation in pay and use toilet in front of 106 Bikepal Avenue. So the approved by the honorable mayor, dated 15.
Page 21.
Page 21 of the stay application.
Injunction application.
Injunction application.
Can 1.
Can 1.
Page 21 is the caption and this letter, first page of the letter.
But the annexer D.
This is P5. Page 18 in our copy. Security deposit.
Security deposit.
Page 18 আমাদের এখানে. It was annexure D to probably your trial code application, but it's not annexure D here.
Page 18, my lord.
Security deposit, yes.
Yes, but operation to pay and use toilet in front of 106 Bikepal Avenue, approved by the honorable mayor, dated 15 June 2017.
That is subject to their will. I mean, that can be terminated at will. No period is fixed.
That may be terminated, but that no letter has been issued for termination.
No further payment was required. Where is the further direction to pay 8,000? Where do we get that?
There is no further.
You are continuing, that certificate is there in the next page.
Yes.
You yourself said 8,000 is to be, was decided by the mayor.
মানে যেটা থেকে 18/7/2000
Where is that annexed?
page 20
Not ready with your
page
man.
19.
Your page 19 must be something else.
The agencies continue
Yes, our page 17. Yes. Your offer, you are ready to pay 15,000 and royalty of 8,000.
Yes.
You say as required by you.
This is
That
the
was accepted by them. Well, so what is the your suit?
my suit.
You sought injunction regarding what?
Not to dispossess forcefully without due process of law. This is the only my prayer.
Why refused? Let us see the reason.
And
No document showing that you are granted license.
no,
That is the second last paragraph of the first page of the impugn order. There is the first line of the trial court's judgment ratio.
yes. But the previous paragraph, plaintiff has submitted copy of the letter requested dated to 27th December 2016 and 21st May 2017, receipt of the security deposit and receipt showing payment of royalty up to the first quarter 2023. Apparently, no payment of made after the first quarter 2023. Injunction is an equitable relief. It is well settled maximum of the equity.
Why didn't you pay after the first quarter?
Next, the corporation did not receive any amount from me.
You have to pay for them to receive.
But
Shows that you have tendered.
I am ready to pay, but they refuse to accept.
What would be the amount according to you?
But quarterly 8,000.
Quarterly, you have not mentioned in your letter.
15,000 per year. Page.
Our page 17, your page 19 says you say that you are ready to pay 15 as security and royalty of 8,000 as required by you. Where is the requirement? As required by you means? Where do they agree? We don't see any letter from the corporation to you. Page 16, there is something. Sanction. Certificate of enlistment, that is different. Your society has been sanctioned. We don't see any license agreement either, like the trial court.
Yes. The license agreement under custody.
8,000, we are not getting anything that they fixed.
Yes. But the license agreement is under custody of the corporation, not above.
You must know what you have to pay.
Yes, 8,000 for quarterly.
License agreement, you don't have a copy of the license. Incredible. You are the licensee, you won't have a copy of the license. Not possible. One copy has to be with you. We don't know the terms of your license and then you cannot seek an injunction on that premise without any document, without anything. You are ready to pay till date.
Yes.
Let us hear them. Yes, Mr.
A tender procedure was initiated. He has suppressed that fact, my lord, before the Honorable Landers court below and also before this court. He participated in that tender process. The tender process was initiated for granting the permission to run the pay and use for a limited period. He participated, his bid was not accepted. Then another person, my lord, was selected as the bid was accepted and he was, my lord, given the work order. But he is not leaving that place, my lord, so that he cannot, my lord, come into that place. And therefore, my lord, we also issued a notice to the police so that, my lord, the person to whom the order has been given can, my lord, take over the control of the particular pay and use toilet.
Achha, page 18, Mr. Ghosh, how do you deal with this? A security deposit has been received by you for operation of pay and use toilet. What about this? It's your record.
2017, my lord, he paid it. He was there. He continued. But the thing is this, my lord, we used to give it, my lord, by issuing a tender process. That tender
Have you got a copy of the tender or something? Or the contract entered into? We want to see a copy of the contract.
My lord, here is 2 copies, my lord, of that regarding instruction. Your lordship, page 12 is the H1, H2, H3. Petitioner before your lordship is H3. Page 4.
No, that is in the new contract. But in the previous, he was permitted previously. How do you know that what was the agreement with him?
But this fact, my lord, he ought to have said, my lord, he participated in the tender. And but he could not succeed in this particular tender.
But this is
fact
a
not
new
before the court.
this is a new fact, Mr. Ghosh. This was not the ground on which it has been dismissed.
No, he did not come with this fact, my lord, before the landed court below, and also before this court, that he participated tender process they initiated.
But the ad interim injunction is granted or refused on the basis of the plaint prayers and injunction application in the absence of anything on your part. Your pleadings are not on record as yet.
না মানে এই
Ad interim stage you are not there.
But yeah, I understand.
Yes, ex parte ad interim injunction, the test is, Mr. Ghosh, you know, that the whatever is there in the injunction has to be taken as sacrosanct.
But the thing is, this,
So
my lord,
as per them, they are now in continuation of that.
they are continuation, but my lord,
And their injunction is without due process of law. If this is due process of law,
without due process of law is all right. But the thing is, my lord, he come to the losses court, my lord, without I have taken, my lord, due process of law. But I have, my lord, granted someone.
they are wanting only that. So we'll grant injunction. You cannot do it in due process of law. You will record your arguments, Mr. Ghosh.
And also, my lord, we have issued also the police, my lord, to take steps, because if,
That-
if
that-
a
that-
valid order is passed by us, the police is to execute that order in terms of our direction.
That you cannot oust them without due by police.
So that is the law. That is the law. Due process, my lord, under the Kolkata Municipal Corporation Act, any lawful order to be executed by the police.
What
If
is the
I
lawful
act-
order?
My lord,
What is the lawful order?
or lawful order, my lord, that I have given a tender to someone and he is to vacate the premises, that particular premises. And if he does not, my lord, then I can ask the police, my lord, to.
As on the date of the ad interim order, which is before us, nothing is there on record. Only that they are still in possession, and they are asking cannot be evicted without due process of law.
That process I have undertaken. I have undertaken that process. But I cannot force
Yes, you
them, but-
participated in the tender. What about this? Mr. Ghosh will restrain you from evicting him for 4 weeks. Will permit you to file a written objection in the court below with all these documents within a fortnight. The entire injunction application will be decided within that 4 weeks. Before that, don't evict him without due process. These have to come before the trial. These are not there. And a suppression is a very good ground. We'll record everything, whatever you say. We admit the appeal because questions of fact and law are involved. First up, next para. We are disposing of the appeal itself with your consent. The appeal itself is taken up along with the connected application for disposal on consent of parties. Full stop. The learned trial judge refused ad interim injunction at the ex parte stage on the suit of the appellant, claiming that the appellant are running a Sulabh complex by virtue of license given by the Kolkata Municipal Corporation stroke respondent. Full stop. Next para. The learned trial judge observed that apparently no payment has been made after the first quarter of 2023, but in the same breath, observed that letter of request was submitted by the appellants and receipt for security deposit showing payment of royalty up to the first quarter of 2023 for user of such Sulabh complex was furnished by the appellant. Next para, learned counsel appearing for the respondent corporation submits that the appellant had been continuing for a limited period to run the Sulabh complex with the under permission from the Kolkata Municipal Corporation. However, the said license was for a limited period. Thereafter, upon expiry of the same, a fresh tender was floated where the appellants participated and were unsuccessful. It is submitted that as such, the Kolkata Municipal Corporation is entitled and duty bound to give such license to the successful tenderer. Next para, it is vociferously submitted on behalf of the Kolkata Municipal Corporation that the appellant is guilty of suppression of such material facts before the trial judge. Next para, upon a consideration of the documents sought to be relied on by the Kolkata Municipal Corporation, we are of the opinion that a strong prima facie case to oppose the injunction has been made out by the appellant, by the respondent Kolkata Municipal Corporation. However, fact remains that that at the stage of grant of ex parte ad interim injunction, it is the averments made in the application for injunction which are to be taken as sacrosanct for the purpose of considering whether on the basis of such pleadings, injunction could be granted. Full stop. Since the learned trial judge held that there is proof of receipts of payment of security deposit and royalty up to the first quarter of 2023, in the absence of the documents now sought to be relied on by the KMC, the learned trial judge was not could not have been in a position to refuse injunction. Full stop. It is well settled that even an illegal occupant cannot be evicted without due process of law. Full stop. Next para. Be that as it may, since the corporation has also got documents which strongly indicate that certain relevant facts might have been suppressed by the plaintiff's appellants in the court below, we direct the respondents herein to file their written objection annexing all relevant documents to the temporary injunction application in the code below at the earliest, preferably positively within a fortnight from date. Full stop. Upon such objection being filed, the learned trial judge shall conclude the hearing of the injunction application itself and dispose of the same within 4 weeks from date. Full stop. Next para. However, in the meantime, the respondents shall remain restrained by an order of injunction from evicting the plaintiff's appellants without due process of law from the suit property in any manner whatsoever, for a period of 5 weeks from date or until further order, as passed by the learned trial judge. Full stop. It is made clear that nothing in this order or any observation made herein shall influence the learned trial judge in deciding the injunction application independently on its own merits. And it is also clarified that the present order of interim protection is being granted to the plaintiff's appellants without going into the merits of the matter, on the face of the averments made in the injunction application, and it will be open to the respondents to take all points, including the question of suppression of material facts, before the learned trial judge at the time of hearing of the injunction application.
So one more observation may kindly be made because he
Yes,
has
yes,
now being in possession and has been collecting the
Yes.
amount from the persons who are using the pen-use toilet. It was so long he would be collecting the until the matter is finally disposed of by the learned court below. That some
Mr.
observation.
Ghosh, the moment we do that, we direct him to pay something that will
No,
be.
no, I'm not asking for payment right now. I'm not asking for. But he's
All
going
questions will be open before the court below.
Then Dealership has kept their all
Everything open. Not only that, we have also made certain indications that there is a strong case of suppression of material facts. We could not do more than this.
Those papers have been handed over before this court.
No, we are returning those papers.
Application before the
We have not, that's why we have not specifically mentioned this. We have recorded their arguments and we have said that they have got certain documents to indicate these.
That's copy may be handed over.
They'll file the written objection, they'll hand over the copy of that. FMAT 62 of 2025 is accordingly disposed of along with can whatever one.
Can one.
যা আছে, in the light of the above observations, without an order as to costs.
My lord, I'm for the appellant, my lord. I'm led by learned senior advocate Pobal Kumar Mukherjee. My lord, I'm paying for not today, my lord, due to his personal ground. My lord, kindly make it not today, my lord.
I'm aware that he has left court for the day today. So
On the prayer of the appellant, the matter is adjourned for the day.
In this matter, my lord, there is a section 5 application, my lord, for 30 days delay.
Copy served?
No, my lord, your lordship has to direct, my lord.
The appellant shall serve copies of the application for continuation of delay along with the memorandum of the appeal on the respondents.
Only FAT 140. SAT 145 do have a application for condonation of delay.
SAT 140, what is SAT?
Cross
No,
objection.
SAT 144, there is a delay.
144.
Connected method of লেখার জায়গা নেই বলে SAT 144
The list is wrong.
Yes. 145.
So very well, no, the appeals are connected. What?
Connected, my lord, it's cross objection against, my lord, the.
So therefore, serve copies of both.
Yes, yes, my lord, it's interlinked. So I.
Very well. The appellant shall serve copies of Can 1 of 2025 filed in connection with SAT 144 of 2024, along with the memorandum of the said appeal and the memorandum of SAT 145 of 2024 on the one respondent.
Only one.
On the respondent, indicating that the matter shall be listed under the same heading on March 26, 2025, when an affidavit of service to that effect shall be filed by the appellant.
But only, my lord, the person is, my lord, now in abroad. My lord, his case is that he is in abroad. So in addition, may I serve to the learned advocate who represent before the appellate court?
They serve copies bolechi of such and such on the respondents, directly on the respondent, directly and stroke or through the learned advocate appearing for the respondent in the court below in connection with the title appeal from which the present second appeal arises. Appellate court's advocate. He would be last in contact with him.
Yes.
What is the defect, Mr. Banerjee?
My lord, the defect, my lord, is, my lord, that the appeal was filed, my lord, against the legal heirs of the original plaintiff, my lord.
So many
who died,
defects.
my lord, after, my lord.
Removed.
My lord, who died after, my lord, the decree was passed. And, my lord, no application was taken out, my lord, for leave, my lord, of this honorable court.
Now you have taken out.
No, my lord, on the last occasion, my lord, my learned senior friend, my lord, was of the opinion, my lord, it can be, my lord, well, this can be granted, my lord, without, my lord, his consent was there, my lord.
Leave for preferring the appeal.
Leave, my lord, leave for preferring the appeal against these persons.
Which are the persons?
My lord, the present respondents.
All of them?
All of them, my lord, they are, my lord, the legal heirs of the original sole plaintiff.
Sole plaintiff died after filing of the.
After decree.
After the decree.
After the appellate court.
Prior to, my lord, the filing of this.
Fair enough. Learned counsel for the appellant submits that the present respondents have been impleaded in the capacity of heirs of the original plaintiff, who has expired after the passing of the impugned decree of the first appellate court. Footstep, next para. Learned counsel for the respondents, in his usual fairness, submits that since such leave is a mere formality, the same can be granted even on oral prayer, and the respondents do not seriously object to the same. Footstep, accordingly, leave is granted to the appellants on the oral prayer of the appellants, to prefer the appeal against the present respondents, who are the heirs and legal representatives of the deceased plaintiff, deceased original plaintiff. Footstep, accordingly, the appeal is treated to be, accordingly, the defects in that regard are treated to be cured. What about this? The court number of the trial court furnished in the preamble is erroneous. That also you have corrected. Yes, you have corrected. Yes, what is the appeal about? Out of 41.
Suit for eviction, my lord.
Against Chakraborty, you can take your seat. We just hear him under order 41. Yes.
Suit for eviction, my lord, filed against me. That has been, my lord, decreed.
Both courts?
Both courts. Now, my lord, my plea, specific plea, my lord, taken in my written statement was.
On what ground?
My lord, that I'm a mere trespasser, my lord, and trespasser in the year 2000, and they have filed the suit, my lord, in 2004. Therefore, my lord, they want my eviction from that suit property. Now, my lord, my specific plea was that from 1970, I have been, my lord, possessing that, my lord, two pleas. One of them, my lord, was the plaintiff, my lord, does not have a right title and interest, my lord. So the plaintiff is not in a position, my lord, to challenge my lord, to evict me. My lord, I have specifically, my lord, stated, my lord, that the original, my lord, the original landowners, my lord, they have, my lord, transferred it, my lord, to someone else, and the plaintiff has not connected with them. And my lord, secondly, my lord, that from 1970, I have been, my predecessor, they were sitting in the suit property. I was born there, my lord. So there's a specific, my lord, plea of adverse position. Now, my lord, I'll just take your lordship, my lord, to the appellate court's decree. My lord, the learned trial court, my lord, decreed the suit, my lord. I'm not taking your lordship, my lord, there because there was no document, my lord. The learned trial court held, my lord, that since there is no document to show that I am, my lord, in possession of the suit property since 1970, and my lord, one plea was made, my lord, in my cross-examination that, my lord, the CSROR and the RSROR both stand in the name of, my lord, the original, my lord, the original landowners who is not connected with the plaintiff. Now,
How
my
do
lord,
they claim title?
they claim title, my lord, through a registered deed.
From that original landowner?
No, from someone else. Well, they claim title from one Mohitosh through a registered deed from in 1973.
How did the appellate court deal with this?
Well, I'll just come, my lord. And my lord, my case is, my lord, Shamacharan was the original landowner. Shamacharan died, leaving behind, my lord, Parvati, his wife. And my lord, the CSROR and the RSROR, my lord, were recorded in favor of Parvati.
Have you produced any title deed of Shamacharan?
The record
There's
of
a book, Bengali book called K. Shamacharan.
Yes.
So Shamacharan lied. So that question arises here also.
My lord, what was produced, my lord, is the CSROR and the RSROR in favor of, my lord, Parvati. Now, my lord, what the appellate court has done, my lord, kindly, my lord, I'll just, my lord, be candid, my lord, and point it out. Before the learned trial court, this was not, my lord, produced by me. In cross-examination, I said I will produce.
What did you produce?
The RSROR,
RSROR, yes.
The record of rights. It was not produced, my lord, during the learned.
Now it has been produced. Appellate court has taken care of.
Appellate court has not taken care of.
Even if those are produced, what difference could it make? Your position is not disputed. CSROR does not prove adverse person.
My lord, no, my lord, kindly sees, my lord.
Entry point, hostile all along. Shamacharan put you in position.
My lord, kindly sees, my lord.
You are permissive occupant of the real owner, but against these owners.
Not permissive occupier, my lord. My case is, my lord, against Parvati, my lord. I am, my lord, I am an occupation, my lord, adversely.
Who is Parvati?
Parvati, my lord, is the legal heir of Shamacharan, who I claim to be the actual owner of the land suit property. Against, my lord, the present plaintiff or, my lord, Mohitosh, from whom, my lord, they claim title, they are not, my lord, connected to the suit property.
Findings, their title deeds are there. Did they produce any chain deed? No.
No, only the title deed. Only the title deed of 1973 from Mohitosh.
Adverse person in any event you are not entitled. I mean,
Lord, kindly, my lord, I'll
adverse
just, my lord.
person proof is very difficult. And adverse person, if you can't prove you're in position, they have better title at least by virtue of their title deed.
My lord, I'll just, my lord, take your lordship, my lord, to one.
You have your CSRORs, but you don't have Shamacharan's title deed or anything to show
Shamacharan's title deed I cannot have, my lord. Kindly visualize this, my lord.
Nothing to show that Shamacharan had title because you are relying on his title.
Shamacharan from their
Parvatis.
From their Parvati.
You can discover a Shamacharan and a Parvati. And what prevents you from doing that? Why Shamacharan Parvati? It may be Shobhosachi and Uday also. I mean, you can discover any names.
But the records were produced, my lord, in the appellate court. That is
their title not produced. So the record of writer is also in the name of Shamacharan and Parvati.
My lord, only Parvati.
Only Parvati.
Only
that is also not in your name. So how is your adverse person proved?
My lord, kindly, my lord, says, my lord.
Let Parvati come and file whatever we want.
Parvati, my lord, subsequently, my lord, died.
So the record. So your position is not recorded even anywhere.
My lord, kindly, my lord, I'll just, my lord, place, my lord, very short. Appellate court's judgment is very short. My lord, kindly, my lord, takes up page number 5 once.
We are there, yes. You can start from having regard.
Well,
internal page 5.
My lord, may I start from a bit earlier? I'll start from I'll just place, my lord, the first 2 paragraphs only, my lord.
Yes.
At the time of hearing of the learned, the argument of the learned court, defendant pressed for allowing of the petition filed by the applicants under Order 41, Rule 27, stating that the predecessor in chair of this court, while ordered as a such and such, allowed the amendment petition in respect of the written statement which they filed in the learned court below, and the said order, the learned court was given opportunity to defendants to file additional WS. Learned advocate also submitted subsequently filed order number such and such defendant petition file amendment written statement further submitted on such and such date. On 28th of June 2016, the defendants appellants filed petition with a prayer for accepting CSROR and RSROR in respect of the suit property as additional evidence which defendant appellants could not submit in the original suit. Therefore, my lord, it was submitted. It was submitted, my lord, and taken, my lord, into consideration in the appellate stage. Learned advocate for the respondents raises objection. This was not, my lord, considered. Having regard to the submission of the learned advocate of both sides and after perusal of the above mentioned two documents, CSROR and RSROR, and the above stated order number 22 such and such, petition for the defendants under order 41 on is allowed on contest for the ends of justice. Therefore, my lord, at the appellate stage, I sort of, my lord, improve my case. Now, my lord, kindly takes up once page number 7. Page 7, my lord, second paragraph onwards.
Yes.
Having regard to the arguments, learned advocate of both the sides, and after perusal of record carefully, it appears that though defendants appellants have stated that they are possessing suit property in adverse possession for 35 years, the plaintiff respondent has no right, title, and interest over the in respect of the property, namely Shamacharan, and after demise of Shamacharan, his wife Parvati became owner in respect of the suit property, and accordingly their name has been recorded in CSR1 and RSR1. But in respect to establish their contention, they did not exhibit any document to establish their claim of adverse possession. But plaintiff respondent has exhibited his document regarding purchase of the suit property from Mohitosh and others by way of sale deed dated 12th March 1973, and also by submitting some other exhibited documents such as possession of the suit property, tax receipt by Hugli Chishura municipality, and Khazna Dakila. It is also mentioned here that in the additional rule statement filed by the defendants appellants, the court below on such and such, defendants appellants stated in 1970 adversely possess the suit property, but in the amendment petition, well, the dates are wrong. Well, the dates do not mismatch to the very short extent. 11th of April in one case, and my lord, 1st of November in the other case. And that also, my lord, my predecessor in interest, my lord, started staying there, my lord, adversely. Not my lord, me. My lord, only, my lord, these two paragraphs, my lord, is the observation of this honor, my lord, the appellate
This
court.
is fatal to you. Adverse possession, the date of inception is the most important thing.
My lord, kindly
Once you say
consider-
your predecessor entered, once you say you yourself entered, dates are different.
My lord,
So the date of commencement of adverse possession is
my lord,
also
kindly
not-
considers only one aspect, my lord. Well, the predecessor, my lord, the plaintiff also, in respect of their title, produced one deed of 1973. I have got, my lord, the record of rights of CSROR and RSROR. My lord, no chain deeds, and my lord, nothing to show on record, my lord, that Mohitosh, my lord, is the, my lord, the original owner. They show a deed, my lord, of 1973 from Mohitosh. Apart from that, nothing.
Valiant effort.
The suit for eviction, my lord, has to be a bit valiant.
Valiant effort and very good. And you have submitted whatever that there is to be submitted in this matter. The present second appeal has been preferred against judgment of affirmance, whereby both the trial court and the first appellate court granted eviction on the premise that the defendants to appellants are trespassers in respect of the premises. Push up next para. Learned counsel for the appellants argues that due to a minor discrepancy in the date of commencement of adverse possession, which was the defense taken by the appellants, the appellate court disbelieved the case of adverse possession, without adverting to the fact that no prior chain deed of the alleged vendor of the plaintiff's respondents was produced by the plaintiffs to dispel the case of the appellants on the strength of the CS and ROR record, RORs, that one Parvati, the predecessor in interest, the one Parvati, the original owner, was in possession of the property initially. The appellants claim adverse possession against the said Parvati, and as such, it is argued that the courts below erred in law in holding that the plaintiff respondents have proved their possession. The plaintiff respondent has proved his possession in respect of the premises. So, next para, we find from the judgments of the courts below that the appellate court, while considering an application under Order 41 Rule 27, comma, allowed the same, comma, thereby permitting the CSROR and RSRORs to be produced. Full stop. However, comma, the said records of rights do not make any difference, comma, since at best those depict that one Parvati was in possession of the suit property at the relevant juncture. Full stop. There is nothing on record even to show the date of commencement of the possession of the defendants and stroke or that they were in continuous uninterrupted open and hostile possession of the property for the entire period of more than 12 years from the date of inception of the possession turning adverse. Full stop. Next para. Moreover, comma, the discrepancy between the original plaint case that the defendants appellants had entered into possession on April 11, 1970, with the amended case that the predecessor in interest of the appellants, one Jogeshwar Jha, entered the suit property on November 1, 1970, are destructive of the actual date of commencement of adverse possession. Full stop. In case of adverse possession, comma, the exact date and time of commencement and the method and mode in which such commencement took place is of crucial importance. Full stop. The said fact having not been proved, as opposed to the plaintiff respondent having proved title by way of not only a registered purchase deed but also collateral evidence in the form of tax receipts, etc., to show that they acted on such title deed, comma, we do not find any illegality in the judgments of either of the courts. For sub next para, moreover, comma, it is well settled that merely because a different view is possible, comma, the second appellate court cannot interfere with the concurrent findings of fact of both the trial court and the first appellate court, whose hence, comma, we do not find any substantial question of law involved in the appeal. Accordingly, SAT 206 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2024 also stands dismissed. Full stop. There will be no orders to cost. Sorry, Mr. Lord.
No, there was a Can 2 as well, my lord. Two applications, one injunction and one file, my lord, for appropriate order.
Acha, very well. Can 1 of 2024 and Can 2 of 2025. Thank you very much.
Great.
My lord,
Yes.
there is one defect. It will be FMAT instead of FAT. I will do it. Only one correction.
Oh, what? FAT, it has been corrected. There was a previous
FMAT.
direction. FAT number has been allotted.
It will be
147.
FMAT.
It will be FMAT.
My lord.
No, that has been done. FMAT number has been allotted on 2nd of July.
Oh, in the list it has come.
FMAT is list. The appeal is wrongly classified as FAT instead of FMAT. It should be FMAT.
Yes.
It is 34th. FMAT is appearing as FMAT. What are you saying?
Out of time, my lord.
It is appearing as FMAT only, not FAT. Where is the Section 5 application?
Section 5 is Can 2. 61 days delay.
Can 2.
Initially, civil revision was filed.
Were you directed to file a serve copy of this?
No.
Serve copy and come back. Can 2 of 2024 is an application for condonation of delay in filing the appeal. Full stop next para. The appellant shall serve copies of Can 2 of 2024, comma Can 1 of 2024, along with a copy of the memorandum of appeal on the respondent, indicating that the applications that the matter shall be listed under the same heading on March 26, 2025, when an affidavit of service to that effect shall be filed by the appellant. Come back, we'll hear out the Section 5. If we allow the condonation, we'll immediately take up for. This is against what? Injunction.
Order 22 Rule 10.
Yes, after a long time, when a second appeal without defect.
No, the defects have been.
The defect was there previously.
Was cured.
Yes, what is
My
that?
lord, the defect which was reported, your lordship, my lord, kindly see the 18th February order. My lord, this appeal has already been admitted. Now, my lord wanted to, my lord, hear the second appeal before your lordship in division bench, since a very limited question is, I have served notice, my lord.
And I am appearing, my lord, on 1 to 6. Respondent number.
You have served on all?
All. There was a, lordship said the defect is not correctly.
Can be disposed of the admission. Service of copies of application constitutes service of notice of appeal. We recorded that.
Yes.
What is the appeal against?
Yes, my lord, what happened, my lord? I am the plaintiff in the suit. Now, my lord, after receipt of summons, some of the defendants appeared and filed an application under Order 7, Rule 11.
1 to 6, you filed.
Yes.
You have filed the application.
And other
Others were also there. So why don't you appear for the others?
Others don't come.
I'm not come to take your seat. We'll hear you also after him. Yes.
Now, my lord, that Order 7, Rule 11 was allowed and the plaint of my suit was rejected. Now, my lord, I filed a title appeal. Now, my lord, when the title appeal, my lord, was placed for admission. The learned first appellate court, my lord, had my lord dismissed my title appeal on the point of admission. It is the specific finding of the learned first appellate court is that since Order 7, Rule 11 is an interlocutory application, title appeal will not lie. With deepest of respect, he had not read the definition of decree.
No, the understood.
My lord, what?
Order, sir.
Now, my lord, kindly see the, my lord, order dated 19th July 2020. The learned first appellate court had refused to admit my appeal, saying that
No, order dated 20th of November 2024. That is the order.
Yes.
It was preferred against rejection of plaint.
Yes.
That no, the instant petition under section 11 is hereby
Section
allowed.
11, their ground is res judicata, but application is Order 7, Rule 11.
Application is filed under section 11.
Kindly see, my lord, the
Application is captioned as section 11.
Section 11, but
There cannot be a section 11 application. There is no provision for filing an application. What was the prayer in the
rejection of plaint. I've annexed the application. Kindly comes to, my lord,
res judicata can be a ground of
page
rejection.
31. Page 31 of Can 1. Captioned as section 11. There, I understand, my lord, they have taken a point of res judicata.
That can be a ground of section order 7. Then because it reject the yes. And what order has been passed by the trial court?
Learned first appellate court has
trial court
has rejected it on merit. My suit,
allowed on contest.
suit
It's
was
allowed on contest.
allowed on contest.
What does it mean?
Against the said order, my lord, revision lies.
If the section 11 revision lies,
Yes,
the effect of this allowing the application is that the plaint is rejected. Either the plaint is rejected or worse, the suit is dismissed. Your prayer was for rejection of the suit.
Page 31.
There cannot be a rejection of the suit. Can be a rejection of the plaint or dismissal of the suit. Your prayer is reject the present case on the ground of res judicata.
Cause, my lord, on the basis of the deed, I have challenged the deed.
Res judicata can be a ground, but the prayer has to be seen what has been allowed. This prayer can be allowed only under Order 7 Rule 11.
But Order 7 Rule 11, my lord, only within the periphery of the plaint only.
Plaint.
Not the WS. But he suppressed in the plaint that earlier, my lord.
If he suppressed in the plaint, have you filed your written statement?
He suppressed. I filed.
You have filed your written statement.
I filed the written statement.
You have filed your written statement.
I filed the written statement in that suit.
In this suit. Then why did you file a section 11 application? What is the meaning of a section 11 application, sir? There cannot be section 11. Please read section 11. Is there in scope of any application? It's a substantive provision preventing a further suit if substantially the same issue has been decided.
That earlier on the basis of the deed, earlier, my lord, deed has been challenged. And the said deed, my lord, and the
where is your written statement? Let us see your written statement. You said you filed it.
Paragraph, my lord, if you lordship, page is annexed, my lord.
Annexed here. Yes. So at best under Order 14 Rule 2, the issue has to be decided. How can the section 11 application be allowed and dismissed like this? Just on the basis of your written statement.
And he suppressed
what is going on?
He suppressed the only one thing, my lord, the earlier.
You can argue these ridiculous things, but the court will also grant such ridiculous prayers. You can appreciate advocates arguing whatever they are instructed to argue, but courts should not do that. Application under section 11 allowed. Stopping there, what does it mean?
Because my lord, earlier, my lord, he suppressed the earlier, my
There
lord,
is
order was
another- I
passed.
also have a
And my
second
lord,
point.
agreed against the, my lord, Amirali. On the basis of the said deed, he purchased the land. And
It
my
will
lord,
be decided as an issue in the suit and let the suit be dismissed on the ground of res judicata.
But two suits, that will be, firstly, my lord, against the said order, my lord, appeal was pending. And subsequently, my lord, he filed the suit. That is, my lord, if it is, my lord, decided, the appeal was, my lord, rejected.
That has to be decided as an issue in the suit, sir. Res judicata. And then only the suit can be dismissed on that ground.
Kindly see, my lord, another, my lord, blatant mistake by committed by the learned trial judge, not the appellate court. Kindly see, upon perusal of the instant petition and the case record and documents submitted by the defendant. Cannot be. It has to be on the basis of the plaint. Documents submitted by the defendant cannot be looked into at the Order 7 Rule 11 stage. It has to be on the plain reading of
And
the
take your CTS. What else do you say?
But my lord, the order.
That the suit is barred by res judicata. We appreciate. These are bad orders. Let that be decided as a suit, as an issue in the suit. That the trial court will in any event have to do. And this is not a scenario under Order 14 Rule 2 where on the basis of without taking evidence, at least going through the plaint, the relief sought, the court can decide as a preliminary issue before hearing the other issues. This question of res judicata has to be, it's a mixed question of fact and law. Mixed question. So therefore, Order 14 Rule 2(1) applies. Order 14 Rule 2(1) says, despite the suit being able to be decided on one issue, the other issues also have to be decided. Unless it's a bar of law, palpable bar of law, or jurisdictional error. This is not a jurisdictional error. It can be a bar of law. Definitely, it is a bar of law, but arguable. We'll allow the appeal because keeping it admitted here and staying the suit for infinite years won't help you.
But against the order, my lord, the revision lies, my lord, against the.
We'll deal with that objection also.
My lord, on the last
Petition lies,
on the
not
last
the appeal.
occasion, your lordship had, my lord, specifically put this question, my lord, since the stamp reporter has raised this question, what my learned friend. Now, my lord, that reported judgment is, I have shown that reported judgment that is already on your lordship's record.
As per previous direction, service has been effected on all the respondents, although only the respondent numbers 1 to 6 are represented through counsel. Full stop. We recorded in your previous order that affidavit of service filed today be kept on record. Full stop. We recorded in your previous order dated February 18, 2025 that service of notice and copies of the application would constitute service of notice of the appeal on the respondents. Full stop. Moreover, the matter arises out of an application captioned under section 11 of the Code of Civil Procedure filed before the trial court by some of the defendants. Full stop. Next para. Accordingly, the applicants of the said application in the trial court are substantially represented by the respondent numbers 1 to 6, who were co-applicants therein. Full stop. Next para. The present second appeal has been directed against a judgment of the appellate court, whereby the appellate court dismissed the title appeal preferred by the appellants at the admission stage under Order 41 Rule 11 of the Code of Civil Procedure on the premise that the impugned order was not appealable. Full stop. Next para. Upon a perusal of the trial court's judgment dated July 19, 2024, we find that by the said order, purportedly an application captioned to be one under section 11 of the Code of Civil Procedure was allowed. Full stop. Next para. However, the effect of allowing the said application is crucial, within bracket, fatal to the suit. Full stop. in the said application, comma, which is also annexed to the connected stay application of the second appeal, comma, a prayer was made that the within double inverted present case, double inverted clause, be rejected on the ground of res judicata. Full stop. By the expression within double inverted present case, double inverted clause, comma, the defendants, applicants obviously meant the suit itself, comma, since there was no other case pending, comma, which is also clear from the tenor of the application as a whole. Full stop. Next para. The respondents claim that there was a previous decree passed in a prior suit, comma, which operates as res judicata in the present suit, full stop, and appeal has been preferred against the previous decree, which is also pending. Full stop. It is contended that thus, comma, the appellants were well within the know of the previous decree and that the present suit is barred by res judicata but suppress the same in their plaint. Full stop. Such contention in the application under section 11 is corroborated by the stand taken in the written statement filed by the respondents in the suit as well. Full stop. Hence, comma, although captioned to be under section 11 of the Code of Civil Procedure, comma, the application was one for rejection of the plaint. Full stop. Next para. This is because of the simple reason that the prayer that the character of an application is not determined by its caption, but by the substance thereof and the relief sought therein. Full stop. The relief being rejection of the plaint, comma, could only be granted under Order 7, Rule 11 of the Code of Civil Procedure, comma, although res judicata under section 11 of the code might be a ground for such rejection as a bar of law at best. Full stop. Next para. Thus, comma, in any event, comma, even taking a conservative view, comma, the trial court's judgment tantamounted to allowing an application for rejection of plaint, comma, thereby having the effect of rejecting the plaint, comma, which is a deemed decree under section 2 of the Code of Civil Procedure. Full stop. Thus, comma, the learned appellate judge palpably acted without jurisdiction in observing that no appeal was maintainable and dismissing the title appeal at the admission stage. Full stop. Next para. In any event, comma, section 11 of the code does not provide any scope for filing any application, but is a substantive provision providing a bar to filing of a subsequent suit if similar issues were substantially and directly decided in a prior proceeding by a competent court having jurisdiction to grant the reliefs sought in the subsequent suit. Full stop. Next para. Even if we take the application caption to be under section 11 of the Code of Civil Procedure to be an application for dismissal of the suit, comma, in such event as well, comma, the rigors of Order 14, Rule 2 within bracket 1 of the code would apply, and in spite of the suit being able to be decided on one issue, comma, it was incumbent upon the learned trial judge to decide on all the issues concerned. Full stop. The only bar under Order 2, Rule 2 within bracket 2 would be if there was a bar evident on the face of the pleadings and or if the court lacked jurisdiction, full stop. The second condition is not applicable here, full stop. The bar of res judicata as pleaded in the written statement and the application under section 11 of the code could at best be a mixed question of fact and law, comma, to be decided along with the other issues as an issue framed in the suit, comma, as per the mandate of Order 14 of the Code of Civil Procedure. Full stop. Thus, comma, the learned trial judge palpably erred in law as well in allowing the application for rejection of the plaint stroke dismissal of the suit at the outset, comma, without formulating issues on the issue of res judicata and or deciding the same on a full-fledged trial of the suit along with the other issues. Full stop. Hence, comma, both the learned trial judge and the first appellate court substantially erred in law in allowing the application for rejection of plaint stroke dismissal of suit at the preliminary stage. Full stop. Accordingly, the second appeal is admitted on the substantial question of law as to whether both the courts below, now as to whether one, the learned first appellate court substantially erred in law in dismissing the title appeal under Order 41 Rule 11 of the Code of Civil Procedure on the ground that no appeal was maintainable, despite the challenge being against an order passed for rejection of plaint stroke dismissal of suit. Number 2, Roman 2, whether both the courts below substantially erred in law in allowing the application for rejection of plaint stroke dismissal of the suit at the outset, without the conditions and parameters of Order 7 Rule 11 of the Code of Civil Procedure and or Order 14 Rule 2 of the Code of Civil Procedure being satisfied and or adhered to. Next para. In view of the short conspectus of the appeal, and since opportunity of hearing has been given to both the contesting parties, and the other respondents choose not to appear despite service of notice, we decide to dispose of the appeal as follows. Next para. The learned trial judge palpably erred in law in allowing the application caption to be under Section 11 of the Code of Civil Procedure, without treating that same to be substantially an application under Order 7 Rule 11 of the Code, thereby rejecting the plaint without the precondition and parameters of Order 7 Rule 11 having not been satisfied, since there was no bar of law evident on the face of the plaint and or non-disclosure of cause of action for the present suit within the four corners of the plaint. Full stop. Alternatively, even if we treat the order of the learned trial judge as one of dismissal of the suit, the trial judge was all the more in error, since under the mandate of Order 14 Rule 2 of the Code of Civil Procedure, it was the incumbent duty of the learned trial judge to frame proper issues, inter alia on the question of res judicata, and to decide all issues together on a full-fledged trial, since the issue of res judicata being a mixed question of fact and law in the present context, could not be decided prior to the other issues in isolation. Full stop. Next para. The learned appellate court went one step further in holding that the appeal that the learned trial judge that the impugned order of the learned trial judge was not an appealable order and dismissing the appeal at the Order 41 Rule 11 stage. Next para. However, since we have already held that the learned trial judge, that the judgment and deemed decree of the learned trial judge was itself bad in law, no useful purpose would be subserved in keeping the present appeal pending or remanding the matter to the first appellate court, we should not inure to the benefit of the respondents as well, since an unnecessary and futile long-drawn procedure would ensue before the appellate court, despite this court having found on merits that the learned trial judge substantially erred in law. Full stop. Accordingly, SAT 276 of 2024 is allowed on contest, contest against the respondent numbers 1 to 6 and ex parte against the others, thereby setting aside the judgments and degrees of both the courts below and remanding the matter back to the learned trial judge for deciding the suit on a full-fledged trial upon framing appropriate issues, including the issue of res judicata, and deciding all the issues together upon giving adequate opportunity of adducing evidence and hearing to the parties. Full stop. In view of the long pendency of the suit, suit is of which year?
22.
Oh no, the last cherry. Consequentially, can 1 of 2025 is also dismissed. Full stop. There will be no orders to cost. Thank you.
Can 1 is disposed of? Can 1?
Yes, consequentially. Not disposed of, dismissed.
Dismissed. Yes, appeal is over.
Yes.
For the appeal.
Out of time?
No, no, my lord, it is perfectly within time. The impugn order was passed on 20th of September 24, and we have applied for certified copy on 30th of September. So there is loss of 10 days. Then it was made ready on 3rd of October, and the puja holidays intervened on 9th of October.
You filed on the reopening date?
Yes, yes, yes.
Reopening date?
Yes, yes. So it is within time. We have explained this before the Lojima court, my lord, but
Not satisfied.
not satisfied.
You are sure you have filed it on the reopening date?
Yes, yes, yes.
What was the reopening date? Check up.
4th of November.
Check up your calendar. You don't have the last year's calendar. Do you have a calendar?
Yes, yes.
You have to be very sure on that to set aside the
Yes, my lord.
thing. Learned counsel for the appellant rightly points out that the appeal has been filed within time, full stop. We find from the records that the impugned order was passed. This is a misappeal here. Impugned order was passed on September 20, 2024, and certified copy was applied for on September 30, 2024, comma, thereby the appellant losing 10 days of limitation. Full stop. Ultimately, the requisites were notified on October 3, 2024 and deposited on the same date, comma, on which date the certified copy was also made ready for hearing. Full stop. Next para. Therefore, comma, thereafter, comma, the puja vacations for the concerned year, that is 2024, started from October 9, 2024 and ended on November 3, 2024. Full stop. The limitation period expired in the meantime. This is from the City Civil Code.
Yes.
Full stop. However, comma, in view of the appeal having been filed on the very reopening date after the said vacation, that is on November 4, 2024, comma, the time lost by the appellant would be excluded by operation of the Limitation Act. Full stop. Hence, comma, we do not find any delay in preferring the appeal. Full stop. The delay in the defect in that regard, the purported delay, the purported defect in that regard stands accordingly cured. Eta ekটু ফেরত দিয়ে দিন। Now, what is the appeal about?
The appeal is rejection of an application under Order 39, Rule 1 and 2 in a suit for declaration and injunction. At the plaint, my lord, we have prayed for declaration that as per the will, probated will, executed by the maternal uncle of my grandmother, I have a right of residence. And I can...
Wait, maternal uncle of your grandmother?
Grandmother.
Executed will in favor of you or grandmother?
My other brother. My other brother. That I have annexed page 44.
So he went across 3 or 4 generations?
Yes, yes, yes.
And it was given to your brother?
Brother. My elder brother will be the first Sebaid. Thereafter, on his death.
Oh, it was made a Devottar property?
Yes, yes, yes.
And
there is a provision.
So it's not a will, it's an Arpannama then?
But it is stated to be a will.
Probate was taken. Very well. Then,
and my lord, at page 44A of the stay application, press injunction application, lordship will find that I have annexed the will. Para 5 of the will is very vital. This is the interpretation. It is my will and desire, and accordingly I direct.
Page 44A?
Page 44.
5 starts from 44?
Yes. Para 5.
Very para 5, yes.
Yes. It is my will and desire, and accordingly I direct my said executrix to perform the Seba and Puja and the periodical festival as the sole Sebaid in manner as I have been performing. And after her death, I appoint, this is vital, Joyanto Kundu, the respondent number 1 herein. And after his death, Kumari Kakuli Kundu, the pro forma respondent. And this is very vital. And son and daughter respectively of Dharmonarayan Kundu. Dharmonarayan is my father. And grandson and granddaughter of Simoti Sorbani Kundu. The daughter of my maternal uncle of village so and so. To be the Sebaid, one after another, respectively mentioned. Then it is my will and desire that none of my Sebites shall have power to sell or transfer the said premises, which shall absolutely vest with the deity, Sri so and so, and the Sebites with their families shall always have the right of residence at the said Thakurbati.
So it was given to this idol.
Idol. I am one of the family members all through Lordship.
You claim through whom?
I'm
Dharmanarayan. You are the son and daughter. You are the daughter of Dharmanarayan or son?
No, I am the another son of Dharmanarayan.
You are a son of Dharmanarayan.
And I am residing there. Kindly come to page 57.
And the plaintiff is your brother.
My elder brother.
He is also in the same capacity.
Same.
Vis-a-vis the deity.
Yes. And my prayer in the main suit for declaration that I have a right of residence as per the will, and I can participate. It may not be as a Sebait. I can participate in the daily Seva Puja. Everybody has right. Even an outsider can also participate. Whatever it may be. My lord, consequently, I prayed for permanent injunction followed by temporary injunction not to disturb my possession. Series of documents that I am in possession, I am a resident.
Why refused?
My lord,
ad interim was granted.
Ad interim was granted.
Order 13 Rule 4 was filed and injunction was taken up along with it.
Yes.
So why refuse? Let us see the impugned order.
Yes. Kindly come to the impugned order. He entered into the main aspect of the matter.
Even then, let us see the main aspect of the matter then.
Page 3 of the last page. From the above, prima facie, it does not appear that the plaintiff is a Sebite. I am not saying so. Prima facie, it also does not appear that he is family member of any Sebite or erstwhile Sebite. Nowhere in the plaint or application, plaintiff stated that he is family member of dependent. He is my elder brother. From the above, prima facie, it appears that plaintiff is not a authorized documents. So this is declared a person in possession, even if
as you are saying you are not a Sebite, but that is contrary to the will.
Yes.
Page 40. No. You yourself said right now on our query that you are not a. Yes, I say so. You say you are.
For the sake of argument. For the sake of argument, I have said.
No, don't say for the sake of argument. As per the
I am also claiming to be a Sebite, and I have right to participate.
Where have you claimed that in your plaint? Let us see that.
Kindly come to.
What relief have you sought in the plaint first?
Page 18, my lord.
Page 18, yes. Declaration, you have unfettered right to use and enjoy. You have not claimed Sebiteship. Without that, how can you?
Then, my lord, there is, including the suit property, without any interference and or disturbance by any person, including the dependent and his main agents and associates, in terms of the probated will, executed by Sarotchand Nandi, since with a right to perform and or participate the daily Seva Puja of the deity of Sri Radha Govinda Ji located at so and so. This is my prayer. And permanent injunction restraining the dependent, including his main agents and associates, from interfering and or disturbing and or disposing.
What is the key paragraph in the plaint?
Plaint,
So,
my lord. Yes.
Asserting your title or right?
Yes, my lord. Para 5, my lord.
Para 5.
Page 15.
Yes. Last will, the Dharmanarayan.
And I was born, my lord, after the execution of the will. Para 6. 5, 6, and 7. And 8.
But you claim to be the son of Dharmanarayan.
Yes, and I'm staying there, and I have my declaration is that I can participate in the daily Seva Puja. And
let us see the injunction prayer.
Yes.
In the injunction application.
Page 21.
Restraining from interfering, disturbing, dispossessing.
Yes.
You have not asked for this Shiva Puja and everything.
In fact, my lord, that is a prayer in the plaint.
But Shiva Puja, we are not granting. That may create difficulties.
But kindly protect my possession. That has been rejected. The trial court entered into the merit of the main dispute. at this interlocutory
And
stage.
any document of possession you have annexed?
57 to 70. Page 57, my lord, my Aadhaar card, then voter ID card, then
All at this address.
all at 30D. 30D.
The present appeal has been preferred against an order whereby the temporary injunction application filed by the plaintiff stroke appellant in his suit for declaration and injunction has been dismissed upon allowing an application for vacating the ad interim injunction filed by the defendants. So next para, learned counsel for the appellant argues that as per the probated last will and testament of Sharat Chandra Nandi, the admitted original owner of the property, the son and daughter respectively of Dharmonarayan Kundu, inter alia, would have a right of Shebaitship in respect of the deity in whose favor the property was vested by virtue of the said will, along with right of residence at the subject property. Next para, learned counsel relies on clause 5 of the said will in such context. Learned counsel also relies on several annexures to the present application for injunction, which was also produced in the code below to establish prima facie that the plaintiff is in possession of the property. We also find from the cause title of the plaint itself that the plaintiff is a son of Dharmonarayan Kundu, and as such, having a right of residence and Shebaitship at least on a prima facie footing with regard to the idol, the deity to whom the suit property belongs. The learned trial judge, in the impugned order, observed in a cryptic fashion that it does not appear that the plaintiff is a Shebait or is a family member of any Shebait, and or that the plaintiff is not an authorized occupant of the suit property, which prima facie operates contrary to the several documents which were annexed on and relied in the code below. Next para, thus, the appeal will be heard on the grounds taken in the memorandum of appeal and is accordingly admitted. Having made out a strong prima facie case for injunction as discussed above, the respondent only the
respondent number 1.
The defendant stroke respondent number 1 shall remain restrained by an order of injunction from disturbing in any manner the peaceful possession and enjoyment of the plaintiff stroke appellant in respect of the suit property till disposal of Can 1 of 2024. The plaintiff, the appellant stroke petitioner shall serve a copy of the application on the respondent opposite party number 1, indicating that the application shall be listed in the monthly list of April 2025 and file an affidavit of service to that effect on the returnable date. Service of copy of the application on the pro forma respondent number 2 is dispensed with for the present, since no relief has been sought against the said pro forma respondent.
Grateful, my lord.
And for the appellant, my lord, the deficit court fees of ₹20 has been paid, my lord.
Paid?
My lord. I have a Xerox copy, my lord. দুটো আছে। It's against an order of injunction, my lord, interim injunction.
20 rupees has been paid. Valuation of the appeal has not been furnished. What was the valuation of the suit?
Suit valued at rupees, my lord.
In the absence of valuation, how can they
15
put
lakhs,
us?
my lord.
3 lakh?
15 lakhs.
15 lakh, you just will give you liberty right now to do it. You are the advocate on record. The learned advocate on record for the appellant is granted leave is directed to insert the valuation statement in the memorandum of appeal during the course of the day. Do it in both the judges' copy. During the course of the day, full stop, since it transpires from the plaint which is annexed to the connected application that the valuation of the suit is rupees 15 lakh, comma, this court has pecuniary jurisdiction to take up the appeal, which is preferred against an interlocutory order. Full stop. Next para. Although the impugned order is bereft of any cause title, comma, since the particulars of the suit from which the same arises, the court and the date of the order are apparent from the certified copy of the impugned order, comma, we do not treat the same to be a defect in the appeal. Full stop. Accordingly, comma, both the defects pointed out by the stamp reporter are deemed to stand cured. But subject to your correcting this, please do that immediately. Even if you lose the appeal, then also do it because you have directed it. What is the appeal against?
It is against an order of interim injunction. I am the plaintiff, my lord.
Refused that interim.
Refused, my lord. The respondent are the adjoining landowner, my lord. He is effectuating any construction. He is effectuating construction.
Adjoining owner is making construction. What is the difficulty?
But encroaching my portion also.
You have complained before the municipality. What is EBPS?
English Bazar Police Station.
Oh, you have also complained before the police.
The English Bazar municipality is also a party, my lord.
চেইন লিড কি প্রডিউস করবে এই স্টেজে? ও তো টাইটেল লিড প্রডিউস করছে, তো এখনো ডিসপিউট নেই। What is the injunction you have sought? Let us see your application. Where is your prayer for injunction?
I have annexed the injunction application also.
Which is the page number of the prayer?
Page 16. It starts from page 16.
No, prayer. Starts from page 16. Where is the prayer?
Here is it.
Yes.
Page 18, my lord.
18. The suit property is your property. You have produced deed regarding this property. But we won't.
I have annexed the deed also, my lord.
Deed schedule tallies with this property.
My lord.
We have to be careful that we don't injunct them from constructing over their own property. Page 26 is the deed schedule. 09, yes.
Page 26.
No, but you have been transferred out of 285, only 546 square feet. But in the suit property, you have included the entire 285 decimal. How can you get that? Page 26 is the transfer deed. The scheduled property is 2.85 শতক মধ্যে, that is 285 decimals. Out of that, only 546 square feet. But in your schedule of the plaint, you have included the entire property. They were including property of others also. How can an injunction be granted? Should be dismissed on that ground. Although on different ground it has been allowed, but we cannot permit you to get an injunction regarding this. We'll give our reasons and dismiss your application, and we'll give you liberty to seek amendment of the plaint and the injunction schedule. Let us see the plaint schedule. If the defect, yes, this is the plaint schedule actually.
At page 14, my lord.
Pardon?
At page 14. Plaint schedule is at page 14.
Acha. Same property, same problem.
Same.
Only one title deed.
Only one title.
Clerical error, but crucial. You cannot grant you injunction on this. The present appeal has been preferred against an ad interim refusal of injunction by the trial court in a suit for declaration of title and injunction. Push up next para. Although we do not.
My lord, may I point one thing, my lord?
Yes.
The suit has also been defective, my lord. It has been filed as partition, wanton.
Oh.
Suit is also not maintainable.
Oh no, partition. No, the relief shot is not partition.
Oh, my lord. It's not a joint property, my lord.
Yes, you're asking for exclusive. Once
How
more.
can it be a wanton, my lord? Partition cannot lie.
No, that mere nomenclature. Due to a fairness, we are trying to find out something for you. No. But you asked for partition in the prayer also.
Yes, ma'am.
No, the take up. Probably your by the deed, no specifically demarcated property was given. No, the frame of the suit is all right because out of this entire 285.
25.
No, then our impression is also wrong because we are proceeding on the basis this is a declarative. If it's a partition suit and you have been given 548 out of the entire property
2.8.
without demarcating it, then partition suit is also maintainable, and then you are a co-owner and you are seeking partition and you are seeking injunction. Then it takes a different color. We'll again reconsider the injunction.
Property has not been demarcated, my lord.
No, therefore partition suit is maintainable. But how do you get construction? We can consider nature, character, and third party also. No, you have not asked for third party interest.
I have not asked.
শান্তিপূর্ণ ভোগ দখলে বাধা সৃষ্টি বা নালিশি সম্পত্তিতে কোনো প্রকার কনস্ট্রাকশন করিতে না পারে, নেচার ক্যারেক্টার চেঞ্জ করতে না পারে। নেচার ক্যারেক্টার উইল গ্রান্ট, বাট রিগার্ডিং ইয়োর পজিশন, হ্যাভ ইউ
The construction is still going on.
construction will grant, will admit, but regarding your possession, what is the proof apart from this deed? Is there anything else? Your name is recorded somewhere, only this deed.
There are purchase as it happened from the impugned order, my lord. There
Yes.
are purchase at Khatian number, copy of the complaint, my lord. Xerox copy of the
Yes,
plot.
LR purchase has been given.
Plot
No,
information.
we'll grant you an injunction. The present appeal has been filed against the refusal of ad interim injunction in a suit for partition filed by the plaintiff stroke appellant. Full stop. Next para. The premise of such refusal was that the plaintiff has only filed sale deed and no other document in support of chain of title. Full stop. However, the settled law is that at the stage of grant of ex parte ad interim injunction, the trial court shall proceed on the premise that the averments made in the injunction application and the plaint are sacrosanct, unless rebutted, and to consider only whether injunction can be granted on the basis of such averments, of course, also by looking into the documents filed along with the plaint and the injunction application. Full stop. Next para. In view of the appellant having filed, in view of the plaintiff appellant having filed him or her,
My lord.
her title deed, there was no further necessity for the purpose of deciding prima facie case, which only comprises of a triable issue, to go to the hilt and seek further proof of title of the plaintiff by way of production of prior chain deeds. Moreover, we find from the impugned order itself that the plaintiff not only produced her registered deed of sale, but also the LR Porcha showing possession, as well as complaints filed before the municipality and the local police station, and plot information to indicate that not only is she in possession of the property, but she has purchased a share in the property. Full stop. As such, comma, the plaintiff having made out a strong prima facie case to go for trial, comma, the learned trial judge apparently erred in law in refusing ad interim injunction. Full stop. The present appeal is thus admitted and shall be heard on the questions raised in the memorandum of appeal. Full stop. Next para. Since a strong prima facie case has been made as indicated above, comma, only the respondent one. The respondent number one shall remain restrained by an order of injunction from changing the nature and character of the suit property and or making any construction thereon in any manner, and or from disturbing the peaceful possession and enjoyment of the petitioner in respect of the suit property till disposal of Can 1 of 2024. Full stop. The appellant stroke petitioner shall serve copies of the application on the defendant's respondents, indicating that the application shall be listed for hearing in the monthly list of April 2025. Full stop. The appellant shall file an affidavit of service on the next returnable date. We were saved by a whisker from passing a wrong order, because part has been given to you. If it's a partition suit, it's not a demarcated part, you are entitled to partition. Prima facie. Eta ki? Eta দিয়ে দিন। এটা কি এটারই নাকি? This is yours.
Court fees.
You can take it back. Oh, no, keep it on record. প্রথমে একটা লাইন অ্যাড করো, in view of deposit of deficit court fees as evident from the photocopy of the receipt handed over in court today, comma, the defect in the matter is deemed to stand cured. There was any other defect, we permitted you to correct.
Say valuation statement.
Put that valuation statement in.
Appear for the defendants, appellants before you, Lord.
Right.
Lord.
There is no caveat?
There is no caveat.
Very.
Lord, you see, this first miscellaneous appeal is arising out of the temporary injunction granted by the learned court below. Lord, may I just give your lordship a short nutshell facts of the case. Lord, one, Monmoto Mondol was the owner in respect of certain plots of land. One plot. Lord, such Monmoto Mondol died intestate, leaving behind him his 3 sons and widow. So 4 heirs and successors are there. From 4 heirs and successors, the defendant number 1, appellant number 1 here in before your lordship, purchased the entire property. After purchasing the property, that is vacant land, Lord, I enter into a development agreement, the developer who is the defendant number 2. And my lord, in terms of the development agreement, I have also executed the general power of attorney, development general power of attorney. And in terms of that, they have constructed G+4 story building.
Them is the developer.
Developer. Who is the defendant number 2? Appellant number 2 herein. Lord, after construction, G+4 story building in terms of the sanction plan granted by the authorities. Lord, after construction, Lord, certain outsider has come and filed a suit for declaration and injunction. Lord, that suit, initially, my lord, he has obtained the order of injunction. Interim order of injunction. I'm sorry, my lord, interim order of injunction. Then, my lord, we have preferred the appeal before the appellate court below. In earlier occasion, not this suit, earlier suit. In that suit, my lord, we preferred the appeal, misappeal before the.
That suit was for what? Declaration of title and
declaration and injunction. Injunction was granted, ad interim injunction was granted.
You preferred an appeal, yes.
Misappeal.
Yes.
In the misappeal, my lord, the injunction, ad interim order of injunction was, my lord, rejected. And my lord, the appellate court below, my lord, directed the learned trial judge to, my lord, dispose of the suit as early as possible and to dispose of the injunction application too. When the injunction application came up for hearing by the learned trial court, Lord, they have withdrawn the suit. They have withdrawn the suit without without taking any liberty to file a fresh or otherwise. Thereafter, they have filed again a suit. This is the present suit. That same person claiming that he has a right over the property. We are disputing that. He has a right. What right? He is saying that he has purchased from one power attorney holder of the two daughters of the that Marmoto Mondol.
His alleged title deed is prior to yours?
No, after.
What was the date of his title deed?
No, his title deed, my lord. I'm just showing to lordship. He has got his title to date was 2021.
And yours?
And my title deed is duty statement.
He claims by two title deeds, one of 2021 and another of 2023. The second one.
My title deed is 2023.
So yours is later?
Yes.
Not early.
My deed is later. My deed is later.
You are the defendant here.
Defendant.
No, the plaintiff claims that he is the owner of 3.4 decimals of land in respect of a schedule by virtue of two sale deeds. One from the power of attorney holder of one daughter of Monmoto, namely Aruthi.
Yes.
And another deed that is of 2023.
Yes.
The plaintiff himself.
Yes.
Plaintiff purchased by two deeds, one of 2021, one of 2023.
Yes.
From two daughters.
Yes.
So, and what about you? What is your...
I have purchased that is 2023. Yes.
That is not referred to in the injunction order. You have purchased from whom? Wife and 4 sons.
Not,
yes.
The agreement was executed in the year of 2018. Before that, I have purchased that.
And not only that, you have purchased from wife and 4 sons.
Wife and 3 sons.
The impugn order says
Wife and 4 sons. Sorry, wife and 4 sons. Yes.
You purchase wife and 4 sons.
Yes.
You deny the existence of any daughter, and
Yes.
they purchase only from 2 daughters.
And it was mentioned that there was no daughter. There was no daughter.
Achha.
Thereafter, after purchasing that, we have entered.
What injunction have they been granted?
Yes, Lord.
What injunction has been granted?
G plus 4 to it construction has been completed.
Where is your title deed? Where have you annexed your title deed? We don't find any mention to your title deed. Anyway, at this stage, we won't grant a stay of the. We are admitting the appeal.
Only one submission I have.
Yes.
So for your lordship, kindly have a look of the last portion of the impugned order. No, your lordship, kindly have a look at last portion.
Further construction alienation.
Kindly see. Your lordship, have a look of the internal page 4.
Yes.
Internal 4, your last paragraph. But the defendants. Your lordship,
yes.
But the defendants denied the title of the plaintiff, stating that Marmoto Mondol died leaving behind his wife and 4 sons. The plaintiff intentionally tried to create an illusion. The defendant again stated these defendants are only unaware of the fact as to Marmoto Mondol has any surviving daughter at the time of his death or not. But the defendant did not file any document to show that Marmoto died leaving behind 4 sons and wife only at his legal age. That whether Marmoto Mondol has any daughters or not, that will be decided after taking evidence from both sides. However, plaintiff is able to establish by so thereafter. That by filing objection, defendants have again stated that the plaintiff has intentionally tried to create an illusion by describing the suit property as a vacant land, but actually on the same, it is entirely There is standing a multi-storied building comprised of several residential and non-residential apartments in ready to move in position. That the commissioner's report also states that under construction 3+4 multi-storied building on identified property, but according to the version of the defendant, there is standing multi-storied building in ready to move in position. So prior visit clear construction has been completed over the shoot plot. As such, if further construction, locally mark that. And alienation begun by the defendant's plaintiff will suffer equal loss and injury. Under such situation, it would be better to restrain the defendant from changing the nature and character, further construction, and alienation of the civil property till disposal of the suit. So there are three things here. One is changing the nature and character. Second thing is that further construction. Third is alienation. So for the alienation is concerned, I can concede the prayer that I may not alienate. But so for the concern is concerned, if the 4-story has been completed mostly, not entirely, mostly has been completed, if it is standing on this facade, the entire building will be collapsed after some time.
Why?
Because your lordship,
You have constructed in such a way that if the 4th story is not complete, the
because all the
lower
doors
stories
are
will
open,
also collapse.
all the doors are open,
Why
all
will
the windows are open.
Why will the lower stories collapse?
No.
There are so many buildings lying in Calcutta where all the doors are open, construction not complete for years. It will collapse.
No. But and the further construction
and at this stage, at the admission stage, without hearing the other side, if you grant stay, that would tantamount to allowing the appeal.
I am not asking stay.
That is what we are asking.
I am not asking stay.
That is what we are saying. We are admitting the appeal directly to sub copy.
The only what I am asking, necessary order is actually passed, modifying the order of the learned court.
Modifying at this stage of admission of appeal without hearing the other side. You are asking, what you are asking is worse than stay.
I am asking one thing that permission may be granted for construction.
No, not at this.
Can consider one thing.
Whatever you say, we are not granting any sort of modification.
If you, for the sake of argument, if we think that,
we are not at this stage of argument. We have decided. The present appeal will be heard on the grounds taken in the memorandum of appeal. Next para, a strong prima facie case has been made for hearing of the appeal, in view of the defendant's appellant's contention that apart from the suit being barred by the principle of Order 23 of the Code of Civil Procedure, since no leave was sought by the plaintiff/respondent at the time of the withdrawal of a previous suit on the self-same ground and reliefs, fact remains that on the strength of a prior title deed obtained by the appellant number 1 from the widow and 4 sons of the admitted original owner, on the basis of which a development agreement was entered into with the appellant number 2 and construction has been substantially completed, the title deeds relied on by the plaintiff were executed apparently by 2 daughters of the original owner. The learned trial judge disbelieved the fact. Now, the learned trial judge apparently overlooked the prior title deed of the appellant number 1 and placed reliance on the title deeds claimed by the plaintiff through the purported daughters of the original vendor, without entering into the question even prima facie as to the prior title of the defendants / appellants. Of that apart, learned counsel for the appellant argues that although regarding alienation, there might have been some point in the trial court passing such order at the preliminary stage, the restraint order from creating further construction or changing the nature and character of the 4-storied building which has already been substantially completed, if the same remains incomplete, the entire building will suffer from serious damages and the vagaries of nature and may fall down ultimately. Next para, however, we find that although a prima facie case has been made out for hearing of the appeal on merits, in the event we modify and or grant any stay of operation of the impugned order at this stage, it will tantamount to allowing the appeal at a preliminary stage without the same being heard finally on merits upon giving opportunity of presentation of their cases to both parties, comma, particularly since the impugned order is of a negative nature, full stop. Next para, thus, comma, we are not inclined to grant stay of operation of the impugned order at this stage, full stop. The appeal bearing can 1 of 2024 along with the application are required to be heard together, full stop. Next para, accordingly, the appeal is admitted. The appeal is admitted বলতে প্রথমেই বলেছি, ছেড়ে দিন। The appellant shall serve copies of the memorandum of appeal along with the application on the respondent, indicating that the appeal and the application shall be listed for hearing on April 16, 2025 under the heading hearing, full stop. For such purpose, comma, the service of notice, service of copies of the application and the memorandum shall be deemed to be service of notice of the appeal itself, full stop, since the relevant documents are substantially annexed to the stay application, comma, the necessity of calling for the trial court records is dispensed with for the present, full stop. However, comma, it will be open to the respondent, comma, as and when the appeal is taken up for hearing along with the application, comma, to produce other documents or pleadings which were before the court below but omitted to have been annexed herein, comma, upon service of prior copies thereof to the learned advocate for the appellant. Appeal application will hear out together and fix a specific date when.
Yes, yes, yes.
But for hearing it goes down, but even then we skip these intermediate steps.
Yes, I'm grateful to.
Thank you.
Let me not take my chance, not on 16th.
Yes.
I'm grateful to.
My lord, 39, my lord, I'm appearing for the appellants, my lord. My lord, I'm being led by Mr. Thakkar, my lord. He has some difficulty this week, my lord. All I was praying if it could be taken up any day next week, my lord.
You're enjoying an interim order?
No, my lord, I am not enjoying. The appeal has been admitted, my lord, but I'm not enjoying an interim order as such.
Then very well. Then no difficulty. On
My
the
lord,
prayer
next
of the
week, any
appellant,
day.
granting adjournment. On the prayer of the appellant, comma, let the matter stand adjourned till when? Give us a date.
My lord, any day on the next day, next week, my lord, 18th, 19th, any day, lordship.
Very well. Adjourned till March 18, 2025.
I'm grateful. I'm grateful. I'm grateful.
Also, suit for divorce filed by the husband, lordship. I am the wife respondent, appellant before your lordship. I filed an application under section 24 of the Hindu Marriage Act 1955 in connection with the suit. Now, lordship, the husband, we have filed a written statement. Husband choose not to contest, not to appear.
What is the impugned order?
Lordship, kindly come page 50 of my stay application.
No, let us come to the impugned order annexed to the memo.
Lordship, as the husband didn't appear in the suit dismissed for default, my miscase also has been dismissed. In spite of the fact I appeared. Kindly come order.
For an appeal? Or dismiss for default?
Dismiss for default, and this is also dismissed for default.
Wrong classification. Dismiss for default is not a decree under section 2.
So FMAT, I have filed FMAT.
It's not applicable under order 43 either. Order 43 does not contemplate civil division, 227.
Dismiss for default is an applicable order.
Under which provision?
No.
Under which provision of law? Has to come under some provision. Dismiss for default under order 9, rule 9, yes. Order 43 and order dismissal for default is not applicable under order 43. If you file an order 9, Once it is dismissed for default, if you file an order and rule line application, that is rejected. That is appealable under Order 43. Dismissal for default itself, surprisingly, is not appealable. And it's not a decree.
Here in this case, it is not a decree, admittedly. It is not a decree.
And it's not an appeal under.
Here in this case,
Appeal is a creature of statute. If there is no provision for appeal, appeal does not lie. There is no provision for appeal. And your Section 24 dismissal is in any event appeal revisable. No appeal lies against
here
that.
in this case, in view of the dismissal order dated 14 January 2025, passed in match suit number such and such, the instant miss case is also dismissed for default without order in its cost.
Section 24, rightly, because Section 24, first of all,
separate miss case.
Separate miss case, but Section 24 operates during pendency of the suit only. It's not a Section 25 application. Section 24, the scope of Section 24 is interim maintenance.
Yes.
Interim means
the maintenance
pendentility means interim. Pendentility, the meaning is interim maintenance. Pendentility means during pendency of litigation. If the litigation is not there, there is no scope of Section 24. Rightly rejected.
Lordship, so far subject to your lordship's correction, this is a separate miss case. In spite of the fact suit dismissed, I am entitled to
Automatically
get the
goes.
interim maintenance.
It's miss case. It's a miscellaneous case because it's classified as a judicial miscellaneous case under the civil rules and orders formed by the full court of this court. Civil rules and orders says that these proceedings shall be classified as miscellaneous cases. That does not mean that necessarily it's an independent proceeding from the suit. It's classified as a miss case under the CRO, under the civil rules and orders. That's why it's a miss case, not because it's dissociated from the suit. Section 24 itself says during pendency of the suit, you can get an order. If the suit is not there, Section 24 goes. Only thing which survives is if an ad interim order was passed in connection with the Section 24 and there is a non-payment of that during the pendency of the suit, you can levy an execution case which will survive even after the dismissal of the suit because of the non-payment for the period for which it was subsisting. Suppose I file a suit today, an injunction, an interim order of alimony is passed in my favor. I am the wife. That alimony order is subsisting till dismissal of the suit for default. During this period, if the husband does not pay, what happens? Suit dismissed, alimony application also dismissed, automatically goes because it's still disposed during pendency of the suit. But I can take out an execution application for payment of the period, non-payment of the period during which it was payable to me. This period becomes due. Too much of a sermon, forget that. This is revisable, we'll hold that. The present appeal has been preferred against the dismissal of a suit for default and consequentially the dismissal of a miscellaneous case under Section 24 of the Hindu Marriage Act filed by the appellant. Full stop. Next para. Since dismissal for default of a suit is not a decree within the contemplation of Section 2 of the Code of Civil Procedure, nor is it appealable under any of the rules under Order 43 of the Code, the main dismissal of suit is not appealable, full stop. In any event, any order passed in a miscellaneous case arising under Section 24 of the Hindu Marriage Act is also not appealable under any provision of law, full stop. Accordingly, FMAT 64 of 2025 is dismissed as not maintainable with liberty to the appellant to prefer an appropriate challenge before the concerned court having determination. Full stop. Nothing in this order shall prevent the appellant from doing so. Full stop. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. Full stop. Can 1 of 2025 is disposed of accordingly as well. No rest to cost. Take back the certified copy, furnish.
Lordship, only one thing.
Sorry.
Kindly consider, I appeared in spite of that dismiss for default. So, Lordship, I...
Revision, take that point in revision. Next. আপনি বলছেন না সিভিলের খুব অবস্থা খারাপ হয়ে আছে সেকশন 24 মিসকেস হচ্ছে বলে অ্যাপিলেবল yes no time apart from time whatever what next day how long are you practicing 8 weeks 3 weeks what is your name Sheikh Nadda Hasda. Mr. Hasda, what is the matter about? You have to say that to us. Otherwise, we'll dismiss it for default. At least what is the appeal against? Take our brief. Tell us what is the appeal against. Tell us what is the appeal against. Who is your senior? Mr. Hasda, who is your senior?
Not my case. I'm just instructed for take time.
Not your chamber's case. Well, then. But your name has to be given for the purpose of taking time. On the prayer of the appellant, the matter is adjourned for the day. ওনার নামটা লিখে নিন।
Number 42. I'm for the caveat to
For
respondent.
42, my lord, learned advocate on record, Mr. Avilash Chatterjee is not able to appear today.
Avilash Chatterjee, what happened
Avilash
to him?
Chatterjee, my lord. His brother is ill, my lord, so that he's in the hospital, my lord.
Very well.
I'm praying for only not this week, my
You
lord.
are the advocate on record.
No, my lord. Avilash Chatterjee is as
Avilash Chatterjee, we understand, but there is the name of the presiding judge of the trial court has to be put in the.
It has been corrected. As per my instructions from Mr. Chatterjee, it has been corrected.
Right. We find from the preamble of the memorandum of appeal that the name of the learned presiding judge has been incorporated. Full stop. Accordingly, the defect in that regard is deemed to stand cured. Full stop. Since an adjournment is sought on behalf of the appellant, let the matter stand adjourned for the day.
My lord, I am praying for not this week, my lord. He's in Hyderabad, my lord.
Acha. Is adjourned for the week and shall next be listed on February 17, 2025.
Great.
No difficulty
February-
on your part.
February-
March 17, 2025.
Grateful, my lord.
Thank you. Yes, Mr. Ghosh, what is the matter? You are for the respondent?
Expiry identity of injunction has been challenged by the appellant defendant. Suit filed by the years of Mukullani Ghosh. Mukullani Ghosh transfer his entire 50% share to the wife of Nilmani Shah. Suit filed by years of Mukullani Shah suppressed the deed of purchase made by their petitioner in a partition suit and sought to get an order of injunction from the learned trial court by way of concealment and betrayal fact. Your Lordship, veracity
No,
of
you don't have a right of hearing. Now, please take your seat. We'll hear you. Take your seat. At the admission stage, you don't have a right. You are the purchasers from Nilmoni.
Nilmani Shah, Mukullani Shah, both purchased the property in the 1955. There in 1958, Mukullani Shah transferred his 50% share to the wife of Nilmani Shah.
You claim through her.
No, I am the owner of the entire property led by Nilmani Shah and Parulani Shah.
And they?
They
Plaintiff?
are the heirs of Mukullani Shah, whose property was transferred in 1958. They cannot claim any right, any inch of any right about the
So
property.
Mukullani Shah transferred an entire share.
Entire share to the wife of Nilmani Shah.
And you purchased from Nilmoni's wife.
We are the heirs of Nilmani Shah and Parulani Shah.
So what was the basis of the grant of?
Deed of conveyance of both 55, 58. But
What was the basis?
Concealment and material facts.
No, you this is at the ad interim stage.
So I want to develop certain portions of the property and I made an execution or develop.
Mr. Ghosh, at the ad interim stage, there was nothing before the court to know that there is suppression. Court has to proceed on the.
That's right.
So we'll direct you to file your objection and decide direct the appeal court to hear out.
In the meantime,
Within 4 weeks, why should you change the nature and character? What heaven will not fall. But on the face of the allegations made in the we'll record your submission, subject to hearing your other side. You have not yet heard it. We will take your consent and dispose of the appeal itself. Will not interfere. We'll record his allegation of suppression, which we say are controverted by you. he will file his objection written objection within a fortnight, within a week. We'll direct the trial judge to decide the injunction application within 3 weeks.
Development agreement. but
Within,
property has to be
within,
developed.
within 3 weeks. In view of certain questions of facts and law being involved, comma, we admit the appeal for being heard on the grounds taken in the memorandum of appeal, full stop. On the consent of parties, comma, in view of the short ambit of the appeal, comma, the appeal itself, along with the application, is taken up for hearing, full stop. The present challenge has been preferred by the defendants in a declaratory suit, full stop. Learned counsel for the appellants argues that despite the predecessor in interest of the plaintiff stroke respondents having transferred her entire share to the mother of the defendants stroke present appellants, much prior to the institution of the suit, comma, injunction was granted, comma, by overlooking such gross suppression of material facts in favor of the plaintiffs. Full stop. Next para, such contentions, comma, of course, comma, are controverted by learned counsel for the respondents. Full stop. We find that in the event the defendant stroke appellants are able to produce the relevant documents in support of their contentions, that much prior to filing of the suit, the entire title of the alleged predecessor in interest of the plaintiffs were transferred in favor of the mother of the present defendants appellants, comma, it would undoubtedly lead to a case of gross suppression of material facts. Full stop. However, comma, it is well settled that at the stage of grant of ex parte ad interim injunction, comma, the learned trial judge is only to look within the four corners of the injunction application and proceed on the premise that such applications are correct unless rebutted subsequently, and to consider whether on the basis of such averments and such averments alone, comma, an injunction is to be granted to the plaintiff. Full stop. Thus, comma, we find little scope of interfering with the impugned order, comma, since the allegations made by the defendants appellants before this court and the documents sought to be relied on by them were not available at the ex parte ad interim stage before the learned trial judge, comma, for which the learned trial judge cannot be blamed. Full stop. Next para. Hence, comma, we do not find any scope of interference with the impugned order. Full stop. Accordingly, FMAT 57 of 2025 along with CAN 1 of 2025 are dismissed on the grounds as indicated above. Full stop. Next para. However, comma, it is made clear that we have not entered into the merits of the case of either of the parties, and it will be open to the parties to urge their respective contentions on merits in connection with the main injunction application and at all further stages of the suit. Full stop. Next para. The appellants shall be entitled to raise all the questions which are intended to be raised in the present appeal but before the learned trial judge in connection with the temporary injunction application. Full stop. For such purpose, comma, the defendants stroke appellants shall file the written objection to the temporary injunction before the learned trial judge within a week from date. Full stop. The learned trial judge shall thereafter take up for hearing the injunction application itself for disposal, and it is expected that the said injunction application shall be disposed of within 3 weeks from the date of communication of this order to the learned trial judge. Full stop. No address to cost. Very well. Dispose of. যেখানে dismiss বলেছি dispose. Judge in charge cannot decide within 3 weeks. Within 3 weeks cannot. Then we make it 6 weeks, Mr. Ghosh. There has to be some limit to the pressure we put on the trial. 6 weeks. তাহলে 3 weeks টা যেখানে বলেছি 6 weeks করে দিন, আর আরেকটা লাইন অ্যাড করে দিন, liberty is given to the parties to approach the learned judge in charge, comma, in the event the presiding officer of the trial court is not available, comma, to carry out the directions of this court as given above. But ওটা 3 weeks টা 6 weeks করে দেবেন ডিসপ্লে.
Just comes within 3 weeks.
No, 3 weeks no. You have been injuncted, not that injunction has been refused to you. Injunction for 6 weeks, if you don't construct, what will happen? Rain may fall, but heaven will not fall. No, even then. Yes. Yes, Mr. Gupta, tired look, running throughout the day from court to court.
No, because of yesterday.
Yesterday, what happened? Yesterday, the notification.
No. I came back today morning, went for the match.
Went for the match. Oh, achha, you were there.
Ended today morning. That is.
Congratulations. You are lucky for the team.
Yes, it was a lucky.
Yes, Mr. Gupta. Let us see whether you are lucky for your client.
Otherwise, I should be, because your lordships had the occasion to deal with the identical matter in order 39-1-2. This is from a dismissal of order 40. But my lord, the affidavit of service is not ready. So my lord, I would be anyway.
No, the appeal is to be admitted. Oh, there's a caveat.
No.
This is which item? 44.
This is 44. 44, if my lords kindly.
44 is order 41.
Order 40. Yes. I'm saying it's from an order 40 application.
No. Where is the question of service? Affidavit of service is not ready, you are saying?
Because that was.
Appeal has to be admitted first. Is there a caveat in the application?
No, there's none. There was a caveat in the order 39. But
No,
here,
there is no caveat.
There was a caveat.
So take up the appeal for order 41.
But if my lords kindly take a look at your lordship's judgment at page 352 in the same suit.
Yes.
But just to refresh your lordship's memory, my lord,
yes,
this was with regard to a suit for injunction, where my lord, by registered deeds of conveyance from the official liquidator, the plaintiff appellant had purchased the property. My lord, in liquidation sale, my lord, when there's a jute factory of the plaintiff and there's a boundary wall, and my lord, we were wanting to, my lord, guard the boundary wall in respect of portions where there is no encroachment. There are other encroached portions as well, which are not part of the suit properties. So we had filed the suit. In connection with the suit, we had taken out two applications: order 39-1-2 and order 40 rules 1 and 2.
Who are the defendants?
Defendants are the other the persons who are opposing the obstructing the construction of the boundary wall.
What is the locus standi according to them?
They are trespassers, but they are not residing within the suit property. They are outside. So in that event, kindly now seize the order, where your lordships have been pleased to record their objections also and overrule them. May I place it, page 352.
Overlook or turn down?
Overruled.
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 Without overlooked.
No, I'm sorry. The present appeal has been preferred against the dismissal of a temporary injunction application filed by the plaintiff appellant in a suit for identical reliefs by way of permanent injunction and other ancillary reliefs. Learned counsel for the appellant submits that the learned trial judge failed to consider the title deed of the plaintiff, by virtue of which the Schedule B property, which is the suit property, was purchased through a court sale. The property was subsequently let out to a third party, which, however, later on merged with the plaintiff. Thus, the plaintiff is the exclusive owner of the suit property, that is the Schedule B property marked with green hatches in a plan annexed to the plain.
Mr. Gupta, this will take some time. We can't finish within 1 minute. Let us come back to it. You won India match, and so let us wait for a day.
But for the
we are recording. We should record some order, because if although the matter is taken up for hearing, due to paucity of time, the matter cannot be. The hearing under order 41 rule 11 of the Code of Civil Procedure cannot be concluded today. Accordingly, let the matter stand adjourned till tomorrow. Another number.
I'm sorry.